Hello, everybody. Good morning. So I would be pretty surprised if nobody has a stream for today's Courtney Clenney hearing, but nothing looks like it's fired up quite yet, and maybe nobody will, but we'll see. So I have Court TV ready, Law and Crime Trials ready, NBC6. NBC6, if we don't have a live stream from them, pretty much every hearing within half an hour of when it would end, they've got news stories published and ready to go already. So we'll make sure we flick around and try to find a stream, and we'll make that the priority. In the meantime, we have a bunch of motions. So the most recent Courtney Clenney stream that we did was on the defense's motion to dismiss. This should be the most recent video if you go back to the live tab on this channel. And very lengthy, right? The joke was, wow, the attorneys are advocating. And if you missed it, motion to dismiss, mostly for prosecutorial misconduct. We heard a lot about that during the laptop case, but they added an additional argument from Danny, the guy in the red shirt that was the security of the One Paracio building. Apparently said in his deposition that the Miami Police Department, their officers, their first responders, told him to delete photos/videos from his phone that could have had exculpatory evidence that would have aided in Courtney Clenney's defense, or gone to prove she acted in self-defense. Who knows? So that was a new detail in that motion to dismiss. Today we're going to look at, and you can see on the screen, it's kind of tiny, so I'll read it. We're going to look at a motion to set bond reconsideration. So this would be, I think, the third time that Courtney Clenney has filed a motion for bond reconsideration. She's had 2 bond hearings, and it was denied both times. Obviously, we've seen her in custody. We're going to look at, and I think this is the first one we're going to look at, a motion to suppress amended illegal recordings. So we're going to take a look at that because I think a lot of us have been wondering, there's some stuff that looks really, really damning out there for Courtney Clenney. But what if the jury doesn't see it? Is the jury going to see it or not? Because I'm not going to lie, I formed my opinion based on things that I've seen out of court, and those specific pieces of media, a couple of the videos, but also some of the journal notes. Is all that going to come in? And this motion is going to deal with some of those video/audio recordings. And then we've got a motion to compel disclosure. So we'll look at that as well. But good morning to everybody in the meantime. Every few minutes, if you see me look over more, it's me just checking to see if anybody has a feed. The judge seems to have a YouTube channel, but it's a personal channel. It's not a court feed, so that was disappointing. But we'll keep looking. We will keep looking. And last time I tried to join a stream, a Zoom feed from the court, they booted me instantly. So that's not an option. But I did try. And then let me pull up this motion. All right, so that'll be the first one that we look at. Really short. And in the meantime, also, I saw FFS, Love Amy E, Dolly Talk, and Jersey Girl Trey. That's Trakeisha. Are we doing the @ names on YouTube again? Why are these names back? We had regular names for a month, and now YouTube is doing the thing. So this is Trakeisha. So you guys were so early. Thank you so much for showing up, hitting that like button. MJ is ready for Courtney Clenney's content. Hey, J Money, always good to see you. We've got Michelle Brown. We've got Madman says, I'm not first. See, I know this is Candace, but your name's all different here. Dizzy is Dizzy OD today. Sapphire Ridge News, good to see you. I feel like it's been a bit since you've popped into one of these lives. Mentioning that Courtney's not aging well. What I think is really interesting is I'm guessing, right? This is just my guess, that being in custody may have helped with sobriety for Courtney Clenney. So it kind of sucks that she's not aging well, but I kind of feel like she might be a little bit healthier, at least as far as sobriety, because of all of this. Pretty crappy silver lining, I guess, but maybe a necessary one. Hey, Jillian, good to see you. You got the paper clippy with the hat. I love it. No, we are not on a Jet2 holiday. Oh, man. Sheriff Chuck, good morning. Good morning. Time for a wonderful day. Heck yes. We've also got, hey, Martina. We've got Luis. Good to see you. We've got Jennifer and ML. I think you get one of the most, you get all the numbers in your name when it switches back. Shamina, good to see you. Janet Reed, good to see you. We've got Aaron in the building. Good to see you. Created by EJF. For always, forever, for life. Always glad you're here for a Courtney stream. Hey, Kimberly Brown. Miss Kels. Miss Kels says, have a great day, everybody. Yeah, and FFS says she's not a Judge McBurney. That's right. Judge McBurney probably greets the people that join his Zooms. And thank you, Love Amy E, for the reminder here to click that like button. So let's see, you guys. We're going to look at these motions. I'll make it bigger. And again, since I'll be reading, I'm not going to be refreshing every second, but we'll pause periodically to check for a feed. Last time we caught a hearing, they started around 9:30, so we'll see. But with this being said, we've got an amended motion to suppress illegal recordings pursuant to Florida Statute 934.03 and 934.06. Now, this is making me guess it's going to deal with the same recordings from Christian's phone. And previously, one of the arguments here for those pieces of media that Christian recorded was that it was a violation of, or there was an expectation of privacy. So if they're in this huge penthouse apartment at One Paraiso building and they're having conversations, is how the defense would probably characterize it, the expectation is they wouldn't have been overheard. Well, state argued they were getting noise complaints to the building staff. People were hearing these arguments. We have witnesses saying they overheard these arguments in this time frame. So because you are reasonably being overheard, state argued, no expectation of privacy. And the judge agreed with the state there. So I'm guessing this relates to some of the same potential files. So comes now the defendant, Clenney, by and through undersigned counsel and Florida Rules of Criminal Procedure, and respectfully moves this honorable court to suppress any and all evidence resulting from a violation of 934.03 and 934.06, and any evidence derived therefrom, and in support states. So, you've got your background, tentative trial date of December 1st, on November 15th, 2022, and then again on November 17th, 2022, an Arthur hearing was conducted. Guys, this is, Courtney's facing a life sentence. Arthur hearing is a bond hearing for a more serious offense in Florida. Prior to the Arthur hearing, the court indicated it would receive evidence over defendant's objections of surreptitious recordings made by the alleged victim in this matter. So, we've got a footnote. It should be noted that these recordings do not capture any audio and or video from the events of April 3rd, 2022. All the surreptitious recordings predate the unfortunate events of that day. After the close of evidence and arguments by counsel, which were taken under advisement, the court issued an order denying bond in this matter on December 8th, 2022. Ms. Clenney has remained in custody since her arrest in August of 2022. So, they give a list of the files here that they want to suppress. They all say all files come from the Obamcelli mobile phone extraction provided by the state of Florida. So these are all coming from Christian's physical cell phone device. So they list what do they got here. And if we look at the numbers, these are close, but they jump, but they look pretty close in succession. Like this goes from file number 3775 to 7678, 7778. Then there's a bit of a jump here. And this might not be because files were missing on the phone. This could just be because the state didn't move to enter certain files into that they plan to use. We've got some jumps here. We're up to 380, 3889. Some more jumps, and then we have a few more that are in pretty much succession. 01, 02, 03, and then 5. So they're going to argue here that in several of the above illegal recordings, and it's like Frank Prieto, Sabrina Puglisi, Diana Karamis, whoever's writing these motions, always has the same little And personally, I think it's like, it feels a little bit more forced. I love a good sassy writing, but here I think it's a little bit more forced. We drop in these buzzwords. This to me is always more buzzwordy when we read the filings from these attorneys. But maybe it's because of my own opinion on this case that I'm looking at it through my own lens. In several of the above illegal recordings, the alleged victim in this matter would mentally manipulate Miss Clenney when she was in a vulnerable state and provoke her until he achieved the desired result. A heated argument. So he was doing this on purpose and then would pull out the phone. Once in a heated argument, he would then start his surreptitious recording to make it appear that he was the voice of reason by acting calm, obviously knowing that he was recording himself. And I'm going to stop. I don't agree with this. It's not my opinion that this was happening here, but I do really think that this is an issue, and I think that this happens. You know, when we hear bits and pieces of things entered into evidence. I mean, I think the Johnny Depp Amber Heard trial is probably the greatest example of this, because they were recording their arguments as part of therapy, right? So both of them were aware of these recordings, at least most of them. There was some issues with the TMZ video and the coffee mug thing, and the mega pint. But for the most part, you have these arguments where both know this is being recorded, and it still gets crazy sometimes. And I think the jury in that trial decided, you know what, the way that we're hearing her act on these recordings, maybe we don't believe her. And even though it was a split verdict, largely Johnny Depp won in the terms of that verdict. But I do think that this is true. When you hear a recording that somebody took on their own phone, sometimes you do have to take it with a grain of salt because they're aware that they're recording. Sometimes the other party's not aware. And that can affect both of their behaviors. All this was done to fuel his level of dominance and control over Courtney. He would sometimes use the recordings to manipulate Courtney thereafter. Obumseli would threaten to play these illegal recordings in a public forum to friends, to acquaintances, and Courtney's parents. This manipulative gaslighting behavior, aimed at having Courtney question her perception of reality and her own memory, was just one example of the mental abuse she endured in addition to the physical abuse while he was high on cocaine, quote, below. Now, notice they say he was high on cocaine. Just he. Just he. These illegal secret one-party recordings, admitted for the limited purpose of the Arthur hearing, were made by the alleged victim in this case during the course of his relationship with the defendant. He would use these recordings to further his campaign of psychological abuse and gaslighting against Miss Clenney, as he acknowledged in a letter to Courtney retrieved from her apartment as excerpted below. Now, I don't think I've ever seen this in a motion as an argument. So this was one of the... Oh, it's kind of stormy here, so I hope my internet isn't going to act up. We saw this in one of the first troves of evidence from this case. And it was a letter they recovered. It was sitting in the apartment somewhere, and the police collected it. So it reads, but there's a big chunk missing, so we're just going to try to get what we can. So Christian's writing here, presumably, I am, and there's highlights, guilty of not loving you, like the beginning and over time, making you not love yourself, something of gaslighting you to any level, and mentally abusing something, and notice the change that hurt and pain into something is written, and then there's a rip in the paper, and it starts again saying, and turned it into a habit where I couldn't control it, and that's the rip in the page, acknowledge it because of the pain and hurt, which was never rip in the page, something of hurting you on purpose. To the point of rage where there's a D, throw, say words, or call your mom as a lifeline, acceptable by me, and unders crossed out, unacceptable by me, not blank, I have the power to stop what I am doing. Something turned you into something that wasn't like and there's a B, maybe beginning. Sorry, I am so sorry. I can only imagine your head when I did those things, and I am holding myself 100% accountable to everything. I am blank to your mom, dad, and sister. I've shared memories, W space to them many of times, which is hard to believe that something was on a lot of blow or my emotions were high. It was, and what's confusing here is some of this context, he's apologizing, but in my view, this could be the letter written by the person that was gaslighted and always felt like they needed to apologize. And the other person was accusing them of, you're always gaslighting me. You're always manipulating me. You're hurting me. When really this person now just feels like they have to write these letters to appease the situation. So yeah. But there's words that are written, like the word blow. And we're picking those words right here. We're making sure we put them in our argument here. So let's see. The argument continues. These felonious recordings are a clear violation of law and the because we're a two-party state here in Florida. These felonious recordings are a clear violation of law, and the legislature has made it abundantly clear they are per se inadmissible as evidence in any type of proceeding. Florida Statute 934.06 specifically states that whenever any wire or oral communication has been intercepted, no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or other authority of the state, or a political subdivision thereof, if the disclosure of that information would be in violation of this chapter. So they argue that these surreptitious, unlawful, misleading, and felonious interceptions must be suppressed. Florida Statute 934 was designed to effectively protect the privacy of oral and wire communications and to protect the integrity of court and administrative proceedings. And they emphasize this last part. So let's do a check. Let's do a check of the feeds. Hey, Factual Lie. Back to the O'Bailey's name. Hey, Candy Crush. All right, so Court TV is a no bueno. They've got some other trials going on. They've got the Daisy Link trial, and they're going to have, I guess, Adam Montgomery has a hearing. It looks like it's live right now. But no Courtney Clenney. So we'll probably be relying on NBC6 to do their write-up. One of the reporters, Christian Colon, is at like almost every proceeding for Clenney since the case started. So if nothing else, we will look for reporting from him. Also, big love to Jay Money. Jay Money says, love this channel. Cat is amazing in the chat too. Heck yeah, we love the chat. Thank you so much for the kind words, Jay Money. And speaking of the great chat, should probably let you guys know. Yeah, we lost our names again. Jim says he's going to go live Friday. So that'll be fun. He's going to talk about some Moontung things. And either today or tomorrow morning, I've got to figure it out. I'm a little nervous about doing too much reading in one day. So I'm leaning towards tomorrow morning, but we will be looking at the state's reply to the Moontung appeal. So that's going to be a time. And I might yell. So kind of want to have a voice. But I've mostly avoided it. I've been a little tired and groggy. But I think the flu's going around. Everyone around me's been sick. So don't want to commit myself to reading too many things that I want to yell about. But Friday will definitely be a gym stream. So definitely make sure, put that on your calendars. And then either today or tomorrow sometime, look for a stream to pop up. We will look at the state's reply. So, and created by EJF says it's a busy court day. Closing arguments are expected in the New York State Corrections Officer's case this morning, which are allowed to be streamed. If that starts, we can jump over and watch that, you guys, if you want. because opening arguments are streamed, closing streamed, and then everything in between. You've got local newspapers. Rome Sentinel has been one for the New York State Department of Corrections case, the killing of Robert Brooks. The New York inmate, again, that viral video where there's just like officers standing all around the guy. That's that case. But the arguments, it was just paper reporting. So, and it starts at about 10. So these are shorter motions minus some of the argument stuff. So if we don't have a Courtney Clenney stream feed, we can do that here. So, I think with this, we were on the memorandum of law. Now, what's slightly interesting, maybe unrelated, because this charge was added after the probable cause affidavit, so it wasn't part of that. But Courtney Clenney does have an interception of wire communications charge sitting. So, I mean, on one hand, we want evidence out because of a thing, but then we were also doing it too. And again, I'm not sure on the specifics of that charge because I don't have a copy of why they added that charge. But it would kind of go back to, was Christian recording things for his own protection to see if people would believe him? Was he recording to try to blackmail her to make her look bad because she's an influencer and I could ruin you? And you're trying to cut me out of your life. You're trying to cut me out of the management role that I had over your OnlyFans work, which was income for me and also potentially control over you financially. What were these recordings for? And then on the flip side, if Clenney was doing something, messing around with wire communications, she doing it too. And if it's a charge that goes to trial, state is going to be presenting some evidence that Courtney was doing whatever it was to contribute to why they're charging her with this thing. So, who knows? That's something I am very curious to learn more about. But here, back to this argument. They're citing the statute here. .02 defines the oral communication as any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation, and does not mean any public oral communication uttered at a public meeting or any electronic communication. In order to prevail in a motion to suppress under the statute, the defendant must not only have had a subjective expectation of privacy, so a lot of these files were recorded in their apartment building, but also her expectation under the circumstances must have been one that society is prepared to accept as reasonable. And again, if they were whispering quietly, but since they were yelling, doesn't seem like the defense is going to argue here, even though they were yelling, here's why this still should be suppressed. I imagine the state's reply to this will mention they were yelling. So a reasonable person would not expect that to have been private because we could hear them 2 buildings away, a floor away. So, maybe they will argue. I think they should. I don't think they can, though. This expectation is not reasonable where the intercepted communication was made in an open public area rather than an enclosed, private, or secluded area. So they're going to rely on the building. When evaluating whether facts give rise to a subjective expectation of privacy, some courts have determined certain communications to fall outside of Florida Statute 934. These lines of cases have generally involved meetings of public officials in a public building or other quasi-public settings. And then this State v. Foster says that based on the location of the exit interview, the nature and purpose of the interview, the manner in which the communication was made, and the number of people present, there was no subjective expectation of privacy, and the recorded exit interview is not an oral communication as defined by Section 934.02. They've got another. Any subjective expectation of privacy was not reasonable, where the recorded conversation was between 3 police officers during an office meeting about employment grievances. Because of the number of persons present when the statements were made, the chosen place chosen for this interview, and the very nature of that interview. Oh, is this the DA? So this next case is McDonough v. Fernandez Rundle. Isn't that the district attorney's name? Catherine Fernandez Rundle. So they don't put the first name here, but this looks like it may have been a case against the Miami-Dade County District Attorney, or my state attorney, Catherine Fernandez Rundle. No reasonable expectation of privacy, where all the attendees were charged with knowledge that the content of their conversation could be subject to public records disclosure laws. Oops. Oops. A person has no legitimate expectation of privacy and information he voluntarily turns over to third parties. All right, so now we're going back to how it relates to their argument here. Here, suppression must be granted without exception, is bolded, as Ms. Clenney was almost always in her apartment alone with Obum Selly, an enclosed, private, or secluded area, and not in an open public area or quasi-public area. Further, the Third District Court of Appeal has found that society is willing to recognize a reasonable expectation of privacy in conversations conducted in a private home. Other recordings were also made outside her apartment without her knowledge and with an expectation of privacy that society has recognized. The matter sub judice is more similar to McDade v. State, wherein the Florida Supreme Court found that the recording in the case was inadmissible, where it was made in the appellant's bedroom. The recording contained conversations between the appellant and his stepdaughter, and the recording device was hidden under the victim's shirt. In McDade, the appellant's stepdaughter surreptitiously made recordings that corroborated her accusations of sexual battery and molestation. Yeesh. In analyzing the expectation of privacy issues and the, quote, whether society is prepared to recognize formulation, first found in Katz, the McDade court focused on its genesis and rejected any type of categorical rule that persons involved in criminal activity have no justified expectation of privacy in conversations related to those activities. Well, that sounds a little... That's a little crazy. Regardless, the recordings in this matter are not of any criminal activity. They are recordings of Courtney and the alleged victim having heated arguments or discussions in her private apartment, intercepted by use of a hidden mobile phone. The facts in the instant matter present a crystal clear picture that suppression is mandated by Florida Statute 934, even more so than the facts justifying suppression in McDade. So this isn't really different. I think these might be the same exhibits. It just seems like they're rehashing this argument because it's a different judge. So I'd like to see the state's reply to this. Again, if we can catch some of today's... I think today it's a status hearing, but she's also the state's supposed to make a final offer of any plea if they wish to, and see what if Clenney accepts it or not. But we might get some, I would love to hear the state just be like, Your Honor, we've already argued a similar motion, but we'll file another reply. We'll get to you. We'll get you a reply. Maybe this is a good time to refresh. Also, I see Kristen Vasquez in here. You've updated your picture. Good to see you. Good to see you. Again, hope you've been doing well. It was nice to see you pop in the Discord the other day. I should drop that link if you guys want to join. It's mostly right now a place if you want to chat off when we're not stream. You guys can hop over there and chat or share things. But I do think it'll also end up being a great place if you use Discord to share some filings, right? When we don't pop up on a live for everything. But sometimes there's like some juicy documents and we want to share them or talk about them. I think Discord's a great place to do it. So if you haven't joined and would like to, there is a link in the chat for that. And I've got to update. I'll get a description going and get everything in the description of this video as well. Hey, Shannon. You got Shannon Boo as the name again. Nothing on Court TV. Let's see. Nope, still nothing on Law and Crime Trials. So, and then NBC6, nothing live at all. But again, they typically just do a article and then they'll embed a video on their website. rather than on YouTube for Courtney Clenney. So we'll keep checking. Back over here to this argument. Oh, they are addressing it. All right, this next paragraph addresses it. Simply because neighbors made noise complaints does not vitiate the expectation of privacy. Most recordings were made in Miss Clenney's apartment, which was exceptionally private, with its own elevator that opened directly into her private foyer, with no one else being able to access areas near her apartment without a key fob. To me, yes, that's exceptionally private. This is exceptionally private, right? I agree. But what's the problem with that? If we have such a facility, we have like elevators and hallways surrounding the building, we're inside, we have all this privacy, nobody's just like coming up the elevator and they're wall to wall with where we're arguing and overhearing us. We have all of this privacy and you're still overhearing us to the point where we feel compelled to complain about it. Within like a month after they moved into this building, and continuously, several noise complaints to the point of the apartment complex moving to evict Courtney Clenney and anyone who lived with her. I'm not sure it helps to argue how private this residence was because people could still hear them in spite of that. But they're arguing it. So let's see. One of the recordings occurred in a semi-private setting. The court will have to make a determination as to whether this recording should be suppressed in its entirety based on the context of the recording. Regardless, Ms. Clenney had a reasonable expectation of privacy in her oral communications that society is prepared to recognize. There is no more sacred place than a person's home, where the majority of these recordings took place. These recordings are private conversations, not public meetings, or meetings with public officials in public places. There is a clear expectation of privacy in a conversation, or argument for that matter, between a couple in their shared apartment. This is a clear expectation of privacy that has been recognized over and over again by society. Florida law and applicable case law mandate suppression of the above referenced illegal recordings. So, I don't know. I'm all for privacy. I really am. All for privacy. And I guess one alternative is have the neighbors come in and say they used to hear arguing. But I'm just, if there's a complaint in the building, that's an issue now that impacts more than the two individuals residing and having a heated argument in one domicile. So, and I don't know. I think this does get into chilling effect territory. What's going to be so interesting about this case is with Courtney Clenney relying on a battered spouse defense to explain some of her behavior. The flip side of this is these things that you'd want, that they're arguing to suppress to help Clenney, are the same thing that, I don't know. I feel I usually see the person who's claiming to be a victim in a situation presenting to show it. Typically. We want to show these recordings. I took these recordings because nobody would believe me otherwise. We used to argue a lot, but here was the substance and the cause of those arguments. Here's the proof. I argued back, I reacted to it, but it was always just some type of power and control, and I was just stuck in it. Here's the proof. So, things can be different, everything can be unique. But I'm interested in seeing it play out, this battered spouse defense. And we're going to look at it. They're calling the person, I forget her name, but the person, the academic that came up with battered spouse as a syndrome. It's going to be an expert witness in this trial. So there's that. So let's see. In passing Florida Statute 934.06 into law, the legislature unequivocally expressed its desire to suppress evidence obtained in violation of that chapter, Davis v. State. Not only does Florida Statute 93406 unambiguously require suppression of these recordings, but it also mandates suppression of any evidence derived from the illegal recordings without exception. So, whatever the defense thinks the state used these recordings to go as a lead for something else, They want that out too. There is no deterrence-based rationale, as there is with a Fourth Amendment analysis, that determines or influences its application. Indeed, Florida courts have consistently construed Chapter 934 to compel ipso facto suppression of evidence obtained through illegal recordings. And while there are high evidentiary costs associated with 934.06's strict application, unlike the Fourth Amendment context, Florida courts cannot craft exceptions to mitigate those costs. We have a quote from State v. Garcia. Frankly, I believe that United States v. Leon is a better law than the mandatory exclusion required by Section 934.06, but because the statute is valid, we should follow it. So they're citing a court that says, you know what, the statute exists, so we're going to follow it. So the judiciary obliging by the legislation. I would suggest, however, that the legislature view this statute to determine if the automatic exclusion provision should continue. So maybe this really is a super, super strict thing in Florida. I'm reading this. They've made a similar argument to this before. And it was denied. So, but we'll see. And then they quote here that it is not for us to question this policy judgment, but simply to apply it. And then the court's function is to apply the law, not determine the wisdom of legislature's policy. So in conclusion, Statute 934.06 requires strict ipso facto application. So much is required by the rule's clear language and the Supreme Court's reasoning in Garcia and McDade. The illegal recordings must be suppressed as a matter of law. Now, it'd be cool. This, and Miami-Dade's website, they've updated it. They're now uploading documents directly to the docket. But unfortunately, before they updated this, when I used to do the request for documents, the state attorney's office was my channel. When I would go through the court, the clerk, never getting responses. Now we can get certain things like orders and things that are filed by the defense because the Miami-Dade state, the clerk, is uploading the documents directly here. But unfortunately, if we went back in time and looked for the orders for these previous arguments, not available, and I never got a response. So, and I'm not really that interested in pursuing like, hey, I've requested this thing. But I do know that they've argued about these recordings made from within the apartment, and the previous judge, Laura Sharon Cruz, didn't find them to be inadmissible at that point in time. So maybe this judge will have a different opinion, or maybe it is different exhibits. I can't tell just by looking at the file name. It just seems like a similar argument to what was previously argued. Let's see. Yeah, for always, forever, for life says, how can you argue expectation of privacy when you're screaming and yelling for everyone to hear you? Oh no, you say my upstairs neighbors fight like cats and dogs to the point that I'm scared someone will be killed. And that's the thing. Are you just supposed to not call that in anymore if you have a concern? Because, oh, privacy. At a certain point, it becomes unreasonable. Right? That someone should expect that this is private anymore. I can hear you through the floorboards. Like, and I would say not for nothing, but a scarier part of calling something like that in, and this is just me speaking personally, I think these situations are delicate and kind of always warrant context. But there could be some concerns that, you know, if you call something in on somebody, it could make the next argument worse. Yeah. Sapphire Ridge News says Florida has put people in jail for recording people without permission. That doesn't surprise me to hear. What is interesting about Florida, I think we are a no tolerance. And I don't know, I think a lot of you guys will probably say maybe your state is too. There's several states that are no tolerance, where pretty much if a domestic violence call is called in, somebody is going away in handcuffs right then and there. So, you know, we are a no tolerance state here on that regard. But I do always wonder, like, you call something in, somebody gets arrested for it, they get arraigned, they bond out. What happens when they go back to the house? Does that just end up making it worse? Yeah, Kate, it's really awesome and good to see you. Really, really awesome. And so far, no weird. I'm not even logged in. I didn't have to log in. I don't have to pay. Like with anything that we do in Georgia, you got to log in. It's a slow system. It's finicky. To create like 3 accounts on 3 different platforms to finally get court documents over in Georgia for the Fulton County stuff. And then you've got to log in every time. You've got your little shopping cart, and you've got to download right then and there, even though you're logged in. If I don't download something as soon as I do the checkout button, I got to go buy it again. So I've always been good about that, luckily, but it's stupid. Why am I signed in if you're not tracking my purchase history anyway? But yeah, this is, let me see if this link, if you guys want to check it out, there is the link to the clerk of the court and comptroller of Miami-Dade County. Just go if you want to look at criminal cases. I always just search by defendant name because usually that's the first thing I have before I have a case number on the left-hand side. Super, super easy to search this site. It's not like hieroglyphics or anything like that, but really awesome that it's really accessible. The next motion we've got, you guys, let's look at, we'll do the motion to compel disclosure. I think this is a good follow-up, and you'll see why. Let's open this. Come on, Google, play nice. All right, so this one, these were all filed this week. Well, last week, but within the last week. No, this was filed Monday. Okay. Motion to compel disclosure, Florida statute. Now, a lot of states follow federal rules, right? California likes to be different, but a lot of other states follow the same thing. So this is Florida statute 90.404. We've got 404 2A evidence. So 404, think character, bad acts, prior bad acts. Comes now the defendant, Courtney Clenney, by and through undersigned counsel and pursuant to Florida Rules of Criminal Procedure, moves this court for the entry of an order directing the state to disclose the following information. So they want this 404 2A information in this case. As grounds, defendant states that on or about August 4th, 2022, the defendant was arrested and charged with second-degree murder with a deadly weapon. Undersigned counsel filed a notice of appearance on or about August 15th, 2022, and indicated that he would participate in discovery at this time. The state of Florida, through discovery and at several hearings in this matter, has indicated they intend to pursue the admission of other crimes, wrongs, or acts pursuant to Florida statute 90.4042A. 4042D1 states in pertinent part as follows. When the state in a criminal action intends to offer evidence of other criminal offenses under paragraph A, paragraph B, or paragraph C, no fewer than 10 days before trial, the state shall furnish to the defendant or to the defendant's counsel a written statement of the acts or offenses it intends to offer, describing them with the particularity required for an indictment or information. So, this statute says the state's got to turn this over 10 days before. Now, this is a murder trial. We know that this has been going on. We've been waiting for this trial to have a trial date for 3 years. If this kicks off on December 1st, that will still be more than 3 years after her arrest, right? So a long way to get this to trial. And Florida statute says at least 10 days in advance, you've got to let the defense know that these are the prior acts. These are the other criminal offenses that we want to try to introduce at trial so the jury can see it. Got to put the defense on notice 10 days or earlier. So going back to the argument, the state trial in this matter is currently scheduled for December 1st. Should the state of Florida disclose the necessary information on or about November 20th, 2025, there will be insufficient time for the defense to prepare for the presentation of such evidence. Furthermore, admission of such evidence will be challenged by the defense and may require pretrial evidentiary hearings to resolve. So potentially, this could put the trial start date, December 1st, at risk. Do I think this is going to win? I don't think so, because I'm pretty sure what they're referring to has been submitted in discovery like 2 years ago already. So it's not that they're not aware of these other priors for their client or things that could go of wrongdoings, evidence of Courtney's prior wrongdoings. I'm pretty sure the Las Vegas arrest is in there. We've got the January 31st, 2022, the face slicing hospitalization for Christian. That's in evidence. The February text messages that reference that face slicing turned over in discovery. This issue is just the defense saying, we get that the state's only required to tell us 10 days before that they plan to use that at trial. It's not an argument of they have not disclosed it to us. They're trying to compel the yes or no commitment to using specific things at trial sooner or earlier than 10 days as required by statute. So I'm not really sure that this is... Really, my gripe with this is, as I'm reading it, is it just seems like a way to continue the defense. And I'm not really sure this is good for the client at this point. I'm not sure this is good for Courtney to delay her trial again and again and again. As permitted by Florida Rules of Criminal Procedure 3.220K, the court may alter the times for compliance with any discovery under these rules on good cause shown. Depositions of any 404-2A witnesses will have to be taken, and it is believed that these witnesses reside out of state. Further, the defense may need to obtain documentation and conduct their own independent investigation regarding these other crimes, wrongs, or acts. Additional time beyond the 10-day minimum disclosure requirements of Florida Statute 404-2A is appropriate in this matter to prevent further delays in this case and to avoid prejudice to the defense. Undersigned counsel previously met and conferred with Assistant State Attorney Sean Abahoff. Sean Abahoff is now lead counsel. It was Khalil Quinnen, but he stepped down. And now it's Sean Abahoff as the lead. So they conferred to resolve this issue. As of the date of the filing of this motion, undersigned counsel has not received the required disclosures from the state. So wherefore, Courtney Clenney respectfully prays this court enter an order compelling the production of the required disclosures within 10 days from the date of its order. So they want this early. And even if the judge weighs on this, I mean, if they hear this today, I don't know if the state's going to respond. I don't know if this is going to be a big deal. I think the judge might be like, can you get it to them any sooner? We'll try, Your Honor. Okay, cool. And then we're still going to be within 10 days of the December 1st starting timeline. It's the middle of October. I don't know how much sooner that'll get us there. But I don't know. What I think is interesting about this, you guys, is I don't know. This seems like... I just have a gut feeling that we might be getting into amping up the billable hour territory. Like, we just read a motion where Frank Prieto, the motion stated that Frank Prieto, undersigned counsel, has been there from the very start. From like the week that she was arrested, he filed notice of appearance. And he showed up when she first did the interview with police. Because remember, this all happened in April of 2023, or 2022. She's talking to police, but she's not arrested until months later. Frank was in the picture the whole time. And we've always leaned on that. And Frank's had a whole team committed to this. We've watched Sabrina make arguments. We've watched Diana make arguments. We're going to read one other thing. I think this will round out where I'm shaping my opinion from. All right, so the third and final is the motion for bond reconsideration. And this one pains me a bit. All right, so, and we're going to read this factual and procedural history because there's a detail here I didn't see before. So, In this case, the state has charged the defendant, Courtney Clenney, in the death of her boyfriend, Christian Obumseli. The events leading to the death of Obumseli occurred on April 3rd, 2022, at the apartment of the defendant. Mr. Obumseli was not on the lease and was only an authorized guest that stayed with her. All rent was paid for by defendant, Courtney Clenney. Except I think they were being evicted for non-payment, too. I think that was part of it. That and the noise complaints. Prior to April 3rd, 2022, Miss Courtney Clenney attempted to remove the decedent from the apartment. Mrs. Deborah Clenney, Courtney's mom, flew to Miami to help her daughter remove the decedent from the premises. The decedent attempted to remain on the premises by secreting himself in the common areas of the building and other areas of the complex, as he had no means of income to obtain alternate accommodations. After these events, the decedent was able to manipulate Miss Clenney to successfully access her apartment. This was after he sent close to 200 unanswered text messages to Miss Clenney during the time period that he was no longer welcome in her apartment. So this was new to me, and I can't highlight this document, but apparently he sent her close to 200 unanswered text messages to Courtney during this time period. So it'd be like maybe this, I don't know if this was over the course of the week or just the 48 hours that mom was gone. And I guess we'll have to hear more about that. So, but that's interesting. 200 unanswered text messages, if that's within like a one night period, that's a lot. I don't know. Shortly after April 3rd, 2022, undersigned counsel was retained by both Miss Clenney and her family to represent all parties. During the months prior to her arrest, undersigned counsel was in constant contact with both the Miami State Attorney's Office and the City of Miami Police Department. So here we're getting more information that during the months prior to her arrest, undersigned counsel was in constant contact with Miami. So before Courtney's even arrested, we've got billable hours. They're in constant contact with both the Miami State Attorney and the City of Miami Police Department. Undersigned communicated with both agencies to arrange for Ms. Clenney's self-surrender should a charging decision be made. After the events of April 3rd, 2022, Ms. Clenney sought treatment for her substance abuse issues and her post-traumatic stress disorder. This ultimately culminated with her paying for and traveling to Hawaii. There she attended an inpatient program that specialized in treating both issues. Again, at all times, undesigned counsel was in contact with both the Miami State Attorney's Office and the City of Miami Police Department investigators. On August 10th, 2022, the defendant, Courtney Clenney, was formally arrested and charged with second-degree homicide via an arrest warrant and use of SWAT teams located in Hilo, Hawaii, where she was attending the inpatient treatment program. Despite previous communications, neither the Miami State Attorney's Office nor the City of Miami Police Department contacted counsel to arrange for her self-surrender. Following an Arthur hearing and pretrial detention hearing held on November 15th and 17th of 2022, the court ordered Ms. Clenney to be held without bond. And they attached the order of detention. Ms. Clenney has remained incarcerated since her arrest on August 10th, 2022. What they're hinting at here, I agree with this. I do think that the Miami wanted to showboat this arrest, right? They delayed the arrest. Then there was this viral video where it was a girl's voice that recorded the videos, like posted on social media, one of those vertical videos. And they see Courtney Clenney and her father at the hotel lobby bar somewhere. And on camera, you hear the voice that's recording, presumably, like, didn't you just kill someone? You shouldn't be having fun right now. You shouldn't be celebrating, something to that effect. And that video goes viral. People are like, dang, how are they just letting this model walk? And then a few months later, we get an arrest and a high-profile press conference about the arrest. So I do think at this time, the prosecution was capitalizing on publicity, right? I think this is a fair argument. Let's see. Factual and procedural delays caused by government misconduct. And you guys, if you missed this saga, right? The laptop story and then these overbroad search warrants that want like 5 years of records relating to anything from not just Courtney's phone, which is what the warrant stated, but they also end up securing warrants for They also end up securing the iCloud information for Kim and Deborah Clenney, mom and dad. And then there's all these issues because prosecution didn't use a filter team. And it seems like Khalil Quinnen may have seen things he wasn't supposed to have seen. And he tried to say, well, there's a crime fraud exception. And the judge was like, where? No, this argument isn't flying. And did find that there was a violation. Prosecution drops the laptop charges. We had a whole fallout over a year for that. If you guys missed that, go back through the Courtney Clenney playlist. You'll have to go back through 2024. Really last January is when that started to kick off. Let's see. So because of that issue, obviously trial was delayed because of the fault of the prosecution. Let's see. So they go through all of this stuff that we've heard a lot. Let's go here. Let's go to the order on this issue. So on June 26, 2024, the court entered an order granting a motion to exclude and or suppress. This is the laptop case. The order found that the communication reviewed by the ASAs and law enforcement were privileged as attorney-client and or work product communications. And we'll look at the order. On August 20th, 2024, the defense filed a motion to disqualify the state attorney's office based upon the review of the, quote, Team Courtney chat. Subsequent to the filing of the motion, the defense was made aware of an additional and even more egregious breach of privilege by Assistant State Attorney Khalil Quinnen. After a public records request made by a third-party defense attorney, it was revealed that ASA Quinnen had also accessed another privileged communication sent from attorney Sabrina Puglisi to Courtney Clenney's parents. This communication included an attachment titled, Courtney's Checklist of Things to Do, Privileged, .docx. So you guys remember this? We were on the stream, we're like, probably should use caution. Probably should put your filter team on notice. Like, obviously, just because something's called something doesn't mean it is, but maybe you should use your filter team here. And they did not do that. They did not do that. Upon opening the communication, the first page of the document clearly displays the fields from, sent, to, subject, and attachments, with the from being the attorney for Courtney Clenney, and the attachment specifically named Courtney Checklist of Things to Do Privileged. Judge Cruz permitted the defense to take the deposition of Quinnen to determine the extent of the breach into the defense camp and violation of the attorney-client/work product privilege. ASA Quinnen, in the most unusual manner, filed a self-serving notice of withdrawal from Ms. Clenney's case, attaching his own interoffice memorandum on March 3rd, 2025. So he knew this deposition was around the corner. He said, look, let me just step down because defense was going to try anyway, but if I step down, that could look like we've ameliorated the rotten apple. So he steps down in an effort to save the state from being wholly disqualified. And for what it's worth, the state has not been wholly disqualified. We're still going to trial. A hearing was held on the motion. And the defense filed their amended motion to disqualify the state attorney's office. The hearing was held, and Judge Cruz ultimately denied said motion on the grounds that the prosecutorial misconduct appeared to be limited to only the verified conduct of ASA Quinnen. This order was entered on July 2nd, 2025, approximately 18 months after the defense first began to uncover misconduct on behalf of the state of Florida. Now, this is all state of Florida needs to do better. I think any defense attorney should fight this. I think any defense attorney should milk this. State of Florida didn't need to do all these things. It blows my mind every time we talk about Courtney Clenney that we had this whole side saga with the laptop case, when this case could have just gone to trial, and the state should have presented the facts that they have. They have a lot of bad facts for Courtney. A lot of bad facts. So why do we need to do all of this? This never should have gotten to this point. Prosecution should not be, forget our filter team, forget our protocols. Let's just go and look, and then we'll claim a crime fraud exception after the fact to cover our butts. We just never should have been here. So, just stupid. Waste of time, waste of resources. I do agree that 18 months was a delay of trial caused by the prosecution. In Florida, the standard for a substantial change in circumstance that may warrant a judge to reconsider a defendant's bond or the status of no bond after an Arthur hearing. Now, I don't know if they're going to mention it, but they did have a bond hearing after this 18 months played out. And it was denied. So, but focuses on demonstrating a change in circumstances or new evidence that was not available at the time of the initial bond decision. The state must also present evidence that convincingly shows changed circumstances or new information to justify a modification of the bail order. So where are we going? There is no requirement that the defense make a showing of a substantial change in circumstances. However, in the matter sub judice, there has been significant and massive delays, approximately 18 months. So they're sticking with the circumstance is the same thing, and we've already had a bond hearing in relation to this laptop case causing delays. So, but it's caused by the government's misconduct, as referenced above, that constitutes a substantial change in circumstance. Significant delay in the adjudication of Ms. Clenney's constitutional right to a speedy trial has been severely affected by the state's invasion of the defense camp, viewing of protected communications, and the filing of frivolous new charges. Further, Judge Cruz's denial of bond for Ms. Clenney was based on evidence she received from the state during the Arthur hearing. The state submitted to the court, so these are the same files that they just moved to suppress. There we go. This is how it's tying together for a renewed reconsideration. The state submitted to the court. You guys remember these numbers? They got this Arthur hearing packet containing, we have the 3782, 3794, 4001, 4005. These are the same file names. These recordings were surreptitious recordings made by the decedent of Ms. Clenney in violation of Florida Statute 934.06. These felonious recordings are a clear violation of law, and the legislature has made it abundantly clear they are per se admissible as evidence in any type of proceeding. So this is the same statute we read earlier. Same argument we read earlier. Okay. And then additionally, the weight of the evidence has shifted with the discovery of additional evidence and expert witnesses. So here we go, you guys. Are we going to hear anything that we haven't heard already for anyone that's been following this? Is there really going to be anything new? Let's see. To support the defense of justifiable homicide/self-defense. At the time of the Arthur hearing, the defense argued for the motion for pretrial detention should be stricken, because the court may order pretrial detention if it finds a substantial probability, based on a defendant's past and present patterns of behavior, that the defendant has previously violated conditions of release, and that no further conditions of release are reasonably likely to assure the defendant's appearance at subsequent proceedings, or the defendant poses the threat of harm to the community. The court may so conclude, if it finds that the defendant is presently charged with a dangerous crime, that there is a substantial probability that the defendant committed such crime, such as second-degree murder, that the factual circumstances of the crime indicate a disregard for the safety of the community, and that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. Additionally, the court should consider criteria under Florida Statute 903.046. So this is what they do. The courts consider when weighing bond. The nature and circumstances of the offense charged. B, the weight of the evidence against the defendant. C, the defendant's family ties, length of residence in the community, employment history, financial resources, and mental condition. D, the defendant's past and present conduct, including any record of convictions, previous flight to avoid prosecution, or failure to appear for court proceedings. And E, the nature and probability of danger which the defendant's release poses to the community. Oh, we keep going. F, the source of funds used to post bail or procure an appearance bond, particularly whether the proffered funds, real property, or any proposed collateral or bond premium may be linked or to or derived from the crime alleged to have been committed or from any other criminal or illicit activities. Whether the defendant is already on release pending resolution of another criminal proceeding or on probation, parole, or other release pending completion of a sentence. I, the nature and probability of intimidation and danger to victims. J, whether there is a probable cause to believe that the defendant committed a new crime while on pretrial release. K, any other facts that the court considers relevant. So the state has selectively, and this is pretty broad, right? K, any other facts the court considers relevant. I mean, certainly isn't a constraint to word it that way. The state has selectively presented parts of the discovery to the court and the media. There you go, throw that in there. Creating an incomplete and inaccurate picture. At the time of the Arthur hearing, the defense had not yet fully evaluated the extensive discovery materials. Although there were no witnesses to the events in the apartment on April 3rd, 2022, evidence indicates that Ms. Clenney and Obumseli had a tumultuous relationship. During the Arthur hearing, the evidence was biased, portraying Ms. Clenney as the instigator with violent tendencies, such as with the elevator video, the surreptitious recordings that were improperly considered by the court. Oh, they're taking a dig at the other judge. Isn't it nice to have a new judge? Because now you can try these things again. And you can say the other judge was a bad judge. I don't know if I would throw shade at the other judge, personally. I would just leave it as a polite request for reconsideration, maybe. Why not try? But they are like a little bit scorched earth here. They said improperly considered by the court. Since then, the defense has discovered a key witness corroborating Obumseli's physical abuse of Ms. Clenney. This is not new, you guys. Every motion that we read, and then we discovered a new guy. But they word it that way strategically. But they only mean since the April 3rd, 2022 thing. So you've got this guy, Arthur Cupp. He's a neighbor that lives in another building with a vantage point that looks at the window of the penthouse apartment that Courtney and Christian were in. And he goes up to the police on body cam and he's like, hey, my girlfriend said I should come over because last week, I think it was Saturday night going into the early hours of Sunday, we saw an argument. We saw an argument going on last week. And it looked like he was wailing on her, like going like this. And it was a dude and it was a girl in their apartment, their unit. So I thought I should come over and say something. State should have interviewed this guy. State should have, when they reviewed the body-worn camera footage, seen that, okay, one of these detectives, while he's trying to figure out why the elevator isn't working to go upstairs, maybe he was distracted and didn't think to write a more complete report. I mean, he wrote down what the guy was telling him and Arthur Cupp and his contact information. I had to redact his phone number from the body cam footage. State could have said, let's go do a follow-up interview. Doesn't seem like they did. So the defense has loved that. The defense has loved that. As they should. But they word it this way. And we're reading this reconsideration for bond. And the way this is worded makes it think like, last week we discovered a key witness. And it's really not the case. Since then, the defense has discovered a key witness corroborating Obumseli's physical abuse of Ms. Clenney. Arthur Cupp, a witness known to the state during the Arthur hearing, told police via body-worn camera footage on the incident date that he previously saw Obumseli pummeling Ms. Clenney from his apartment across the street. Compelled by what he observed, Mr. Cupp, a neighbor with a direct view into Ms. Clenney's apartment, approached the police on the incident date to report his observations. Reasonable expectation of privacy? I say no. As a member of the public, I'd say sure. There's no expectation of privacy when your window blinds are open and the people across the way can all look in and ogle at whatever's going on in your building. But I'd say the same thing if you're screaming so loud that it's disturbing the neighbors and they have to make noise complaints. Right? So this is the flip-flop of the argument here. Now we're not arguing for expectation of privacy. Statements. Well, I think, Aaron, the change in circumstance that I think they're going to get at, I don't think it's a strong argument, but it makes me feel bad about the criminal justice system. It's the most significant change to me, even though I don't think it's a compelling one for the sake of bond reconsideration, except maybe going to someone being a flight risk. But we'll see. We'll see. Statements from other neighbors document Obumseli acting aggressively towards Ms. Clenney in the days leading up to April 3rd, 2022. Interviews conducted by the City of Miami Police Department after the events demonstrate that Ms. Clenney was clearly a victim of domestic violence. These statements, along with reports from security personnel who contacted law enforcement less than 48 hours before Obumseli's death, after witnessing him aggressively, quote, charging. So if you guys remember the video from the day before, one of the building staff, I think he's like a manager of the staff. He was a shorter guy, and he was holding like a walkie speaking with responding officers. The same video where Courtney's asking for a restraining order, where she says, I haven't always been the victim, but I'm the victim this time. He says he was charging at Miss Clenney through the lobby. Right? So that was one of the things the state didn't really talk about that. The media, when the media posted that video, they posted like 40 seconds total of it. And honestly, there are some things in there beyond that 40 seconds that went all over the media kind of helpful to Clenney. You didn't see it unless you requested the exhibit and watched the thing in full. Right? So that's what they're referencing here. She implores, Courtney, during this interaction, implores the police for a restraining order against Obumseli, and her pleas were documented on the body-worn cameras of the responding officers. Mr. Cupp, a defense witness known to the defense at the time of the Arthur hearing, was unable to provide his testimony for the court's consideration. Additional evidence supporting Ms. Clenney's claim of self-defense includes testimony from defense experts Bobby Branton and Dr. Maraschini. So we have a footnote. Let's finish the sentence. Self-defense includes testimony from defense experts Bobby Branton and Dr. Maraschini, who will assert that the knife in question could be thrown and penetrate the decedent to a depth of nearly 3 inches with a slight downward angle. 2. Footnote. It should be noted that Dr. Maraschini is also experienced in knife throwing, unlike the state's medical examiner. When I read that footnote, I love a footnote, right? But the way they write is just not my style. It's just not my writing style. It almost seems like, I think I called it the flat soda of snark. It doesn't land to me that way. There are so many times where I love good snark, and I think it helps a point be driven home. I think I just don't like this writing style. I think we overuse colorful words too much. Then now we get this like sidebar snark in the footnote, where it's just kind of like, okay, that's the point of you. This footnote is exactly the point of trying to bring in an expert witness to show them experience that somebody else doesn't have. So, like, okay, this just doesn't need to be stated. Who will assert that the knife could be thrown in the I flung it like this manner. Ms. Clenney consistently stated to initial responders, and not for nothing, but I'm pretty sure they disclosed these expert witnesses for the previous bond hearing. They had a new doctor. Maybe this is the third doctor. So you have the state medical examiner. Maybe you had a different one at the second bond hearing. But they had the knife throwing video. And then an expert doctor that they hired to discuss the angle and depth of penetration in relation to the way the knife was purportedly thrown. You had this at the second bond hearing. So this is not new for the sake of this third bond motion. Ms. Clenney consistently stated to initial responders and later at the police station that she threw the knife in self-defense. The state's medical examiner testified that, in his opinion, it was not possible for the knife to have been thrown as Clenney claimed, though he admitted he was not a knife-throwing expert. The defense expert's testimony, and Sabrina Puglisi did the examination. I thought she did a great job. At the first Arthur hearing back in November of 2022. I thought she did a great job, and you can see that they're bringing back her questions and answers. They're recalling it for the sake of this motion here. So props to her for that. The defense expert's testimony validate Ms. Clenney's statements and corroborate that her actions were justified. Finally, the world's leading expert on battered spouse syndrome, Dr. Lenore Walker, is expected to testify at trial that Ms. Clenney was suffering from battered spouse syndrome. Dr. Walker will testify as to Courtney's state of mind at the time she was forced to take action in the defense of her life. So, if you're interested in battered spouse syndrome defenses, if you're interested in self-defense claims, this is going to be a trial. This is going to be a trial. Previously, in the state's pretrial detention memorandum, the state inaccurately claimed that Ms. Clenney immediately fled the jurisdiction. In reality, Ms. Clenney, through her counsel, maintained consistent contact with law enforcement. She did not flee, but instead returned to her home in Texas, where she and her family resided before her relocation to Miami to seek treatment for PTSD and substance abuse issues. To bolster their request for pretrial detention, the state further argued that Ms. Clenney fled the Texas jurisdiction to California. This assertion is also false and misleading. Ms. Clenney had a pending misdemeanor DUI in Texas and traveled out of state because there was no court-imposed restrictions on her travel. That case has since been resolved. Florida Statute 907.043C5 requires that the defendant pose a threat of harm to the community. The evidence in this case does not suggest Courtney to be a threat to the community. So we're just jumping to a different prong. She has no prior criminal history that involves violence or a threat to someone other than Mr. Obumseli. The circumstances and evidence which now show that she was the actual victim. The state also argued that the transfer of funds from Courtney to her father after April 3rd, 2022, while the investigation was pending, was an apparent effort to relocate and conceal assets. And this was big. I think that was one of the bigger things that, social media reactions, the media, the news coverage, that bond hearing when the dad was testifying. And we hear that, you move $1 million from her account to your Bank of America account. Everyone was like, oh. And she buys a house, right? After the incident and before the arrest, she buys a house in the same cul-de-sac area of the neighborhood where her parents' house is. People read into that as well. I don't know if I really read that much into that. I think that this is, we read the note from Christian with the big rip in the middle and talking about how Courtney calling her mom as a lifeline. Maybe you're just buying that house to be closer to mom because that's what you do when you're going through tough times and the house just isn't in the cheapest neighborhood, right? But the Bank of America, the moving of money, people were like, oh, that's sus. That's really suspicious. I can imagine a jury looking at it that way. But I don't get what this has to do necessarily with this renewed motion for bond. You think they're going to tell us? I think we're finally going to get to the difference, guys. So in reality, Kim, this is dad, Kim Clenney, took over managing his daughter Courtney's financial obligations after April 3rd, 2022, because she was suffering from PTSD and excessive alcohol consumption. But they're in a video at a bar together. Like, when I read this line, I was like, how are you arguing this? When the reason the vast majority of people first learned about why this case was so crazy was because of that viral video where the girl sees Courtney and her dad in April, I think it was like April 18th, at a hotel bar together, having a drink. So how does this jive with the argument that dad is actually managing her finances specifically because she was suffering from PTSD and excessive alcohol consumption, when they were already moving the money before this video? It's almost like maybe I'm following you, but then as soon as there's context added, it's like, no, that doesn't reconcile at all. So, the funds to pay a bond in this matter would come from her parents, as Courtney is essentially broke. This is where I think the difference is, guys. This is the pinnacle difference. I don't think it's a compelling difference. The funds to pay a bond in this matter would come from her parents, as Courtney is essentially broke. Her home is in foreclosure, and any equity that she will be able to salvage has been earmarked to pay overdue expert and attorney's fees. So this little 2-sentence line, roller coaster of emotions for me. A few months ago, we're like, hey, it's being reported that her house was put up on the market, put up for sale. And to me, guys, I think that sucks. I don't think it sucks just because if somebody did something wrong and they have to pay for it, sure. But if we take an umbrella view and we look at the cost of somebody affording private counsel that's dedicated, counsel that can write all of these motions for every little thing 3 times. And I think some of these motions are unnecessary. But I think if I was in a cell and I had the money, I'd be like, yes, please just keep going. Please keep fighting for me. I don't know. I don't like to hear that anybody is losing their ability to afford their defense. I also am not sure how I feel if there's a billable hours situation here where we're trying to run that up. I don't know if this is a great position for a defendant to be in. Specifically, that defendant here is Courtney Clenney. But maybe if you're just saying, we could do all these things for you, we're going to send you a bill for it. I wonder if they've had a conversation with her that's like, if Clenney's requesting, keep filing. Well, hey, Courtney, you know what? We've done a lot of work for you. We know your house is up for foreclosure. We don't really know if this has a shot. And then inform her, guide her, give her the proper guidance. And still let her decide, yeah, I'm fine. Like, let's just try again. Write the motion, submit it, send me the bill. Fine. But if that's not happening here, and it's something more like, we've got to file this stuff. We're going to get it. This one's going to work. Like, I don't know. So this little segment put me in a bit of a catch-22 where I don't love it for the system. Also, I have some questions about the bills that are running up here. And then finally, as indicated above, and again, I think this is the biggest change in circumstances potentially. And they're not really, I feel like they should have emphasized here, and maybe they can't because they're saying parents have money. But I would have argued here, I'm not a lawyer, but I would have argued here, like, if they argued that she was a flight risk previously because she had more than $1 million, well, that's largely been depleted. Even the funds that were transferred, even the funds that were put into the house have been depleted. And I would have, that goes to one of the prongs. Maybe we'll get to it, though. Finally, as indicated above, the state has acted improperly in numerous aspects. 1, presenting an overly broad warrant application that was for the iClouds. 2, failing to implement proper filter protocols to ensure attorney-client privilege communications were not reviewed. And 3, reviewing attorney-client communications in violation of the law. As a direct result of these errors, Ms. Clenney remains in custody, with her having remained at a standstill for about 18 months. So, this part, I agree, sucks. Law enforcement, with the approval, assistance, and at the direction of the state attorney's office, filed an affidavit supporting a search warrant for Kim and Deborah Clenney's iCloud accounts. The warrant sought everything on the iCloud, photos, texts, emails, notes, etc., of Deborah Clenney due to the messages exchanged with Courtney Clenney immediately after the incident on April 3rd, and known photographs taken by her mother. It also sought Kim Clenney's iCloud data due to the commingling of funds between him and his daughter after Obumseli's death. The warrant covered a period of 17 months before and 10 months after Obumseli's death. The privileged communications read by the state attorney's office were made after Ms. Clenney was in custody, during which she had no phone communications with her parents. There was no valid reason to request or review these communications, as they were irrelevant to the investigation and inconsistent with the warrant application's reasoning. And again, we've had, if I haven't driven this point home enough, there's been a motion for bond reconsideration that's already relied on these facts. Like, these are not new facts being used for the first time for a motion for bond reconsideration. This is a rehashing. So, Dizzy, Viz, yeah. There is no obligation for their attorneys to inform the state of their representation. Mr. and Mrs. Clenney are listed as state witnesses, so the state attorney's office could have easily contacted them to ask if they had counsel, or contacted undersigned counsel, knowing they were the parents of his client, and would... His client? Oh, Frank's client. And would likely know if they were represented. The more likely answer is that the state attorney's office did not want to tip off the Clenneys that they had sought a warrant for their communications because they simply view everything through prosecutorial blinders. And this is why we have the order attached, because we want to pull in this in dicta fighting here, as reasoned by Judge Cruz in her order suppressing evidence. And we'll look at that. It's attached below. The state attorney's office admitted to having reviewed attorney-client communications and desperately tried to make frivolous arguments justifying their review. There was a conflict and crime-fraud exception. I agree. I think these arguments were frivolous from the state, and I do think that it was a cover-your-ass approach. I agree with this. Despite having no evidence to support their theories, the state continued to litigate this matter through extensive motion practice, delaying this matter even longer. The court ruled that an attorney-client privilege existed, the communications were privileged, and no exception justified the state's review of such communications. Initially, the state argued that no attorney-client privilege existed due to a conflict of interest for undersigned counsel representing them. The state misunderstands the proper procedure for a potential conflict. It is not to unilaterally decide there is a conflict, thus negating privilege. Well, and more specifically, is not for the state to unilaterally decide that there is a conflict, thus negating privilege. The state attorneys should have motioned. Really, the person with the discretion to unilaterally decide a conflict would be one or both of the clients and the law firm, or the law firm. The judge still needs to hear both sides on the matter and ask the client, do you wish to waive this potential conflict or not? And the state can argue. I would have written this as, it is not for the state to unilaterally decide. This is where I would have gotten spicy. The state attorney should have motioned the court, advised of the potential conflict, and sought the court's review to determine, 1, if a conflict existed, and 2, if the clients could give a valid waiver of any conflict. Instead, the state attorney's office made the decision unilaterally. Yeah, we should have led with that. That was punchier. Additionally, the warrant, if you have a chance to throw some justifiable snark at the state, take the opportunity. Take the opportunity. Especially if that's your style. No case law supports the notion that a state witness is precluded from having representation. Guys, and we know this is all a rehashing. But because of the above delays, Ms. Clenney's aggressive defense grinded to a halt, having to defend new charges and refusing to continue discovery with prosecutors who should not be handling the case. So this is talking about after Quinnen steps down, but Sean Abahoff is stepping up, is now the lead. This delay could have and should have been avoided had the state attorneys followed proper protocols. So, in the conclusion, I guess the argument's that cumulatively, all of this stuff is a new reason to motion for bond reconsideration. The evidence, now more fully evaluated, reflects a long history of mental, emotional, and physical abuse inflicted by Ms. Clenney's abuser, Obum Selly. The calculus has shifted in favor of granting a bond in this matter when considering defense experts' testimony and anticipated testimony in this matter. Additional defense witnesses have been located that corroborate the abuse Ms. Clenney faced. The court can impose conditions to ensure Courtney's appearance in court and the safety of the community. The defense recommends a monetary bond with special conditions, including home confinement. Ms. Clenney can participate in an electronic GPS monitoring system from her home in Texas, with the program providing regular reports to the court and the state. She should also attend an outpatient program for PTSD and alcohol/drug abuse. The defense requests that the court release her to the custody of undersigned counsel to travel with her to Texas and ensure the monitoring system is implemented. So wherefore, Courtney's moving the court to reconsider the denial of reasonable bail, given the delays caused by the state's misconduct, the strength of the defense case, and the expert witnesses who will testify to the reasonableness of Ms. Clenney's actions. We've already argued the delays. I don't think these expert witnesses were already previously disclosed before the second motion for bond reconsideration. And they didn't get into the specifics. They gave this vague mention Arthur Cupp is not new. I think Arthur Cupp was involved in the second bond hearing somehow, some way. I don't know if they brought him in or were able to present video testimony. Yeah, so I don't know. There is this vague mention of other defense witnesses, but they didn't really make an argument how that's going to shift, the weight of the evidence against what the state is saying. So if they do have these other witnesses that have something very compelling to say, they didn't spell it out in this motion. So, and they attached some of the things that they referenced here. This is the first bond, right? This is the first one? Yeah, so this is the first November 2022 denial of the bond. Now this is where we get that quote from the decision finding the prosecution overstepped. So let's see, this is back in 2024. Again, this is all Judge Laura Sheeran Cruz. It's now Judge Wolfson, Andrea Wolfson. Ricker Wolfson is the trial judge. But this is from Laura Sheeran Cruz in the laptop case. The court has read defendant's motion, defendant's supplement to the motion to suppress, and motion to dismiss for prosecutorial misconduct, State of Florida's motion to strike and response to defendant's motion to suppress and dismiss, State of Florida supplemental briefing, all of these things. They read all of it. And here, the order, defendant's motion to suppress and or exclude is granted with a footnote stating that, again, the court is only granting the suppression and or exclusion portion of defendant's motion. We're not disqualifying the state. The court finds that Courtney, Kim, and Deborah Clenney have all been represented by Frank Prieto and Sabrina Puglisi since August/September of 2022. The communication sought to be excluded by the parties is protected by attorney-client privilege and or work product privilege. This privilege was violated, albeit perhaps unknowingly, when the communication was read by prosecutors in this case. The court finds that the crime fraud exception of privileged communications under Florida Statute 5024A does not apply in this case, because the state of Florida has made no prima facie showing that defendants knew their communications could be an alleged crime. The proper remedy for this breach of privilege is exclusion of the communications from use in this case as evidence. So then they file, and after that order, by the way, that's when the state comes out and they say that they're not pursuing the charges anymore. So they dropped the charges in the laptop case. That was not the judge saying, I'm dismissing this. But the state made that decision in reaction to that order. Let's see. This is the order to compel the deposition of Assistant State Attorney Khalil Quinnen. So, again, this order was before he voluntarily steps down. So this was back in the spring of this year. So having heard the argument, court hereby orders that this motion is granted in part. The court has previously found that ASA Khalil Quinnen violated the work product privilege of defense counsel when he accessed and read an email dated December 22nd, 2022, titled Update, and the attachment to the email titled Courtney, Checklist of Things to Do Privileged. This email was sent by defense counsel to Courtney Clenney's parents, who are paying for her defense. After reviewing the contents of the email and attachment, the court found that it was quintessential opinion work product, and that it contained the views of the attorney as to how and when to present evidence, his knowledge of which witness will give certain testimony, and personal notes and records as to witnesses. The protection of an attorney's mental process is essential to the proper functioning of the adversary system. Although ASA Quinnen argued that the work product privilege was waived because the email was between defense counsel and Ms. Clenney's parents, rather than to Ms. Clenney herself, the court did not agree. Disclosure of opinion work product might be made by any number of third parties before trial if they are to be potential witnesses in the case, or if, as here, they are intimately involved in the litigation as parents of the defendant paying for her defense. Where did they get this? I want to get to the quote. And also I love, this red text. This red text, it's just saying that, this is the copy that was uploaded to the docket online, not like the certified printed out copy from the courthouse. But I always think of like the denied red stamp. Here they quote some case law from the 3rd District Court of Appeals of Florida that in contrast to the attorney-client privilege designed to protect the confidential relationship between the client and his counsel, the work product privilege is designed to promote the adversary system by protecting an attorney's trial preparations, not necessarily from the rest of the world, but from an opposing party in litigation. Thus, a disclosure made in preparation for trial does not waive the work product privilege unless it is, quote, inconsistent with the maintenance of secrecy for the disclosing party's adversary. That is, that it substantially increases the possibility of an opposing party obtaining the information. Clearly, defense counsel would not have anticipated the opposing party obtaining or reading their communication. Although taking the deposition of opposing counsel is rarely justified, the court believes in this case it is. Defense counsel has filed a motion to disqualify the Miami-Dade State Attorney's Office based upon a prior breach of attorney-client and work product privilege. Defense is now faced with the second breach of that privilege by ASA Quinnen. Defense only learned of the second breach during a Chapter 119 request made by defense counsel. As ASA Quinnen has not voluntarily withdrawn from prosecution in this case, so this is what prompted it, the court believes that the defense should be allowed to determine the extent of ASA Quinnen's knowledge of privileged documents and communications. The email in question was forwarded to Detectives Cremacini and Perez of the Miami-Dade Police Department. And we read some of their... So there was a deposition with Cremacini and Perez, and, you know, what it boiled down to with the two of them, these detectives were like, I think one of them was like, he went through it. He told us to go through it. And then the other said something more to the effect of, he didn't tell us not to filter these instructions. He just told us to go through the instructions. So the statements that they got from Detective Cremacini and Perez both pointed in different ways at Quinnen stomping all over the attorney-client privilege. Which, oops. Both detectives were deposed by defense counsel and were not able to testify to ASA Quinnen's knowledge of the email or other defense communication. When this motion was first filed, the court denied it without prejudice, pending the depositions. So these depositions were critical. And this is cool because we got to see the state's reply to some of this stuff, but we didn't really get to see, this is my first time seeing this order that we're reading. We didn't really get to know the math or inner workings until now of how the judge came to this decision. So at first, nope, it was denied, but then they go and speak to these detectives, and once they get the statements from the detectives, the court's like, all right, yeah, we see why deposing Khalil Quinnen would be necessary. Because these two guys cannot tell us what Quinnen might have gone through and looked at in this material that he wasn't supposed to be looking at. But they did tell us all signs point to Quinnen looking at things that maybe he shouldn't have been looking at. Let's see. So they can't testify to his personal review of the privileged documents. Although ASA Quinnen argues that defense could address its concerns about breach of confidentiality through interrogatories, the court does not agree. Interrogatories means they would be able to answer on paper, right? And anybody for the state could write that motion, write those interrogatory responses. A deposition, you're under oath and you've got the attorney sitting there able to ask you questions. So big difference. And I think it's funny to see that Quinnen, oh no, we just let us do it during interrogatories. And the judge is like, I don't think so. So at this point, there has been extensive litigation regarding this ASA's review of privileged documents. He has not voluntarily withdrawn from this prosecution, nor did he volunteer knowledge of this new breach. Defense counsel had to learn of it through a public records request. At this point, the court believes that the defense has, quote, exhausted less intrusive discovery methods, made a showing of necessity and materiality, and that the interests of justice require this extraordinary step of taking the deposition of opposing counsel, ASA Quinnen. The court agrees with defense counsel that this deposition should proceed so that they can adequately argue this motion to disqualify. So, this was one of like the few and far times where we get to see the prosecution's a witness. Gotta depose him. Gotta make him take the stand. The prosecution is the witness. The court actually agreed here. The deposition will be subject to the following limitations. And I think we heard about this somewhere. Somewhere we saw about these limitations. That questions will be limited to the subject of Quinnen's receipt and knowledge of privileged documents. The deposition will be conducted in the court's chambers in the presence of this judge. Defense will proffer a proposed list of questions before deposition to the court in state so that the court can review and rule on the propriety and or relevance of each question. After questions are proffered, further argument can be made by each party about propriety and or relevance of the questions. So there was that order, and that was it for the exhibits attached on this motion for reconsideration. So to me, the biggest difference is we have a new judge. Other than that, you guys, I don't see, we don't hear them arguing about the deposition testimony from Danny, red shirt guy. We don't really see them hash out. They basically say Courtney's essentially broke. They don't make the argument, although I guess the court could infer sua sponte, they don't make the argument that, her financial means, what previously might have allowed the state to argue she was a flight risk, aren't at play anymore. And then everything else isn't really new. So there's that. Let me do a refresh on NBC6. Let's do a Courtney Clenney search over there. And by the way, you guys, if you want to read, because I know we skipped over that one attachment. Let me get the share link for this motion. All right, so in the chat, if you want to check out the full text, there it is for the reconsideration of bond. Hey, KP, good to see you. I always love when I can tell someone's in the chat because of everyone else showing the love. And I'm like, oh, KP's here. So good to see you. You know what? Young Black Economist says how many private jets her dad have access to. Friend of a friend have a plane. Whatever firm he works for has a private plane. What's interesting about this, and it's like so unrelated to this case, but I feel like more and more I'm seeing like jet rental services where it's almost becoming more accessible, right? Or people are kind of doing like an Uber with a jet rather than calling in a car service. So this type of question to me isn't necessarily constrained to what's the availability of resources that this family has and would be willing to use in the defense of their daughter. I mean, their family has done these interviews. They've sat with TMZ and they did some production with like a Hulu TMZ collaboration. These parents are out there advocating for their daughter. I don't think anybody's disputing that. So if they have the resources, they certainly also have the will to do big, expensive things, and they would do so for their daughter, right? And then on the flip side, I think it's becoming more affordable and more accessible to get like private transportation services that used to be considered very highbrow, very high ticket. So yeah, created by EJF says, can't relate, haven't been on a plane since January of 2003. I also do not think that I am in private jet territory. Although I'd say it's getting closer, right? It's just not as, I think you can get probably a phone app, right? There's got to be an app or a website you can go and try to book a private jet service. It's just easier to do. You don't need to be rich and have an administrative assistance. You need more money than regular airfare, right? I just think it's a cool industry growth. Yeah, in Miami especially, you're right. Let's see, we got Barbara in the chat. Good to see you. KP's gonna bring out the crazy scale for us. The crazy scale. I don't see any updates from NBC6. Although, maybe new judge. Maybe the new judge is like, look, media access is fine, but let's not do it live. Maybe it's not set up in her courtroom the same way. Law and Crime has nothing. Court TV has nothing. Let me do a general search. And then we can look, if you guys want to do the New York State, the Department of Corrections trial, the closing arguments, we can go over to that. And we'll start from the beginning of the closings if you guys want to stay on and do that. If we don't find a Clenney stream. I'm shocked. I'm shocked that there is not a feed for this. This case was big news during, like, I'd say 2022 and the early parts of like January, February 2023. Tons of coverage, all these documentaries, and then all of a sudden nothing. All right, and if I filter by Courtney Clenney hearing today, the only thing happening today, the only result is my own, this stream right here. So we're in a closed loop here. This is the only result for Courtney Clenney hearing, unfortunately. So I'm going to have to update the title. Let's do, created by EJF says the Central New York Central has the New York State one, just started 20 minutes ago. So we can pull that up. And now, quick background, we're not going to do a full case breakdown on this, but in short, a bunch of Department of Corrections officers that were on the video, either because they're alleged to have been participating in the beating of Robert Brooks and or participating in some type of cover-up after the fact. This trial, closing arguments are what we're going to watch. Only opening and closing arguments were streamed. Everything else you had to follow through text-based reporting or had to go in person. Only 3 defendants are on trial here. 1 remaining defendant severed from this trial and will have their own trial in January, but the rest all took plea deals. And those officers came in, they testified against the 3 that are on trial here. So unfortunately, we didn't get to watch the play-by-play from gavel to gavel. So it might be... And it looks like this actually might start in the middle. So this first frame looks like he's already speaking. So it might be a little confusing for us to jump in on. Unfortunately, that's just what you get when trials aren't streamed, aren't televised. FFS says redirect us to the kattnotwilliams Courtney Clenney hearing stream. Why is this doing this? Let's refresh it because it's being a good time.
What the law requires in the...
Yeah, so this is starting on this guy mid-sentence. We'll see if captions are here. Yeah, get this full screen.
In the body, even in the mouth. They also told you how important it is to check for hidden weapons, drugs, or items that could be swallowed or used against officers. That's the environment these men work in every day. And that's when Officer Farina steps in. He moves in to check Mr. Brooks' mouth. Not to hurt him, but to make sure there's no hidden contraband or obstruction.
Is this kind of quiet? Bump it up a little bit. We got YP and Jenny hopping in at the same time. Good to see you guys. Bump up the volume.
And possibly to wipe away blood or pepper spray. You'll see a cloth in his hand. The district attorney wants you to believe that cloth was used to try and gag Mr. Brooks, but that's simply not true, and it's illogical. Look at the video. You'll see Farina wiping. He's performing a standard, lawful, and necessary part of the search process. Suddenly, Mr. Brooks bites down, hard, on Officer Farina's finger. He didn't hurt his finger by punching him, as Sergeant Trombley tried to imply. He even heard somebody say, "got bit." And in that instant, Farina reacts. Officer Kessler...
Okay, so, thank you. So, created by EJF says WKTV has it from the beginning. So, sorry, we're going to switch over. We're going to watch. Because, I mean, presumably this is a defense attorney, right? Based on what he's saying. But if we can get to the full opening, that's way better, I think. So, thank you for finding 2 different ways to watch this. And this one sounds a bit old-timey. You guys will hear it, I think, when we start playing it. All right, so let's go here.
We will be hearing the summations of the lawyers. Following the summations, I will instruct you on the law, and then you will begin your deliberations. Under our law, defense counsel must sum up first, and the prosecution must follow, and the lawyers may not speak with you after that. The summations provide each lawyer an opportunity to review the evidence and submit for your consideration the facts, inferences, and conclusions that they contend may be properly drawn from the evidence. If you find that a lawyer has accurately summarized and analyzed the evidence, and if you find that the inferences and conclusions the lawyer asks you to draw from that evidence are reasonable, logical, and consistent with the evidence, then you may adopt those inferences and conclusions.
Yeah, this is the judge.
Do bear in mind the following points. First, you are the finders of fact, and it is for you and you alone to determine the facts from the evidence that you find to be truthful and accurate. Thus, you should remember that whatever the lawyers say, however they say it, is simply argument that's being submitted. One lawyer's recollection of the evidence may include the testimony refreshed. You may have all or any portion of the testimony read back to you. Fourth, remember that under summations, the court will recognize as English on behalf of.
You have all been part of a very unique process. You've all been part of a very unique process that honestly does not take place very often. You have had to manage 3 trials at once and listen to 3 different defense attorneys, and that itself is not an easy task.
And
I want to thank each of you for all your attention during this trial.
Thank you.
When this trial began, I told you that this case is not about perfection.
It's about perspective.
It's about how we judge a man who works in one of the hardest, most dangerous environments imaginable. It's about how the law requires you to evaluate his actions, not from the safety of hindsight, not from the comfort of this courtroom, but in the reality of that world. Inside those walls, chaos is normal. Threats are constant. Every sound, every movement could be the start of something that turns violent in seconds. In that world, correctional officers like David Kingsley don't get to stand behind glass. They live on the line between order and danger. David Kingsley has lived that reality for years, working 16-hour shifts in a place most people couldn't walk in for 5 minutes. He doesn't get to hit pause or rewind when something happens. He reacts, because if you hesitate, someone gets hurt. This case isn't about a gang or a conspiracy. It's about reality, the real world of a New York State prison. It starts at Mohawk. The prosecution doesn't want you to think about Mohawk, but you must, because everything that followed began there. You heard that Mr. Brooks was involved in several physical altercations for 3 straight days, on December 7th, 8th, and 9th. You were told more specific information when you heard from incarcerated individual Michael Peacock. And Michael told you that on December 8th and 9th, Robert Brooks was assaulted by other incarcerated individuals, not by officers, but by other prisoners inside Mohawk. Michael described how these people use locks and socks, deadly weapons capable of causing serious internal and external injuries. Michael also told you Mr. Brooks, on both occasions, was struck in the face, head, and body with fists, as well as being kicked, slammed to the ground by 3 individuals, one who was 6'10", 400 pounds, who were beating him all at once. That after his head hit the concrete floor, Brooks crawled away, got up, and started screaming for help. After these beatdowns, you heard from witnesses that told you about Mr. Brooks' resulting symptoms and the medical treatment that followed. The symptoms of nausea, vomiting, headaches, and general confusion, followed by making irrational statements like going on an airplane. All indications that something was seriously wrong with Mr. Brooks. Now, common sense tells you this. If a man is beaten like that, a game beat down, as it was described, hit with swinging metal inside a sock, not limited to his face, you can assume those blows covered his body, and those injuries didn't disappear. They went with him from Mohawk to Marcy. Sergeant David Sayab responded to the 3rd incident on the 9th. He saw Mr. Brooks' face swollen and bruised, and during that frisk, he found a sock in one pocket and a lock in another. He told you how quickly that could become a weapon. In seconds. It's a lock and a sock. He said locks are not allowed outside an inmate's cubicle, that it's a serious infraction. Sergeant Sayab also described that just because a lock and a sock are in separate pockets doesn't make them harmless. All an individual has to do is slide the lock inside the sock, and he has a weapon that can cause serious injury and even kill somebody. He explained the first procedure, the importance of keeping an inmate's hands high on the wall and his eyes straight ahead. If hands comes down, it creates danger. If an individual looks around, it means he's sizing up his surroundings, gauging the correctional officer's position, and contemplating his next move. He also told you that contraband drugs and weapons are hidden everywhere, in clothing and hats, on and inside the body, and even in the mouth. Now, he didn't search Mr. Brooks' hat. I'm not faulting him for that. He did his job honestly and professionally. But it shows how quickly risk can hide in plain sight. It can also legitimize Officer Kessler's concern with Mohawk. Assistant Commissioner Marticello tried to talk about policies and procedures, but he hasn't worked in a housing unit in nearly 30 years. He worked behind those walls for 3 years and got out as soon as he could. He knows what's written on paper, and he even sat there and was able to read those policies to you, but he doesn't know the reality of that world anymore. He does not understand the practical solutions or techniques officers employ to keep themselves safe, such as having an individual keep his hands deep in his pockets. All he could say is that I would want to see his hands. Sergeant Sayal does understand the reality. He works 16-hour shifts, day in and day out. You heard about how short-staffed they are, and about all the overtime that they work. He doesn't go home at 5 o'clock to see his family. He's living in a job where every movement, every second, can turn violent. And the law says this: you must evaluate what happened in the context of that environment, not from the comfort of hindsight, not from the calm of this courtroom, but from that place, the world of danger and unpredictability, where decisions can happen in seconds, and hesitation can get you seriously injured and sometimes killed. By the evening of December 9, 2024, Officer David Kingsley was almost at the end of his day, a 16-hour shift at Marcy Correctional Facility. He wasn't pacing the floor looking for trouble. He was standing there watching a movie, waiting for the clock to hit 10 so he could finally go home. He wasn't angry with Robert Brooks. He wasn't frustrated with him. He didn't even know who Robert Brooks was. There was no plan here, no conspiracy, no welcoming committee, no setup to ambush. When Mr. Brooks was transported out of Mohawk and arrived at Marcy, Officer Kessler was called up to the administration building to help get him out of the van. Officer Kessler refused not once, but 3 times. That alone tells you there was no welcoming committee waiting to hurt anybody. He didn't want to go because he didn't want to have to solve Mohawk's problem again. But the Mohawk officers were having trouble. Mr. Brooks was refusing to get out of the van. He was being difficult. The Mohawk officer himself described him as an asshole. So Officer Kessler finally agreed to help, along with Officers Kiefer and Anselo. Remember, at this point, it was Mohawk's responsibility to transport him into the facility and into the infirmary. That's procedure. The Marcy officers, however, went out to assist, and Mr. Brooks was reluctant and refused to carry his bags. Officer Kessler was able to convince him to get out of the van, and he carried one of Mr. Brooks' bags to move things along. And all the officers escorted Mr. Brooks into the facility. Once inside, Mr. Brooks again didn't want to carry his property. Officer Kessler tried to convince him otherwise, to no avail, so they left it behind in the lobby. While escorting Mr. Brooks into the facility, they went through the first sally port and into the vestibule area. Brooks was unshackled by the Mohawk officer. At that point, his hands and legs were free, and he had not yet been searched. And that's the most dangerous moment for an officer, when you're face-to-face with an unrestrained inmate you don't know, who hasn't been searched, and who's acting unpredictably. An order was given for Mr. Brooks to put his hands deep in his pockets. That's a safety order. It prevents sudden movements or swings, and he didn't comply. The order was given again, and again, he didn't comply. It was at this time Officer Walrath suddenly ran forward and put Mr. Brooks in what can only be described as a UFC-style chokehold, a violent maneuver with tremendous force. He lifted up and sank down on Mr. Brooks' neck, sustaining that pressure, and eventually slammed him.
All right, you guys, so I just linked in the chat an article from the Rome Sentinel, who's been doing a lot of coverage on this case. They're a local outlet in New York, but they're doing really, really great coverage. It's an older article that has the multiple videos of this incident from the different cameras of several different officers. So if you haven't seen the video, or if you haven't seen it from different angles, that is a great resource. Rome Sentinel does paywall some content, but I do not believe this article is paywalled. I got in with no problem, and I've looked at it before. So I think they just don't have the paywall toggled for this resource. So hopefully that's a good resource if you guys want to see the videos, if you aren't familiar with what this is about, and what you're questioning. Like, everyone in the chat is like, no, it was brutal. The video speaks for itself. Videos are right there. So, also, YP's highlighting the UFC style. Oh, wow. Do you guys think that highlighting that, again, this is a defense attorney. Do you guys think that highlighting like UFC style here is helpful or hurtful to emphasize here? I'm not sure. Does UFC like, oh, UFC, it's supposed to be safe? Or do you look at it as UFC, well, only professionals do that, and it's only professionals doing that for a reason? So I don't know. I don't know. Choice of words can go either way.
Against the wall, face first. It's impossible to know exactly why Officer Walrath did it. Maybe he thought Mr. Brooks was going to resist. Maybe he saw a movement he didn't like. Maybe he was frustrated. We don't know. But what we do know is that David Kingsley wasn't even there. He didn't see it. He didn't plan it. Officer Kessler said that after the chokehold, someone yelled for it to stop, and the officer stopped. He said that after that moment, he thought it was over, that he was surprised by Officer Walrath's action, that he didn't see it coming, and that during this he reacted by giving several colonial strikes to Mr. Brooks' legs. And in an effort to gain control and compliance, the reality is he did not know why Walrath did this. But in that moment, he relied on his fellow officer. And that's what he was doing. It was for that purpose, to make sure everybody was safe. We also know that there was no plan for this to happen, and no thought that the use of force was going to continue at this point. In Kessler's mind, as he stated, it was all over. After the vestibule, the Mohawk officer turned and left. Officer Kessler, Kiefer, and Anzalone escorted Mr. Brooks outside through the cellar port, the man trap with the two heavy doors. It was at this time Mr. Brooks went limp. The officers believed he was being non-compliant, using a passive resistance tactic that's all too common in prison. Officers Kessler explained this. Inmates go limp to make it hard to move them, or to put officers in vulnerable positions where they can be kicked or struck. They didn't think Mr. Brooks was in distress, despite seeing Officer Walrath's vicious chokehold or considering the damage it may have caused. We, however, now know his going limp was the first sign of distress. Officer Kessler stated that it took several attempts, but they eventually got Mr. Brooks back to his feet. There was no use of force at that moment, but it seems like a pivotal moment in time. Once they continue and exit the second gate, Officer Kiefer ordered them to put Mr. Brooks on the ground. He went to his knees, then his stomach. And Officer Kiefer then told the other officers to stand back, and he deployed a short burst of pepper spray towards Mr. Brooks' head and neck. Kessler stated he did not know what Officer Kiefer was going to do until he told them. An act that admittedly would not cause physical injury, let alone serious physical injury, but maybe some discomfort and irritation. Immediately after this, Officer Kiefer called a red dot, a facility-wide emergency. After all this, Officer Kessler told you again he thought it was over, that the use of force was over, and they would continue to the infirmary. There was no plan, no ongoing conspiracy, no accomplices, no welcoming committee. Each event was its own, separated in time, cause, intention, and purpose. Now when a red dot is called, every available officer must respond, even if it's canceled. They go to the scene to ensure no one is hurt and no further help is needed. And that's exactly what David Kingsley did. He wasn't...
All right, so just for context here, this attorney is the attorney for Kingsley. So now he's making this argument, look, it was the other guy, was it Trombley that did, or Walrath? Christopher Walrath. He's the guy that does the UFC style chokehold, not my client. My client was there for a different purpose, and you should consider his circumstances independent of what other officers may have been doing. Because my client had to respond. Policy is when there's a call, everybody that's on duty has to go and respond to this area. That's why my client was over there with this huge group of people. Not because he was trying to assault somebody. So, I mean, I think this is what he has to work with, right? And then, well, I had one more thing and I lost my train of thought. I lost my train of thought completely. I can slow it down if you want, Brooklyn. Something about him showing up and oh yeah, the reason I wanted to pause is because, guys, if you haven't seen this video, it's like literally a crowd of people, a crowd of these corrections officers around this guy. He's expended, and they're wailing, they're pummeling the guy, to use language from the Courtney Clenney Motions. And apparently they're supposed to all be there. This crowd grows to like 20 people inside the room and in the immediate hallway right outside the doorway, because that's how many people they have on duty and they all have to respond. And as a side thought, I'm thinking about Fulton County, I'm thinking about Rice Street, and how when something goes on in Rice Street, there's like 4 people working total. So that's an interesting contrast. And also very interesting that in this situation, having more people on duty did not result in a safer environment for the inmates. So just some food for thought there. Brooklyn, we can slow it down.
Called to hurt anybody.
There we go.
He was responding to the sound of an emergency. The sound that tells every officer that somebody might be in danger. And while en route, Sergeant Trombley had already arrived and called off the red dot. At that time, even Sergeant Trombley thought it was over, that they were good to move on with the search and exam. But as every officer will do when a response is called off, they assist. They will continue to that location. And when David Kingsley arrived, he did not know what happened in the administration building, the Sally Port, or outside its gate, nor did he see any injuries on Mr. Brooks. It was just another day at the facility. He decided to follow Officers Kessler and Anzalone, who each had Mr. Brooks by the arms. When he saw Mr. Brooks begin to slow down, maybe going limp, likely in distress from Walrath's chokehold, Kingsley did what made sense. He picked up Mr. Brooks' legs to help. That's not violence. He wasn't slamming him, hitting him, or dragging him to punish him. He was helping to move him into the infirmary so the process could continue. The required search, exam, and photographs. This wasn't aggression. This wasn't a committee to welcome Mr. Brooks. It was following procedure. Once inside the infirmary, the officers moved into a different phase of the process. This isn't a use of force anymore. It's policy. Every incarcerated individual involved in an incident must be searched for contraband, medically evaluated, and photographed before they can be cleared. That's not optional. It's Department of Corrections policy. And as the search begins, officers follow standard procedure. And that said, when an individual refuses to open his mouth or to comply during the search, it becomes a legitimate safety concern. Remember, both Sergeant Sayal and Assistant Commissioner Marticello testified that contraband and drugs are hidden everywhere in prisons, in clothing, in the body, even in the mouth. They also told you how important it is to check for hidden weapons, drugs, or items that could be swallowed or used against officers. That's the environment these men work in every day. And that's when Officer Farina steps in. He moves in to check Mr. Brooks' mouth. Not to hurt him, but to make sure there's no hidden contraband or obstruction, and possibly to wipe away blood or pepper spray. You'll see a cloth in his hand. The district attorney wants you to believe that cloth was used to try and gag Mr. Brooks, but that's simply not true, and it's illogical. Look at the video. You'll see Farina wiping. He's performing a standard, lawful, and necessary part of the search process. Suddenly, Mr. Brooks bites down, hard, on Officer Farina's finger. He didn't hurt his finger by punching him, as Sergeant Trombley tried to imply. He even heard somebody say, "Got bit." And in that instant, Farina reacts. Officer Kessler describes those punches, once in the face and several others striking Mr. Brooks viciously in the throat. Violent, forceful, uncontrolled punches that nobody in that room knew were coming and impossible to stop. As quickly as it happened, it ended. It's not policy. It is excessive. It's a spontaneous reaction to sudden pain and frustration. Put in context, being bitten or exposed to blood in a state prison isn't the same as it would be out here. Officers know what that can mean, and it happens all the time. Exposure to hepatitis, HIV, AIDS, or other life-changing infections is always a concern. They know the long, uncertain process that follows: testing, medication, and the waiting. That's the kind of panic that drives a reaction like this. Now, where's Officer Kingsley during all this? Right next to Officer Farina, steadying Mr. Brooks' neck and head so the search can be completed. He's not choking him. He has his fists on both sides of the head under his jaw. His fingers are not wrapped around his neck. He's not restraining him to cause pain or obstruct his airway. He's doing what officers are trained to do: control movement in close quarters, try to steady the head and open the mouth. And when Officer Farina starts throwing those punches, Kingsley releases. He shifts, adjusts, and tries to manage the chaos. At no point does he strike Mr. Brooks. He doesn't punch, he doesn't kick, he doesn't act out of anger. Nothing shows David Kingsley is taking any pleasure in what's happening. He's calm, focused, doing his job in the middle of chaos he didn't create. That's not depraved indifference. That's not malice. That's a correctional officer trying to do his job in an impossible place. After Officer Farina punches, the room is tense, but not loud. Even though there's no audio on the video, you can see that most of the officers are not shouting or even speaking. They're moving with purpose. It's not a frenzy. They're trying to regain order and get Mr. Brooks into position because he keeps sliding down the gurney. Multiple officers try to assist, to search, examine, and so photographs can continue. There is no ill intent, as suggested. It's in that moment that David Kingsley does what you'll see on the video. He reaches down, takes hold of Mr. Brooks, and lifts him up in a seated position on the end of the gurney. In slow motion, or when it's paused at just the right time, it looks harsh, kind of like the gagging accusation. It is simply not accurate or true. You need to remember, this took place in a matter of seconds. A screenshot taken in a moment of time does not show intent or indifference to life. This isn't a deliberate hold or a violent act, like we learned when Walrath was in the vestibule. It's a reflexive, reactionary movement, an instinct to get Mr. Brooks upright and steady. David Kingsley isn't striking him, he isn't yelling or showing aggression. He's doing what he's trained to do, trying to keep control of the situation and trying to position Mr. Brooks for the next step in the process. The prosecution wants you to see depravity in those few seconds, but depraved indifference means something else entirely. It means utter disregard for human life, cruelty for its own sake. And that's not what this is. This is a split-second human reaction in a room full of correctional officers trying to do their job. And then what happens? Moments later, you see Mr. Brooks sitting upright at the end of the gurney, speaking with Sergeant Trombley. As Trombley stated, Mr. Brooks was mumbling, not making sense. The officers have stepped back. The tension has calmed. The use of force is over. Sergeant Trombley has control of the room. He's getting the paperwork ready, the questionnaire, the photo sheets. The process can move forward, and once again, the officers believe the incident is over. This was an opportunity for Sergeant Trombley to regain the control he claimed to have lost. A sergeant with years of experience being the boss, A sergeant who we can assume was well respected by other sergeants and correctional officers. Somebody who was known to take control and give orders, as he did after this incident. So what does Sergeant Trombley do? He orders Officer Kingsley and Anzalone to bring Mr. Brooks to the mat, to the corner. And after this order, Trombley somehow loses control and can't give any more orders. His mouth, for some reason, no longer works. He just blames Sergeant Mashaw. And when Mr. Brooks is brought to that corner, Kingsley and Anzalone take their position as they are trained to do. What you're seeing isn't violence by David Kingsley. It's procedure. It's the officer doing exactly what they've been taught, step by step, to maintain safety for everyone in that room. Bring him to the corner, get the cuffs off, secure his arms, get hands high on the wall. Another officer will follow. Sergeant Trombley fails to give an order for somebody to assist. The third officer, who is responsible to place themselves behind the incarcerated individual to help assist in removing shackles and clothing. At this time, it's important to separate what each officer does. Officer Anzalone and Officer Kingsley are not acting the same way or with the same intent. And that's based on their prior behavior. And you can see the difference clearly on the video. David Kingsley isn't lifting, yanking, or striking. He's beside Mr. Brooks, keeping control of the left side. Maintaining position, trying to keep his hands high on the wall, putting his leg underneath Mr. Brooks to support his weight, as Officer Kessler testified. That's an officer trying to prevent an individual from collapsing, trying to keep the procedure controlled. Two officers trained to keep an individual upright and against the wall looking straight, keeping an eye on his hands and body while other officers handle the strip search. Remember what Officer Kessler said about that procedure. The officers positioned in those corners don't have the luxury of turning around to see what's happening. They can't anticipate what might come next. Their entire focus is on the individual, on those hands, that stance and balance. That's why the sergeant plays such a critical role. The sergeant is the one who's supposed to see the whole picture, to know what's happening in every corner of that room, and to give directions when it's needed. That's how these movements are meant to function. Clear chain of command, clear control, so things like this don't happen. Let's remember what Sergeant Trombley stated to you, that he never directed anybody to assist. That when he saw Mr. Brooks in distress, he did nothing. These words came out of his mouth. It's not my job to remove shackles. Yet, he sat there and tried to convince me that he is sorry for what he did, while trying to blame everybody else. Remember, Sergeant Trombley orchestrated everything after Mr. Brooks left the facility. He crafted all the reports, even going as far as writing Mr. Kingsley's and ordering him to sign it. Then he says, I let him read it. Yet he claims he did not have control. Officer Kingsley is a line officer with the least amount of seniority in that room. All you have to do is count the bars, stripes on all the other officers' arms. Officer Kessler told you at first he thought Mr. Brooks was just being non-compliant, maybe faking it when he went up in the corner, maybe trying to make the process harder. But then something changed. After a couple minutes, Officer Kessler realized this wasn't acting. Mr. Brooks wasn't resisting. He now believed he was in distress. Something was wrong. So he stepped in without being ordered to. He became the third man, but not to control, to help. He urgently tried to remove the leg irons and the shackles without being ordered because it was clear to him that Mr. Brooks needed immediate medical attention. And once he freed the restraints, the officers placed him back on the gurney to begin life-saving efforts. And what you do see during these moments on the video, you see Officer Kingsley with one hand on Mr. Brooks' left wrist and Officer Gallagher on the right. They're not striking, not choking, not holding him down to harm him. They're holding those wrists because they don't know what's happening. And policy requires control of the inmate's hands whenever there is uncertainty about an inmate's condition. They could have thought Mr. Brooks might be overdosing. That maybe before transport he had swallowed drugs or a balloon ruptured. That's why the first step is to administer Narcan. Narcan is designed to reverse an overdose, and it can cause an immediate violent reaction if the person suddenly regains consciousness. That's why those wrist holds are used, not to punish, but to protect everybody in the room.
But this takes me back to, and I said it in the chat, I didn't say it out loud, so if you're just listening, how compelling is the argument that, hey, policy procedures are in place because prisons, these types of facilities, are inherently dangerous places, when the job duty of those that are on trial is to maintain the safety of those in these facilities. I would argue including themselves, sure. But it's kind of like, if you're going to argue that this place is so bad and dangerous, that makes it seem like the job isn't getting done, period, any of the time. Regardless of whether there's a murder on the table or not, we're not keeping this place safe. And now we're veering into arguments of, well, he was given Narcan because it could have been a fentanyl overdose. And during the days of trial that weren't streamed, there was testimony about contraband in the prison. So there was someone that came and testified about the availability of shanks and the different types of shanks and how the inmates can make shanks, and also the availability of drugs like heroin, fentanyl, meth, and they said something about wasp spray. So like insecticide sprays that are used to make some type of contraband drug. But again, that takes me back to the big umbrella argument of like, if the video we have of you doing your job is somebody being beaten, either by this individual and that individual, or it's being watched and not stopped by these individuals over here. And then we're hearing about all of these drugs. Well, we had to do this because the inmate could have, the Narcan could have made him aggressive when he came back to, implying that he was losing consciousness because of a fentanyl overdose. That just takes me to the bigger problem of why is it so accessible in the first place? What do you guys do all day? And this is not a situation like Rice Street where there's no staff. You can't blame this on lack of staffing. Because here the specific issue is we have 24 corrections officers swarming around somebody who ends up being beaten to death and nobody stops it. So how compelling is it to argue this is such a bad place when the people that are supposed to keep it and make it a safe place by following procedures aren't keeping it a safe place? I'm not sure that's helpful. I'm not sure that's helpful. And shout out to Angela Thompson. 11 months is such a long time. Thank you for being a member for so long. Oh, but guys, I mean, this guy's got to defend his client. Got to argue something.
And as the medical examiner testified, there were no external injuries that would have informed the officers what was actually wrong with Mr. Brooks. And it's critically important. There was nothing they could see that revealed the internal trauma. So they reacted to what they thought they were seeing, a possible overdose, a medical crisis, and did exactly what they were trained to do. What happens next is the best evidence of their intent. Because once it became clear that Mr. Brooks was in distress, these officers, including David Kingsley, did not stand back. They lined up to provide CPR. They worked to save him, They performed life-saving measures for minutes on end. This was not some sort of ruse to cover up these actions. And as the testimony showed, Kingsley was the first one in line to provide CPR. You heard a lot about the body cameras in this trial. The district attorney wants you to believe that these officers, including David Kingsley, intentionally didn't turn them on because they wanted to hide what they were doing. But the evidence you actually heard tells a different story. The entire facility rarely used them. Not just these officers on this particular night. Specific to David Kingsley, however, Investigator Cornish testified that the transportation officers are required to pick up their cameras from the camera room right before taking somebody out of the facility, and then return them to their docking station immediately when they get back from the transport. That's the policy. They're not regularly issued an alternate camera when they come back. And Investigator Massot confirmed that. He told you that no alternate camera was ever provided to Kingsley after he returned from transport that day. That's not concealment or being part of some conspiracy. That's procedure. Now, during the medical response, Sergeant Trombley gave an order. He directed the officers to activate their body cameras, and they did. Once that happened, those cameras captured not only the video, but also the audio of what took place next. And that's how you could know what those moments really looked and sounded like. Investigator Massot told you that there was additional body camera footage recorded after that order. Footage that showed the medical response, the CPR, the Narcan, and the efforts to save Mr. Brooks' life. It may have shown officers doing everything they could to help, including David Kingsley, who was the first to perform.
I don't know if the judge was making this face as a passing of the time or in reaction to what's being said here, but look at the judge's face.
It may have shown officers doing everything they could to help, including David Kingsley, who was the first to perform CPR, which you heard directly from Sergeant Trombley. This action destroys the theory of depraved indifference. Those few minutes reveal the truth, that when the officers realized something was wrong, when they understood that Mr. Brooks was in distress, they acted immediately. They did not prevent medical assistance. They worked with urgency to save a man's life. That's not depraved. That's not indifference. That's not murder in the second degree. And that is the heart of this case. When you strip away the speculation, the slow motion replays, the freeze frames that extend time, and the labels that the prosecution wants you to adopt, what you're left with is this. David Kingsley never struck Mr. Brooks. He never kicked him. He never set out to hurt him. He followed his training, trusted his fellow officers, and responded when chaos erupted around him. You did not conspire. He was not an accomplice to others' unforeseen actions. When it mattered most, when Mr. Brooks was in distress, he tried to save him. The medical examiner couldn't say that anything David Kingsley, the medical examiner couldn't say that anything David Kingsley did caused or contributed to Mr. Brooks' death. All she could do was describe his injuries from multiple incidences, including Mohawk, and explain toxicology results that indicated the presence of K2, a drug that can cause many different behaviors and health issues. That alone creates reasonable doubt. And as Officer Kessler said again and again, after each incident, I thought it was over. After the vestibule, after the cell report, after the pepper spray, and after Officer Farina's punches, I thought it was over. Each moment was its own. Separate, distinct, and unplanned. That does not create a conspiracy, a welcoming committee, or an accomplice. And remember this, just because correctional officers wear the same uniform doesn't mean they're part of the same gang. It doesn't mean they have the same motivations, the same knowledge, or the same intent. Just because one officer saw or witnessed something, it does not travel to officers who are in the hallway or in a different room. The acts of some, even those that look violent on video, do not make everyone in that room equally culpable or prove that they are acting together with the same purpose. The law demands that you judge each man individually. And when you do that, you'll see David Kingsley for who he is, a correctional officer who responded to chaos, followed orders, and tried to save a life. Now, the second charge in this case, manslaughter in the first degree, asks whether David Kingsley intended to cause serious physical injury, and in doing so caused the death of Mr. Brooks. But nothing in this record, not one word, not one frame of video, not one piece of testimony shows that intent. There is no evidence that he wanted to hurt anyone. There is no evidence that he set out to cause serious injury. There is no evidence that he caused injury. From start to finish, his actions show only an intent to control and to stabilize. And that's not intent. That's training, duty, and decisions being made under immense pressure. You may believe, as human beings, that mistakes were made that day. You may wish something had been done differently. But these feelings don't make a crime. Under the law, David Kingsley is not guilty of murder in the second degree, nor is he guilty of manslaughter in the first degree. Maybe you think he could have done more, moved faster, or spoken up sooner, but the law doesn't punish imperfection. It punishes intent and indifference, and those simply are not present here. Thank you.
Thank you, Mr. Nibush. Mr. Hildebrand.
So I think this whole, and Nick hits the nail on the head here. He says, this is so ironic after the kitchen sink Rico we spent half a year watching. Yeah. Because the prosecution's argument here is all of the officers charged here were acting as a gang. We just heard the attorney for Kingsley say, not a gang, not a conspiratorial effort. It wasn't some group acting together in unison. These are individuals, and if you take it piece by piece, sure, different individuals were acting criminally. But my client was following policy and blah, 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 right? Not a gang, not a gang. It's just interesting to watch it in this perspective where now we're watching employees of the state on trial for abuses in the prison system, right? We're kind of watching like government prosecute government workers who are following policy of that facility. Very interesting. So now we're going to get another attorney up. I don't know who it will be yet. Maybe they'll update the banner or help us. I think it's hard. It's got to be hard to sit in court and listen to all of this. I'd be chewing the gum like that too. I'd be like, Sheriff Chuck says they were all wearing the same color, right? That's a gang in Georgia. They got the signs and symbols.
Good morning, folks. And Your Honor, good morning, and counsel. I'm going to make use of the video and the television behind me so I can show you some of what I'm going to explain to you as part of my summation. Because I think with the that the evidence that you see is critical. Before I do that though, let me begin by thanking you, and I mean that sincerely. Thank you. You've been apart from your families and your jobs, your normal lives for over a week now, not just physically, but you've been asked to keep secrets from people, and that's not easy to do. You had to be careful about what you watch online, right? Or what popped into your internet feed. You had to be careful about that. And I'm sure that you were. And you've been asked to do that in as difficult and public a subject as a jury might ever see. There's a camera pointing at me. There's a courtroom full of people. And you didn't pick any of that. We did. We picked you. And we understand and appreciate you. And we thank you. I thank you. Matthew Gallagher thanks you.
Okay, yeah, this is
Now,
Gallagher's attorney.
before we start talking about what the evidence...
Gallagher is the one who handcuffed Brooks. That's, I mean, there's more to it, right? But that's just how I remember the who's who.
shows, I want to take a moment and remind you of something very simple. Something that sometimes gets lost in the noise of the courtroom.
Okay, wait, never mind. Did he not just say it was Gallagher? Because the banner says Nicholas Kiefer. All right, I guess scratch everything I just said.
This process is not about which side has the most witnesses or the most exhibits or takes the longest to present their case.
Oh, they changed it.
This case is also not about who has the best graphics or whose IT people could put together the coolest presentations. It's not about that.
Not the PowerPoint.
It's also not about which witnesses or lawyers that you like or you dislike, or what lawyers made you laugh, or who seems serious. And it cannot be about emotion. It cannot be about emotion, your deliberations. Emotion from the lawyers or emotion from what you feel cannot be part of your considerations. The judge will tell you that. And I know you understand that. And I know that you'll do your job because you've been as attentive as any jury that I've ever stood before.
Say that to all the juries.
Your decisions are about the evidence. It's about proof, and it's about the government with all its power and all its resources has met its very heavy burden to prove Matthew Gallagher guilty beyond a reasonable doubt for 3 crimes: murder, manslaughter, and gang assault. And critical to every one of those is what was Matthew Gallagher's mental state on December 9th. The judge will explain that to you at the end. The government must prove beyond a reasonable doubt that Matthew Gallagher's intent, by any action that you see of him, was for Robert Brooks to be seriously injured or injured, and that he intended, it was Matthew Gallagher's intent to harm Robert Brooks. Within each of the jury charges you'll hear from Judge Bauer, your core consideration is this: what was Matthew Gallagher's mental state? What was his intent? Was he, by his actions, acting with what the law requires be proven, wickedness and evil? Was he intending himself to injure Robert Brooks, or to help others because he wanted them to injure Robert Brooks? Matt's actions and his mental state when he acted are the core, the very core of what you will need to decide. And as you examine the evidence to determine Matt's mental state, it is critical to look at what Matt understood as events were unfolding and examine the decisions Matt had to make in circumstances he came upon involving Robert Brooks. These were circumstances that Matthew Gallagher did not create, that his decisions were without guidance from his sergeants, and in the roughly 45 seconds that Matthew Gallagher was in the medical room before he was sent off by Sergeant Trombley to get the shackles, did the government prove to your satisfaction beyond a reasonable doubt that during that time Matthew Gallagher's intent was to injure Robert Brooks? That in those 45 seconds did Matthew have a mental state that convinces you that he is trying, intending, to injure Robert Brooks. I will try my very best to show you Matt Gallagher's mental state shortly. You will see it on the videos. Ask yourself as you deliberate, for what reason would Matthew Gallagher have the intent or the goal to harm or injure Robert Brooks? Matthew Gallagher had never spoken to Robert Brooks. Robert Brooks had caused Matthew Gallagher no harm, no disrespect. Matthew Gallagher had never even given Robert Brooks an order or spoken to him, and Robert Brooks had never refused an order from Matthew Gallagher. Matthew Gallagher did not strike Robert Brooks at all. If his intent was to injure Robert Brooks, would he not strike Robert Brooks when he had an opportunity? Your analysis is not about whether Matthew Gallagher made decisions that you think should have been made differently. None of you have faced those circumstances that he was in, or whether his decisions were not perfect. It is whether in Matt's decisions he intended to injure Robert Brooks and not that he just made imperfect decisions. The question for you to decide will be whether the government has proven beyond a reasonable doubt that it was Matt Gallagher's intent, his goal to injure Robert Brooks, and the answer to the proof shows it was never his intent. When Matt Gallagher stepped just inside the medical room at roughly 9:25 and 13 seconds p.m., 9:25, he knew nothing whatsoever about Robert Brooks. He wasn't present when Robert Brooks was beaten by Mohawk inmates on December 7th, December 8th, and December 9th, struck by multiple inmates. He did not know that. Matthew Gallagher wasn't present shortly after 9:07 p.m. in the Marcy Administration Building when CO Walrath snapped and attacked Robert Brooks, leaving Robert Brooks' blood on the administrative building's concrete wall, and it put Robert Brooks in a headlock, which Officer Kessler described as yanking and choking him and pulling him up by the neck.
So this is the second defense attorney we're watching do closing arguments, and both are saying that Walrath is the one with blood on his hands, not their clients, respectively.
Matthew Gallagher wasn't present, and he didn't know about that. He wasn't present when Officer Kessler testified that he piled on Robert Brooks and repeatedly struck Robert Brooks himself. Matthew Gallagher wasn't there. Matthew Gallagher wasn't present when multiple officers had to pull Walrath off Robert Brooks in the administration building. He wasn't present when Robert Brooks went down on the concrete walkway outside the administration building at 9:20 p.m. Nor was Matthew Gallagher present when Kessler punched Robert Brooks twice while he was escorting Robert Brooks to the infirmary. When Robert Brooks was brought through the lobby of the infirmary building, injured, at 9:22 p.m., Matthew Gallagher was outside parking his van and could see nothing about how Robert Brooks was carried into the building or his physical condition. Matthew Gallagher was not in the medical room from 9:22:44 to 9:25:12, 30 seconds, when Kessler and Walrath and Anzalone were in the medical room alone with Robert Brooks, where you get a glimpse of how they were already on top of Robert Brooks from CO named Along, his body-worn camera. You will be able to see a small sample of that, a brief sample from Along's body camera recording into the medical unit, but Matthew Gallagher did not see that. He wasn't present. At that exact time, Matthew Gallagher was just entering the infirmary building, from the outside parking lot, after having parked his van. When Matthew Gallagher was standing out in the hallway, not knowing any of what had happened, from 9:23:06 to 9:24:55, that's how long he was standing out there. He could not see into the medical room. And we do not know what Anzalone, Kessler, Farina, and Walrath were doing to Robert Brooks. From 9:26 until 9:26:37, when Farina and Walrath lost it a second time in the medical room and struck Robert Brooks in front of Sergeant Trombley and Sergeant Mashaw. Matthew Gallagher was not present because he had been sent by Trombley to get shackles from his van. Matthew Gallagher was not present for any of that conduct I just described. 5 different times at Marcy and 3 times at Mohawk where Robert Brooks was assaulted. Matthew Gallagher didn't see it and didn't know about it. The government's allegation is that Matt Gallagher is responsible for the murder, manslaughter, and gang assault of Robert Brooks. That the government has to prove that Matthew Gallagher had the intent to cause Robert Brooks injuries, that Matthew Gallagher was wicked and depraved and inhuman. For stepping forward in the medical room at 9/25/13, when the officers who had assaulted Robert Brooks were unable to move Robert Brooks onto the medical gurney, and Matthew Gallagher pulled him up onto the medical gurney. And then they alleged to support those offenses at 9/26/37 for putting on leg shackles on Robert Brooks. That was his intent, Matthew Gallagher's intent, to harm and injure Robert Brooks, and that was depravity, wickedness, and inhumane. That's what they alleged. And that not himself, Matthew Gallagher, calling for medical help before Sergeant Tremblay did at about 9:29 p.m., that also constituted inhumane wickedness and intent to injure by Matthew Gallagher. The government must prove beyond a reasonable doubt but that by those 3 decisions, Matthew Gallagher intended, it was his goal, to cause Robert Brooks injury, or that his actions showed Matthew to be wicked and inhumane, and he did so. Anzalone, Walrath, Kessler, Farina. You saw that they caused Robert Brooks' death. They acted irrationally and without notice. But the heavy finger of the government is pointing this last week at Matthew Gallagher, saying he intended to cause Robert Brooks' death, that he is wicked and inhuman, and that he intended to cause physical injury to Robert Brooks. You were promised much in the government's opening statement to you, and you expected to be shown evidence of reprehensible actions by Matthew Gallagher. You were promised that by both the tone and the substance of the opening statements. These were promises to you, and you would have been reasonable jurors to have expected the government to follow up on those promises. 1, the prosecutor told you repeatedly at the start that they was said 10 times, they killed Robert Brooks. He told you he would prove Robert Brooks' death was quote, a carefully orchestrated act, close quote. And Matt Gallagher, quote, treated Robert Brooks with depravity. I can imagine what you expected to see. Blows raining down by Matt Gallagher on Robert Brooks as part of the, quote, orchestrated act or a planned meeting to create an orchestrated act. And what was then shown to you by way of evidence to support that promise, that Matthew Gallagher never struck Robert Brooks. And it was never shown even to try to injure Robert Brooks. Matthew Gallagher walked into a situation in the medical room at 9:24:55 p.m. that he did not create.
So I think the catch-22 for this specific client, this is just my own thought, is, again, we're kind of making a dual argument. He came into the middle of it, he didn't do anything, but he's also the guy that shackled, that put handcuffs on Brooks. And to me, that's a pretty big deal. It's a pretty big deal. Because what made you come in there and decide to put handcuffs on somebody if none of the officers who were already there didn't handcuff him already. You walk into this chaotic situation and the other officers are so bad and they have intent at this point. They're acting irrationally. They're doing their own thing that doesn't involve my client. But then my client also says, we're going to come in and shackle the victim. It's not, to me, you can't reconcile those two things.
He orchestrated nothing. All the conduct that was promised you, that they would prove to you that Matt Gallagher did, was done by others. Anzalone, Farina, Kessler, Walrat. None of it was done by Matthew Gallagher. Second, you were told in the opening that the government witnesses were to show you that Matt Gallagher was part of a gang. Remember how it was said, a gang! You heard that several times. 3 times. What gang did they show you that he was part of? Sergeant Tromley told you that these CO employees were not even friends. They don't hang out. They are co-workers. They're owned by DOCCS. DOCCS tells them how to dress. DOCCS tells them how to act. They're owned by DOCCS. They go to work in a horrible setting, and they're not buddies. They're co-workers. They're not a gang. They work shifts on different days, double shifts, triple shifts. There were 204 employees.
Again, this is me being nitpicky, but why would you make an argument? They didn't even work at the same time, but then they were working triple shifts. And there was an issue with a union worker strike in New York State with the Department of Corrections statewide. And one of the key grievances was, look, they're working these long shifts. They're doing doubles, sometimes triples, and they're supposedly not allowed to be relieved from their duties. Secondary issue, and without turning this into a side story rant, a lot of those worker strikes seem to have increased after the Robert Brooks incident, and there were some criticisms that perhaps this worker strike is growing, not necessarily in a protest for the stated grievances of, these double and triple shifts that people are working, but rather, and more silently, not being stated explicitly, in a reaction as a protest to the choice to prosecute and or suspend without pay the officers involved in this indictment, right? So did the workers' strike build in momentum coincidentally after this just because more people wanted to join in on the stated grievances, or did it grow in momentum to stand in solidarity with those that were being forced to resign or being suspended without pay and or were indicted in relation to this incident? And after that started to kind of spiral out of control, right? This protest got huge and it was affecting multiple facilities across New York State. There were reports from individuals who were communicating with their loved ones who were incarcerated, saying like, look, they're not even being fed. They're not being given their medications that they're supposed to take daily. Some facilities didn't have heat. And really the worker strike had huge ramifications for the individuals that were incarcerated during that time period. So big context there surrounding that. And I'm not really sure the argument that, oh, they weren't buddies, they barely even ran into each other, even though they were working triples. How do you not run into somebody? How do you not work the same shift as somebody if you're also arguing that everybody was working double and triple shifts? Kind of fails as an argument to me. So yeah, created by EJF says the same thing. That says the CEOs I know or knew were big fans of the overtime. I had some friends that were nothing related to this. This was in the Rochester area, that the work, it paid well. And, their take on it would be, I'm working a lot, but it's nice. I know why I'm working a lot. So.
He's in that prison that day because there were 204 cameras that had been used, and COs don't know who they would be placed with on any shift. They don't plan or orchestrate anything together. There was no meeting beforehand or plan, and it certainly was not a gang. And Matt Gallagher was not part of any group. He's an employee. At 9/25/47, Matt Gallagher individually, as a DOCCS employee, tried to pull Robert Brooks onto a medical gurney. Shortly thereafter, he was told to fetch leg shackles because his work supervisor told him to do so. They could be put on ankles of Robert Brooks. Where is the gang in that? Isn't that a man doing his job? Third, you were also promised at the outset that the government would bring forth evidence that Matt Gallagher had intent to cause Robert Brooks physical injury. That there was a plan that
Oh, they want us to go to Dolly.
Yeah, we just started.
YouTube just took us to Dolly. So I didn't know that feed ended for real.
or whether his decisions were not perfect. It is whether in
So we still have some time to cover, but it looks like this feed conks out. So we'll have to jump around and see.
Matt's decisions, he intended to injure Robert Brooks, and not that he just made imperfect decisions. The question for you to decide will be whether the government has proven beyond a reasonable doubt that it was Matt Gallagher's intent, his goal to injure Robert Brooks, and the answer to the proof shows it was never his intent. When Matt Gallagher stepped just inside the medical room at roughly 9:25 and 13 seconds p.m., 9:25, he knew nothing whatsoever about Robert Brooks.
They delayed the
He wasn't
trial.
present when Robert Brooks was being...
Chat, let me see if this is a current article. Guys, Courtney Clenney's trial's delayed again. Oh, sorry for the brash interruption there. Let's see. The murder trial of Instagram model Courtney Clenney, accused of stabbing her boyfriend to death, the trial's delayed again. The prosecutors rejected claims that the state is drawing out the case. Prosecutor Sean Abahoff telling the judge the defense filed motions to suppress evidence, reconsider her bond, to dismiss the case. He added that Courtney Clenney's attorneys don't have any new evidence and that she's not a flight risk or dangerous. The hearing to reconsider bond is set for November 4th. All right, so let's see if there's stream for this, a court feed for another. This will be the third bond hearing, guys. So we'll get together for that. And the December 1st trial date is postponed. Clenney maintains that she threw a knife at 27-year-old Christian Obumseli in self-defense. Her attorney, Frank Prieto, spelled wrong, is also using battered spouse syndrome as a defense. The state alleges she plunged a knife into the chest of her cryptocurrency trader boyfriend in 2022. Meanwhile, Clenney continues to be held without bond on a second-degree murder charge. She just sold a $1.3 million home. Did it sell or is it in foreclosure? So we'll have to take a look at that. And that's it. That was a quick little article there. That is the only article I see. It's from WFLA Orlando. Let me refresh NBC6 real quick. Because that is, I really love Christian Cologne's coverage. Yeah, so for Courtney Clenney, they don't have an article from today coming up in search results for NBC6, but I'll keep checking. They usually give really good context. But yeah, there's a little interlude there. So November 4th, you guys, for Courtney Clenney. Bond hearing, round 3. I keep promising you guys that we're going to watch the initial bond hearing from November of 2022. I wanted to watch that like the week before the trial start date as a primer. We'll have to work it in somehow, some way eventually. But November 4th, I would imagine that the court TV, they're going to want to be present for a bond hearing, a formal bond hearing. So November 4th for that, you guys. Let's continue with this feed over here. The defense closing arguments. Again, there's 3 individuals on trial for this trial. Others took pleas. 1 other is severed and awaiting trial in January. Sheriff Chuck says she's gonna serve, this is really true. She's gonna serve a Fulton County conviction. They put you in jail and take so long for a trial, you get time served if convicted. If found not guilty, still time served. Oh boy. Oh boy. And factual lie with the update on the Kelsey Fitzsimmons Supreme Court appeal. Denied. So Tay-Biz with the update on and Tay-Biz, I mentioned in the chat, you guys, that Tay-Biz is covering a lot of the Mickey Steins stuff. Also shared an interview he's going to be published. It's not a live stream, but he's publishing. It looks like a premiere where there'll still be the chat feature. He's doing an interview where we're going to hear some of the tea on Judge Mullins. So Mickey Steins is the sheriff in Letcher County, Kentucky, shoots Judge Mullins in chambers. I think the case is so widely known because it kind of a shocking video, right? Just someone kind of point blank walking into chambers where they should know there's cameras. So started the virality of that case. He's done great coverage, and now we're going to hear a little bit more about Judge Mullins, who gave somebody a $35,000 bond, but that individual has been on the run ever since. So we've talked about that, but I think you've also talked about the Mark Sanchez case. So if you guys are looking to stay up to date on what's going on with that, yesterday, like the judge kind of seemingly suddenly recused herself. But Mark Sanchez pretrial hearing has been pushed back to December 5th, and jury trial is the 11th. So even though that's delayed, that's still around the corner, it feels like, at least for now. At least for now. So lots of stuff there. And then let's see. And then, yeah, so good context here from For Always, Forever, for Life is Courtney wouldn't really have time served because, you know, if the jury finds that she is guilty, in Florida, you've got this aggravating factor that she used the knife, right? So I don't think her 3 years so far would be time served. I think that would be well below the minimums that she would be facing if convicted of the second-degree murder with the knife. So good context there. Yeah, let's get back into this New York DOCCS. He's calling it DOCCS. They've been calling it DOCCS. They're not talking about doxing somebody. It's just the acronym for the Department of Corrections.
Beaten by Mohawk inmates on December 7th, December 8th, and December 9th. Struck by multiple inmates. He did not know that. Matthew Gallagher wasn't present shortly after 9:07 p.m. in the Marcy Administration Building when C.O. Walrath snapped and attacked Robert Brooks, leaving Robert Brooks' blood on the administrative building's concrete wall, and it put Robert Brooks in a headlock, which Officer Kessler described as yanking and choking him and pulling him up by the neck. Matthew Gallagher wasn't present, and he didn't know about that. He wasn't present when Officer Kessler testified that he piled on Robert Brooks and repeatedly struck Robert Brooks himself. Matthew Gallagher wasn't there. Matthew Gallagher wasn't present when multiple officers had to pull Walrath off Robert Brooks in the administration building.
I'm sorry to be a Pawsy McPawserton, but the article we just read said November 4th, right? So I want to, in case you're popping out of here after the Courtney Clenney update, maybe this is a typo. Well, let's look at the dates. Is that maybe November 4th is like a Saturday and we can... Nope. So November 5th would be a Wednesday. The 4th would be a Tuesday. I'm kind of inclined to think that maybe it's the 5th, that they meant Wednesday, if they're setting it, you know, they like Wednesday days in this court. But we have the article, which presumably they heard something orally. And then we have the docket, and there's been things that have been corrected on here. So either the 4th or the 5th for the Courtney Clenney bond hearing. And they're going to hear these other motions as well. Plea is now set for also November 5th. And then they're granting the motion to compel, but we won't know what that order says. Remember, that motion to compel was just to get the state to disclose earlier than 10 days that they're going to rely on these specific past crimes, past wrongdoings at trial, right? And put the defense on notice. So that was granted. And I think this motion for continuance was probably from the state that we see granted at stipulation. So There we go. So keep your calendar, mark your calendars for the 4th and or 5th. We'll figure out what day is going to be this new bond hearing, you guys. And then back to our regularly scheduled program.
He wasn't present when Robert Brooks went down on the concrete walkway outside the administration building at 9:20 p.m. Nor was Matthew Gallagher present when Kessler punched Robert Brooks twice while he was escorting Robert Brooks to the infirmary. When Robert Brooks was brought through the lobby of the infirmary building, injured, at 9:22 p.m., Matthew Gallagher was outside parking his van and could see nothing about how Robert Brooks was carried into the building or his physical condition. Matthew Gallagher was not in the medical room from 9:22:44 to 9:25:12, 30 seconds, when Kessler and Walrath and Anzalone were in the medical room alone with Robert Brooks, where you get a glimpse of how they were already on top of Robert Brooks from CO named Along, his body-worn camera. You will be able to see a small sample of that, a brief sample from Along's body camera recording into the medical unit, but Matthew Gallagher did not see that. He wasn't present. At that exact time, Matthew Gallagher was just entering the infirmary building, from the outside parking lot, after having parked his van. When Matthew Gallagher was standing out in the hallway, not knowing any of what had happened, from 9:23:06 to 9:24:55, that's how long he was standing out there. He could not see into the medical room. And we do not know what Anzalone, Kessler, Farina, and Walrath were doing to Robert Brooks. From 9:26 until 9:26:37, when Farina and Walrath lost it a second time in the medical room and struck Robert Brooks in front of Sergeant Trombley and Sergeant Mashaw. Matthew Gallagher was not present because he had been sent by Trombley to get shackles from his van. Matthew Gallagher was not present for any of that conduct I just described. 5 different times at Marcy and 3 times at Mohawk where Robert Brooks was assaulted. Matthew Gallagher didn't see it and didn't know about it. The government's allegation is that Matthew Gallagher is responsible for the murder, manslaughter, and gang assault of Robert Brooks. That the government has to prove that Matthew Gallagher had the intent to cause Robert Brooks injuries, that Matthew Gallagher was wicked and depraved and inhuman. For stepping forward in the medical room at 9:25:13, when the officers who had assaulted Robert Brooks were unable to move Robert Brooks onto the medical gurney, and Matthew Gallagher pulled him up onto the medical gurney. And then they alleged to support those offenses at 9:26:37 for putting on leg shackles on Robert Brooks. That was his intent, Matthew Gallagher's intent, to harm and injure Robert Brooks. And that was depravity, wickedness, and inhumane. That's what they allege. And that not himself, Matthew Gallagher, calling for medical help before Sergeant Tremblay did at about 9:29 p.m., that also constituted inhumane wickedness and intent to injure by Matthew Gallagher. The government must prove beyond a reasonable doubt that by those 3 decisions, Matthew Gallagher intended, it was his goal, to cause Robert Brooks injury, or that his actions showed Matthew to be wicked and humane, and he did so. Anzalone, Walrath, Kessler, Farina. You saw that they caused Robert Brooks' death. They acted irrationally and without notice. But the heavy finger of the government is pointing this last week at Matthew Gallagher, saying he intended to cause Robert Brooks' death, that he is wicked and inhuman, and that he intended to cause physical injury to Robert Brooks. You were promised much in the government's opening statement to you. and you expected to be shown evidence of reprehensible actions by Matthew Gallagher. You were promised that by both the tone and the substance of the opening statements. These were promises to you, and you would have been...
Yeah, I think... Sorry, this is deja vu, and I'm only just realizing it. I don't know, maybe we did make it to the end of this? And that's why it did that weird cutout, but when I went back, it had a placeholder for like 4 minutes before this. So let's finish this out. We'll speed this up for the last 2 minutes, and we'll go to a new feed.
Reasonable jurors to have expected the government to follow up on those promises. One, the prosecutor told you repeatedly at the start that they said 10 times, they killed Robert Brooks. He told you he would prove Robert Brooks' death was, quote, a carefully orchestrated act, close quote. And that Matt Gallagher, quote, treated Robert Brooks with depravity. I can imagine what you expected to see. Blows raining down by Matt Gallagher on Robert Brooks as part of the, quote, orchestrated act or a planned meeting to create an orchestrated act. And what was then shown to you by way of evidence to support that promise, that Matthew Gallagher never struck Robert Brooks. And it was never shown even to try to injure Robert Brooks. Matthew Gallagher walked into a situation in the medical room at 9:24:55 p.m. that he did not create. He orchestrated nothing. All the conduct that was promised you, that they would prove to you that Matt Gallagher did, was done by others. Anzalone, Farina, Kessler, Walrat, none of it was done by Matthew Gallagher. Second, you were told in the opening that the government witnesses were to show you that Matt Gallagher was part of a gang. Remember how it was said, a gang! You heard that several times. 3 times. What gang did they show you that he was part of? Sergeant Tromley told you that these CO employees were not even friends. They don't hang out. They're co-workers. They're owned by DOCCS. DOCCS tells them how to dress. DOCCS tells them how to act. They're owned by DOCCS. They go to work in a horrible setting, and they're not buddies. They're co-workers. They're not a gang. They work shifts on different days, double shifts, triple shifts. There were 204 employees in that prison that day because there were 204 cameras that had been used. And COs don't know who they would be placed with on any shift. They don't plan or orchestrate anything together. There was no meeting beforehand or plan, and it certainly was not a gang. And Matt Gallagher was not part of any group. He's an employee. At 9:25:47, Matt Gallagher individually, as a DOCCS employee, tried to pull Robert Brooks onto a medical gurney. Shortly thereafter, he was told to fetch leg shackles because his work supervisor told him to do so. They could be put on ankles of Robert Brooks. Where is the gang in that? Isn't that a man doing his job? Third, you were also promised at the outset that the government would bring forth evidence that Matt Gallagher had intent to cause Robert Brooks physical injury. That there was a plan that
All right, so that's where we got to. All right, so now let's go back.
or whether he...
Oh my god, they did this in 3 parts, you guys. I'm not kidding. Right? Although, maybe this is the same. Alright, let's see. Let's see what we've got going on here.
His death, that's Matthew Gallagher's brutality. It is not.
This seems like it's starting right where we left off. So let's get this one going. Put the volume back up.
Fourth, the prosecution told you in their opening that Matt was trained to intervene in these circumstances. Trained. During a 79-minute training video, 6 months before this incident, Matthew Gallagher, if he was even there, because they never proved he was even there for this training session, this particular one, had 43 seconds of training on a new DOCCS policy about intervention. And what was the training? They read the policy. They picked up the policy and they read it. 1 sentence they read. That's the training you were told Matt Gallagher had that they claimed was sufficient to prepare him for that moment in that room. No instruction was given by DOCCS to Matt Gallagher or any DOCCS employee on when to intervene, how to intervene, what to do when your supervisor, in this case 2 supervisors, are in the room when excessive force is being used. What to do when you're the last man to come onto a situation and don't know what happened before. No training in that. He wasn't told what tools to use, what words to yell, to tackle somebody, how to recognize if when force was used, was there a chance it was going to be repeated again minutes later. He wasn't taught that. He's not a psychologist. Training, there was no proof of training. Matthew Gallagher's work circumstance is something you may all have experienced. They hand you the handbook, you sign the handbook, and they say, you know the handbook now, right? You know it. That's the training. They sent him into hell. The New York State prison system is hell. And they didn't train him what to do. The prosecution did not put a single witness who testified that Matthew Gallagher was trained for what he was going to confront that evening. Investigator Marticello testified that he did not know whether Matthew Gallagher was trained on the duty to intervene. Marticello showed you a training document on use of force, but there's no signature from the trainer confirming Matt's training. He can only tell you that Matthew Gallagher signed a document that says he attended a training session on use of force, but nothing on what was taught in that. This is the government's idea from its opening of training, a 43-second clip on a 79-minute long video. The 43 seconds is the reading of the definition of duty to intervene. DOCCS policy, 1 sentence. It's on a flash drive in evidence if you want to see it. It does not tell the CO what to do. And the same document states this: a staff member who observes another staff member or another law enforcement member use force that exceeds the degree of force permitted by law and or policy shall promptly report these observations to an immediate supervisor within the chain of command. The supervisors are in the room. The supervisors are watching what's going on. How is Matthew Gallagher supposed to know what to do at that moment, based upon that instruction to tell the supervisors? What if your boss, in fact, it's happening with his 2 bosses present, and his bosses, who you're looking at, Sergeant Mash on the left, Sergeant Trombley on the right. That's the leaders. That's who he's supposed to report the force. And they're smiling. They're both smiling. This is Mashaw. That's Mr. Trombley, who was so sorry about what he did. That's him. That's the man in charge of the room. There was no discussion in this so-called training video of any hypothetical intervention scenarios, any methods that the COs could use to intervene, what to do if the COs supervisors were there. And it's outrageous for the government to have told you in the opening that Matthew Gallagher was trained on how to intervene, how and when, and then presented nothing to you by way of that claim training other than 43-second reading of the policy. That's all the training they received. Fifth, perhaps the worst of what you were promised in the prosecution's opening to you was this, quote, Mr. Gallagher went so far as to cover his body camera up as he zipped his jacket up. What he was telling you was Matthew Gallagher's camera was on. He didn't want it to record others using force, so he zipped it up. That's not what the witnesses said. The witnesses told you nobody knew the cameras were recording. Matthew Gallagher's camera is on his body, but it's not recording, it's not activating. If he zips it up, it's like he zips up over nothing. He's not trying to cover anything up because he doesn't believe his camera's even operating at that time. Marticello testified that in all of his years in DOCCS and experience, he didn't know the cameras were passively recording when they were turned off, that they were still recording. He didn't know that. No one knew that. Matthew Gallagher did not know that. So how could he intentionally try to conceal the actions of others by covering up his camera, by zipping up his jacket? You were promised that that was going to show that Matthew Gallagher was acting to cover up excessive force. 6.
I think I'm missing a part. So Gallagher, the reason that his camera is no longer displaying video, that description was about Gallagher? His video feed goes away? Because he zips up his own jacket? Why do you zip up this was cold, this was New York, but they're inside at this point, so why would you then zip up your jacket?
You would have expected from the opening that the people would show you that while Robert Brooks was being beaten, Matt Gallagher decided to cuff Robert Brooks' legs, intending to hurt Robert Brooks. But that's not what the video shows. I'm displaying on the room what Matthew Gallagher did at 9:26:41 with the shackles. He walks into the room, he puts the shackles on his right leg. That's what he does. That's what his job is. That's what Trombley told him to do. Trombley said to you, I told him to get the shackles, but I didn't tell him to put them on. But what do you think is in Matt Gallagher's mind when Trombley says, go get the shackles, and bring the shackles back? And when he walks in the room, you're going to put the shackles on. That's why you went to get them. You didn't get them for a hobby. You went to get them to put them on. And when Matthew Gallagher comes into the room, he goes, his head's down, because you can see his state of mind. I'm going right over and put the shackles on, because that's what my job is. That's what I'm supposed to do. Matthew Gallagher wasn't excessive or abusive, and he showed no intent to harm Robert Brooks when he applied the shackles. You can also see when Matthew Gallagher returned, Robert Brooks' legs were being held. So putting on the shackles also was a logical next step for him. Matthew Gallagher left to get the shackles because he was the only one who has them. It's in his van. When he returns with the shackles, no one is striking Robert Brooks. When he comes in right here, there's no one striking him. As you were promised you would be told. He sees two people holding Robert Brooks' legs. He attaches one to the left leg and then struggles with the right leg. Robert Brooks is not being beaten or struck while the shackles are being put on. Matthew Gallagher is charged with 3 counts in the indictment: second-degree murder, first-degree manslaughter, second-degree gang assault. With each count, he is also charged with being an accomplice, helping others while intending himself to see Robert Brooks murdered and assaulted. It is complicated, but Judge Bauer will explain it so we all understand at the end of the case. In essence, the government claims that by Matt's actions, pulling Robert Brooks onto the gurney and then placing shackles on his ankles, that Matthew Gallagher intended to injure Robert Brooks. He's also charged with second-degree murder. That under circumstances evincing a depraved indifference to human life, Matthew Gallagher recklessly engaged in conduct which created a grave risk of death to Robert Brooks and thereby caused Robert Brooks' death. By pulling him onto the gurney, by applying shackles, Matthew Gallagher, the government alleged, evinced a depraved indifference for human life and caused Robert Brooks' death. That's absurd. Depraved indifference, which you can see as part of having to prove depraved indifference murder, has a definition, which you're going to hear from the judge, but I'll show it to you. Depraved indifference to human life means utter disregard. Utter disregard, a wicked, evil, or inhuman state of mind. That's what's alleged, that they've proven that with Matthew Gallagher's actions that I just told you. They also have to prove that he acted recklessly and created a grave risk of death. By pulling him up onto the gurney, he created a grave risk of death, according to the government. That he consciously disregarded a risk when he pulled him up onto the gurney and applied the shackles. And that those two actions constituted a gross deviation.
This is the problem. I can see someone successfully arguing this, but you just told us he walked in with his head hanging down. Was his head hanging down just because he was doing his job? Because if you're arguing he was just doing his job, and that's why he shouldn't be held accountable in that regard, it seems like he's consciously aware and disregarding the risk of doing the things he's doing because it's his job. So the highlighting by this defense attorney of the body language, and I know we talk about we shouldn't read body language, but the jury can and will, probably almost always, infer, from demeanor, from intent, from facial expressions, from somebody pacing back and forth really fast or waving their arms aggressively. The jury will make inferences. I think it's kind of human to make inferences about those things, even though, up here on a YouTube stream, I might say, hey, I don't want to judge somebody's body language, because it could mean 2 different things. Unfortunately, that's the reality. So someone hanging their head, and you have the defense attorney emphasizing hanging their head down. what's the connotation of someone hanging their head down? Are they just trying to mind their business? Or are they ashamed of something? So I don't know. I feel like this attorney is highlighting the same thing that's going to go in the wrong direction for his client.
From the standard of conduct that a reasonable person would have done under the same circumstances. The government alleges that Matt's depravity, his depraved indifference to human life, his wicked, evil, or inhuman state of mind, they believe they've proven that to you. Because they have to prove that, or this charge has to be dismissed. Count 2 is first-degree manslaughter, second murder-related charge. They have to prove that Matthew Gallagher had intent to cause serious physical injury and cause the death of Robert Brooks. That he intended to cause physical injury to Robert Brooks, while pulling him up on the gurney and shackling him. That was his intent. Intent to cause physical injury and cause death. A conviction for this charge requires intent. This is different from a depraved indifference. Here the government must prove that Matthew Gallagher, by his actions, intended to cause serious physical injury. And then he did so by pulling Robert Brooks onto the medical gurney at 9:25:47 and putting him in shackles. And putting shackles on his ankles at 9:26:37. Once again, there is not proof beyond a reasonable doubt that Matthew Gallagher intended that it was his goal to seriously injure Robert Brooks by pulling him onto the gurney and later applying shackles. The third count is gang assault. The government has to prove beyond a reasonable doubt that Matthew Gallagher intended to cause physical injury to Robert Brooks, was aided by 2 more persons actually present, and caused serious physical injury. The first one is the key. They have to prove beyond a reasonable doubt that Matthew had the intent to cause physical injury to Brooks by his actions. Again, repeatedly, the word intent. This crime, again, requires the government to prove that Matthew Gallagher intended to cause physical injury to Robert Brooks beyond a reasonable doubt. And as with other charges, the government alleges it is proven that Matthew Gallagher intended to cause physical injury by his actions. All counts are charged under an accomplice theory of liability. This means that Matthew Gallagher acted with the mental culpability required for the charge, and he solicited, requested, commanded, importuned, or intentionally aided those others engaged in the criminal conduct. That's a mouthful. But what does it mean? It means that he helped people cause the death of Robert Brooks, serious injury or injury to Robert Brooks, and he intended by his actions that would happen. That was in his mind, his goal. That his goal of moving Mr. Brooks up onto the gurney, he wanted other officers to then assault him further and kill him. That's what he wanted. They wanted them to injure him further. I know this part that I just ran through just now is a lot. It's new to you and it seems complicated, and it certainly is. This is the law. But Judge Bauer will explain it better than me before you begin to deliberate. The key, though, the absolute key is what is Matthew Gallagher's state of mind when you see him pull Robert Brooks up on the gurney and when he applies the shackles. Were Matthew's actions wicked, evil, inhumane? Did he create the grave risk of death to Robert Brooks? Was he intending to physically injure Robert Brooks? Did the government prove that his intent, his goal, was to injure Robert Brooks? Or what I think the proof shows is that he was trying to step forward when his bosses, his sergeants, Tom and Marshall in particular, stood mute and to help get Robert Brooks onto the medical gurney after his co-workers were struggling to get Robert Brooks onto the gurney. I believe the evidence shows that Matthew Gallagher was trying to do his job. He had no intent to harm Robert Brooks. He was just trying to get Robert Brooks onto the gurney. And I believe the evidence shows that Matthew Gallagher's job was to respond to this reasonable order from Trombley to get shackles from his van, to get the shackles when his boss told him to get the shackles, to get them because his boss thought they were necessary, and then when he returned to apply the shackles, as he would any inmate, so the boss wanted to be shackled. The government did not prove that Matthew Gallagher acted with depraved indifference. The bad actors present, Anselm, Kessler, Freeman, and Walrath, they knew some of what Robert Brooks had been put through before, but Matthew Gallagher did not. The prosecution presented to you a highlight reel called a compilation. It was shown to you yesterday, very technically done. With new movies, the marketing people offer a trailer, right? You see trailers on Netflix, at the movies. And more often than not, the trailer doesn't tell the whole story. Instead, it's a selective assembly of parts of the story that make the marketing people think will sell the movie. The government took carefully excerpted video, short, with dramatic effect. They highlight that which they claim shows people in their briefest and worst light. They exclude the context. They exclude anything that contradicts the message. In one of the images, the prosecutor showed a photo of Matthew Gallagher with a smile. I suspect he's going to show that that's evidencing guilt or indifference. So I think they suggest, for whatever reason, have you ever managed to smile in a setting that you shouldn't? In this trial, was there ever a moment when you smiled? What if that smile was photographed? And what if the photo was going to be used to define you, to define your character? What if the reporters wrote, "The jurors smiled at images of Robert Brooks," and then they matched up the timing of the smile with something very bad, made you look foolish, made you look indifferent? Is that fair, or is that a distortion? And is it intended to be a distortion? Why didn't the government in its compilation photos show the grim look of Matt Gallagher standing back at the doorway when he first arrives, and then moves forward when he sees Farina starting to use the cloth on Robert Brooks' face? Or his face after the 3 to 4 seconds striking by Farina and Anzalone when he steps forward? Or when
So, they're panning? They're going to show us? I was just about to say what they're showing.
Matt Gallagher looks at Sergeant Mashaw to do something. Or when Sergeant moves in front of Gallagher for 3 to 4 seconds.
So there's a dispute of facts here, right? State, and the guy took a plea to first-degree manslaughter, but Farina, the state's accused him of taking a cloth and shoving it into Robert Brooks's mouth, like gagging him. And then we heard, I think both defense attorneys so far in closings make the argument that he was just wiping blood off his face. And I don't know how that helps, because then we're consciously aware that this guy's bleeding. Let's continue doing this thing. So again, one of those things that doesn't really help. You bend one way, it flips in the other. But I'm glad they're showing what he's referring to in this moment.
Seconds after the assault, and you can see his concern. Does his face show that he's thinking what he's thinking? Or when the sergeant moves closer to the gurney and the COs try to pull Robert Brooks onto the gurney the one time, and then again, and then the third time, his face is serious. It's professionally serious. There's no smile on his face then, but the marketers in the trial trailer, in the compilation, want you to see Matt Gallagher smile, and then use that to make you conclude he is bad character. The people have told you that Matt Gallagher had depraved indifference because he knew he had a duty to intervene and did not act on it. Judge Bauer will instruct you that there is no duty to intervene in New York state law. It does not exist. It is not a law. And then you cannot find that Matthew Gallagher is guilty of the offenses solely by failing to intervene, because no such law exists. But the government will argue, and can argue, that you are to consider what you think that Matt Gallagher was taught, his training on intervention, or what he knew about intervention. And I'll speak to that further in a few minutes. You have to decide if the prosecution proved beyond a reasonable doubt that Matthew Gallagher's actions, moving Robert Brooks onto the gurney and putting on shackles, that those actions involved actions of a person with an evil or wicked mind. Matt Gallagher's state of mind is paramount. I'm being repetitious, because I want that to sink in. His state of mind is what matters. What will help you to determine his state of mind? What he knew when he was acting, what he did, and what he didn't do. First, Matthew Gallagher was not present for what happened in the administration building when Kessler assaulted Robert Brooks. At 9:16 p.m., remember, Mr. Brooks arrived at 9:07. At 9:16 p.m., Matt Gallagher is in the infirmary lobby. This is his body cam vantage point you have right now. He and the other COs in the infirmary were watching a Tom Cruise movie. A call came in over the radio that there was an in-graft or a new inmate coming to Marcy. Matt Gallagher walked down the hall of the infirmary to talk to the nurses. Is that the mindset of a CO that wants to see someone harmed by going and talking and alerting the nurses? Or is he likely connecting with the nurses to be sure Robert Brooks receives medical care when he arrives to the infirmary for his intake medical exam? After almost a minute talking to the nurses in the nurses' room, He walks back down the lobby. Two other COs are standing just outside the infirmary front door. Then the red dot call comes in. The in-draft has changed. It's a call for an emergency backup. Now instead of a simple inmate transfer, it's an emergency. COs need help, so that's the message. This is Matt Gallagher's duty as a CO, to respond to calls for backup. Kessler told you that, Trombley told you that. It means a CO is in trouble. Matt Gallagher runs to his van. I told you that every second of Matt Gallagher is on film. Every second. And I'm painstakingly going to show it to you. As painful as that is, I'm going to show it to you right now. Because I want you to see what he did and didn't do and why he did it. Matt Gallagher, when he gets the red dot call, he runs to his van. He gets in the van and then he drives the van to where the red dot call indicated there was a problem, which is the walkway outside the administration building. It's dark. He can't see much, and there's another van in front as he pulls up the walkway. It's Farina's van. It's in front of him. That's Farina's van. That's the administration building. Right there on the right is Matthew Gallagher's van. He walks up to Farina's van and opens the side door, assuming that the COs are going to put the new inmate, who's Brooks, into it for transport when they arrive from the administration building. He's opening Farina's van. His camera shows that he can't see if any force was used on the walkway. He's too far away. He's not involved. He just stands next to the van. Instead, 6 COs and 2 sergeants walk towards and right by Matthew Gallagher with Brooks and do not put Robert Brooks into Farina's van. They walk right past him. They walk past the van and now you're seeing their back end as they go by. The COs escorting Brooks, who is handcuffed, are Anselmo with his backwards hat on, and Kessler, right there. Behind them are Farina and Kingsley. Farina, who's one of several people that act like an animal that night, is not a sergeant. But Trombley testified he's an experienced, specialized officer on the crisis intervention unit. He's more experienced than Matt Gallagher. And following them then is Sergeant Mashaw, Walrath, and Kiefer. Kiefer's holding the inmates' records, and Sergeant Trombley. 2 supervisors, 2 sergeants, Trombley and Mashaw, and Farina, who is a member of a special unit. All seems good. Crisis over. Here's what Matthew Gallagher does not know. According to Kessler, Robert Brooks likely is already seriously injured. According to Kessler, Walrath had snapped in the administration building shortly after the 907 arrival. And Walrath, by all accounts, is also an animal. He had choked Robert Brooks, yanking him up by the neck, punched him, and Kessler had punched him, both repeatedly. Walrath had to be pulled off of Robert Brooks. This is after 9:07 p.m., the time period when the medical examiner, the doctor who testified on the autopsy, told you that Mr. Brooks suffered his deadly injuries. It was at that time. But Matthew Gallagher knows none of that. He is out in the parking lot driving over to Farina's van. As the 2 sergeants and 6 COs pass Matthew Gallagher, not a one even acknowledges Matthew Gallagher. He's invisible. This is the first of several times over the next 15 minutes. And mark this, by 15 minutes from now, Robert Brooks is almost dead. When the 6 COs pass Matthew Gallagher from this van, they don't acknowledge him. It's the first of multiple times that Matthew Gallagher appears invisible. Well, he's invisible the whole time to his colleagues. He's not one of the boys. No one pays attention to him. The COs escorting Brooks down the hallway, walk right past him. And none of the COs later, outside the exam room, talk to him as he walks up and stands out in the hallway. He appears as a loner. Kessler ignores him. Mashaw steps in front of him as if he's not there in the exam room. For Trombley, his only direction, his only acknowledgement of Matthew Gallagher is fetch. Fetch the shackles. The COs escorting Robert Brooks go from the walking Robert Brooks to dragging Robert Brooks to carrying Robert Brooks as they make their way towards the infirmary building. On the way to the infirmary, while Matt is not even there, Kessler punched Brooks again twice. That's what he said. Matt did not see this because he was driving his van back in the parking space. Robert Brooks is then being brought inside the infirmary building at 9:22 p.m. and 30 seconds. 9:22. There are now 4 officers with him as they go through the lobby. Still, Kessler and Anselmo carrying him on his shoulders. Castleberry punched him twice on the way to the infirmary. Kingsley is now holding his legs, and Walters is walking behind him. This is coming into the lobby of the infirmary building. And that fourth person right there, that's not Matt Gallagher, that's Walters. Robert Brooks is injured, but Matthew Gallagher doesn't know this. He's still outside in the parking lot, and he's seen nothing so far that would cause him to believe there is any problem. He goes back to his van at the walkway, and then he drives and reparks it at 9:23 is when he parks it. By now, Robert Brooks and the officers are through the infirmary building lobby and down the hallway towards the medical room. If you look at this next side-by-side photographs, in the right-hand corner is 9:22 and 32. This is Mr. Brooks being carried to the lobby by the officers. At 9:22:32, this is Matthew Gallagher's body cam. He's in his van. He's nowhere near them. No one is in the lobby when Matt Gallagher comes in except Trombley, who's on the telephone. Robert Brooks has been brought by the officers down the hallway and into the medical unit at 9:22:43. This is a slide from Officer Avon. They just went in the room, and on the right-hand side is a nurse looking in the room. Once in the room, several officers, likely Kessler and Walrath, who beat Brooks in the administration building, and Anzalone, none of whom can be made out because their backs are to Alone's camera, appear to be on top of Brooks in the medical room. The only image of that is from Officer Alone's body-worn camera, which I'm going to put up on the screen. At that moment, there's 3 to 4 officers on top of Robert Brooks in the medical unit. Matthew Gallagher, at that moment, is nowhere near the medical unit. He's coming in the door. This is him coming in the door as they're in the medical unit on top of Robert Brooks. This is the vantage point from Matthew Gallagher's camera. At multiple officers, actually let's show next slide, Ash. This is at 9:22:52. This is the medical unit. These are the officers in on top of Mr. Brooks. And this is the vantage point at that same moment of Matthew Gallagher. He's out in the parking lot. He knows none of what's going on. While Matthew Gallagher is down in the hallway, multiple officers come down to the area of the medical room. They go back and forth, they mill around, and they leave. Matt stands in the hallway and can see the nurses in the hallway. Slide 34. That's the nurses. This is Matt Gallagher's vantage point, and beyond him is the nurse looking into the room. At 9:23:16, this is where Matt Gallagher stands in the hallway. Right there. That's Matt Gallagher on the left. He's had zero involvement with Robert Brooks. He knows nothing about Robert Brooks. They've had no interaction. So Matthew Gallagher, this is a typical in-graft, and he can and does stand in the hallway because the medical room has a sergeant who he can see and COs who he cannot see in the room. He's just not needed. For the next 119 seconds, Matthew stands in the hallway several feet from the entrance to the medical unit. He's casually talking to officers. He doesn't seem depraved. He doesn't seem to have an evil mind. He's literally hanging out. This is Matthew Gallagher's perspective. That's Officer Farina and Officer Walters. Matthew Gallagher sees nothing about what's going on in the room. At 9:23:26, whatever's going on, Walters finds it entertaining or something, and he goes like this with his hand. At 9:23, keep going. Sergeant Nashaw. Welcome, Sergeant Nashaw. At 9:23:35, Sergeant Nashaw, the man in charge of the room, according to Officer Trombley, stands at the door. That's Matthew Gallagher's boss. Officer Sergeant Nashaw is a profile of a disinterested clown the whole time. Under the circumstances as they unfold, his behavior is dangerous as a leader. This is the person to whom the COs take orders, are to follow, who is to guide them, who is to curb their behavior, who is to help them, and who himself is to make decisions. There are over 15 people in and out of that room, and Sergeant Nashaw never does or seems to say a thing. Is he afraid of Farina and Anzalone? Or of Kessler? Of Walrath? Is he incompetent? And how does DOCCS put him in charge of anything? Then Trombley comes in the room at 9:23:48. Right there is Sergeant Trombley. And right behind him is Walrath, the animal. Now there's a second supervisor in the medical room. Trombley's in charge, I think. He runs the shift, he runs the infirmary, but he told you convoluted that Marshall runs the incident. I don't know if they know who's in charge, but somebody's in charge. Trombley told me he came down the hallway and he said he heard a scream. But watch the tape right here. He's got a smile on his face, no one in the hallway is moving or appears concerned, and the moment Trombley turns into the room, other than Mr. Brooks having blood on his nose and being on the end of the gurney, nobody appears to be doing anything. Kingsley's leaning on the counter, Anzalone has his hand on the back, and I believe it's Kessler has his hand on the back. It doesn't appear there was screaming coming down the hallway. It's Trombley's job now to meet with Brooks. To Matthew Gallagher standing out in the hallway after having been there 2 minutes, this is still a typical in-graft of which he has little interest. He gives a thumbs up to one of the officers who walks out, probably trying to figure out, is everything okay? There's a thumbs up that you see in a minute. But it's on there, and it's not important actually. It's now 9:25 and 12 p.m. 9:25:12. Robert Brooks has been on site since 9:07. That's 18 minutes. Matthew Gallagher has still not seen Robert Brooks, other than passing by his van in the dark at 9:21, 4 minutes before. Robert Brooks has been alone in that room with Anzalone, Kessler, and Walrath, who were involved in 3 incidents. 2 of the 3 had struck in the administration building, and another in the walkway. And several others were also in the medical room, kneeling on top of Robert Brooks. Sergeant Mashaw is at the doorway, supposed to be monitoring what's going on, and Sergeant Trombley, who would be working with Robert Brooks to check him in, is supervising everyone in the room, if Mashaw isn't there. Matthew Gallagher looks in the room the first time at 9:25:15, slide 40. And this is what he sees. 9:25:15. It's the first moment he sees Robert Brooks in the light, and who is in the medical room. There are 3 officers next to Brooks, and Trombley is next to them. At this moment, Officers Kingsley, Farina, and Anzalone. In that corner, behind them, is Trombley. And right here is Sergeant Mashaw. He's got the best look at what's going on. And it appears that they're wiping his nose off. It's got blood on it. It would make sense that he's wiping his nose off. He also been pepper sprayed. Maybe he's wiping the pepper spray off. But he's doing something. And it doesn't involve Matthew Gallagher. He's in the room watching and taking everything in for 5 seconds from behind Sergeant Mashaw. 5 seconds. And it appears then that Robert Brooks bites Farina at the end of those 5 seconds. Farina is a long distance away, a good distance away, long is relative, from Matthew Gallagher, and in between Matthew Gallagher and Farina is Sergeant Mashaw. And Farina reacts to the bite by assaulting Robert Brooks several times in the head and maybe the neck as Anzalone hits his legs. You've seen that image a lot. It lasts 4 seconds, from 9:25:20 until 9:25:24. It's horrific. But it's 4 seconds. And it's over. You saw Mashaw take a half a step in and stop and settle back. He's not doing anything. There's not a thing Matthew Gallagher from his location in the doorway could do to stop Farina. He wasn't in the room 5 seconds before it happened. And then it took only 4 seconds for it to start and be done. As importantly, his 2 sergeants, the bosses in the room, they don't move. Both are closer to the gurney than Matthew. Sergeant Trombley can touch them. He's that close. And Mashaw is in front of Matthew. Both Kessler and Trombley testified that there was no notice before Farina snapped. Kessler testified he was shocked and didn't know what was going to happen. Trombley testified that he didn't expect it to happen. But then it stops. As quickly as the assault happens, it ends. Trombley told you it was over. He thought the use of force was over. And Matthew Gallagher would also believe it's over. He's been in the room 5 seconds when Farina and Anselo lose it, and once it's over, there's nothing for him to do. There's nothing more to stop. But their Staff Sergeant Trombley and Sergeant Marshall are required to do at that moment. It's now disciplinary. It's supposed to be disciplinary at that moment. And Sergeant Trombley is supposed to tell those officers right then, Farina and Anselo, to leave the room. It's policy. Trombley testified. DOCCS has a policy that if an officer is involved in a use of force, he has to be removed from the vicinity of the inmate. Matthew Gallagher is expecting that Anselo and Farina are going to be removed from that room. Why? Because it's DOCCS policy. It's standard. And Trombley explained why that policy exists. If an officer uses force on an inmate, he shouldn't even the inmate further because he could be hyped up. He could be excited. He could be agitated. And there's an opportunity or possibility that it will happen again. So if Anselo and Farina are removed from the room as they're supposed to be, who would take over with Robert Brooks? The 2 sergeants are there, but there are also other COs nearby. There are 3 to 4 in the hallway, and Matthew Gallagher is just inside the room because none of them had been involved in the use of force. Matthew Gallagher would be suitable to step in place of Anselo and Farina when Trombley or Marshall sent them out of the room. But Trombley testified, I didn't send them out of the room. He didn't do anything. Instead, Trombley and Marshall leave them both in the room. And then with Robert Brooks on the edge of the gurney, the officers who should have been told to leave the room by policy, and Officer Kingsley try to move Robert Brooks from his leaning position at the end of the gurney up onto the gurney. He's leaning at the end of the gurney. He has to be placed on the gurney. He's not able to get on the gurney on his own power. He's going to be placed on the gurney for a medical examination and to be searched. And the officers start trying to move Robert Brooks onto the gurney. Once, twice, 3 times. They try to pull him up onto the gurney, and they don't get him up. Is he passively resisting? Is he knocked out? Do they have the wrong angles or leverage? But Matthew Gallagher, he wouldn't know the answer to any of those questions. All he can see is they are not getting Robert Brooks onto the gurney. And now Matthew Gallagher faces a decision. What is he to do? The government argues that Matt's decision in the next several seconds proves, beyond a reasonable doubt, some combination or all of these. That he's depraved, that he's indifferent to human life, that he created a grave risk of death to Robert Brooks, that he intended to injure Robert Brooks, that he intended to help others injure Robert Brooks. Simply, that over these next 16 seconds of Matthew Gallagher's life, the government's alleging that he's deciding to injure, he's intending to injure and cause the death of Robert Brooks. That's what they have to prove beyond a reasonable doubt. The next 16 seconds of Matthew Gallagher's life, over the next 16 seconds, they state that he intended to injure Robert Brooks. 16 seconds. 1, stop it, Ash. They tried to pull him up once, they didn't get him on the gurney. Ash. Twice, they can't get him on the gurney. Marshall moves in front of Brooks, but he doesn't move in front of Farina, Sergeant Marshall moves in front of Matthew Gallagher, but he doesn't approach to help. He doesn't help. Go ahead, Ash. 3rd time, they don't get him on the gurney, and they're getting rougher. I don't know, they're frustrated. Are they incompetent? They can't get him on the gurney. So who's supposed to act? He's supposed to act. Marshall. He's supposed to take charge. And he doesn't. What is Matthew Gallagher's state of mind? Because it's going to be judged by you for these 16 seconds. What does he know before he makes his next decision? When they try to pull him up 3 times and fail, when he knows that he's been struck by Farina less than 30 seconds before, Farina and Anselo, what's he supposed to do? What's his decision process? What does he know? This is what he knows. Number 1, he knows he's not angry at Brooks because it's not Brooks' fault that Brooks can't get up on the gurney. He knows who's in the room and in charge. His boss is to his right and in front of him. His other boss is in the corner of the room and can reach to the gurney. He can touch it. And they're all watching. Trombley, Mashaw, and they're doing nothing. What else does he know? He knows that Farina and Anzalone, 30 seconds before, had used excessive force and they weren't sent out of the room. So they're going to be agitated. He knows what the employee requirements are. If an employee observes another employee in an altercation with an incarcerated individual, all available employees must immediately go to the aid of the involved employee. Matthew Gallagher, by rule, by policy, has to now step up. He's got to do something. He has to do something. Directive 4944, the duty to intervene I spoke about earlier. What's he supposed to do? Who's he to tell at this moment when the supervisors are watching and are closer to Brooks than he, who have been in the room longer, who have more experience than he does? What's he supposed to do in terms of intervention when he knows that they're there? The government says he has a duty to intervene because there's a DOCCS written policy and he was trained on it. I went through that training. I didn't go through 4944, the actual policy. It's the entire document, 16 pages long. This is the priority of DOCCS training of Matthew Gallagher and COs. 16 pages on force. 12 of the pages are how to write a report. 12 pages are how to fill in the blanks on reports.
I know an organization, I know a group of people that could use some training on how to write a report.
One sentence in this policy is on duty to intervene. It provides no details on what Matthew Gallagher is to do. Does he yell? Does he ask Mashaw or Trombley to do something? They're the bosses, they should be telling him. Does he run from the room? Does he just leave the room? What was he taught to do? He wasn't taught anything, and they never showed you he was taught anything. You didn't hear from the instructor who taught these guys what to do. They claim he took a course on force that included duty to intervene. That's crap. He was read one sentence of a policy manual. That's his training. 79-minute video he was shown. In 43 seconds, they read the policy. And that is supposed to prepare Matt Gallagher for his next decision. That's supposed to prepare him. And for his failure to act like they think he should act, he's a murderer, manslaughter, and gang assault. They gave him nothing of what he needed to make a decision. They sent him to hell and didn't tell him how to act. That's the extent of his preparation. No guidance from Trombley, no guidance from Mashaw. Nobody's taken out the wrongdoers from the room. But regardless of what training he had, is there something he can do? He's supposed to do something. He's supposed to step forward and help. They failed 3 times to get Robert Brooks on the gurney. And what did he do?
Shackling him.
He could go out in the hallway like the other cowards and just stand there and watch. He could act like Mashaw. Why couldn't Matthew Gallagher put his hands in his pocket and do nothing? That's what Sergeant Mashaw was doing. Why couldn't he do what Sergeant Trombley's doing? Stand in the other corner with his hand on a pen 2 feet away from what's happening and not doing anything. He could wait longer for an order. But then look at the pathetic look of Sergeant Mashaw. He has no idea what he's going to do. Matthew Gallagher.
I agree, but I don't think this helps your client.
Is left standing at this moment having no idea what to do. He has seconds to decide. There's no order coming. His supervisors are mute. One is doing nothing. The other is not paying attention. And the officers are having trouble getting Robert Brooks onto the gurney. They tried 3 times and they can't get him up. I've talked for 20 minutes on this. 28 seconds have passed since Matthew Gallagher was in the room. 28 seconds. And he's got to process all this and make a decision. What can he do? He could step forward. He could do something to help get Brooks on the gurney. Is that intervention? Maybe. Is it going to the aid of an officer? Maybe. Is it diffusing what appears to be getting more and more heavy-handed as they try to pull him up on the gurney? He could diffuse that. He could help Brooks get on the gurney to alleviate the struggle the other officers are having to help. But as he stands here, his mindset is, Somebody help me know the right thing to do.
Judge, I object to that. He's speaking for the defendant, and that's not proper. He's going in, there's no evidence of that in this record.
No.
Oh, let's replay that. So we have this statement from the defense attorney about what was his client's state of mind. We have an objection and then a speaking objection, and then we have a scoff back from the attorney. Whew. We need the flames.
Somebody help me know the right thing to do.
Judge, I object to that. He's speaking for the defendant, and that's not proper. He's going in, there's no evidence of that in this record.
No. His decision has to come in an instant. Not 20/20 hindsight, not through analysis, in an instant. How would he ever anticipate that this instant decision that he would have to make would be judged in the horror of this courtroom a year later? Almost. So he steps past his leaderless sergeant and takes one hand, his left hand, and only his left hand. He does not touch Robert Brooks' body. He does not hit Robert Brooks. He doesn't touch his skin. He grabs his shirt and he pushes him up onto the gurney. He takes the shirt with his left hand, and if he succeeds in getting him onto the gurney, everything should stop at that moment. Brooks would be on the gurney. And as he does it, without notice, Farina, who is behind him at that point, as he's pushing, Farina's over in the corner of Trombley. Farina comes around. Corner of Trombley without notice. And as Matthew Gallagher is pushing him up on the gurney, Farina comes behind and begins kicking Robert Brooks in the groin area. Horrific. Matthew Gallagher at that moment has his back to Farina, and he's looking in Mr. Brooks' face. He's trying to evaluate what's going on. He is not moving Robert Brooks so Farina can assault him. He's trying to move Brooks, Mr. Brooks. So at the end of the struggle and the frustration he sees on the officer trying to get Brooks on the gurney. And notably, Farina's not trying to get him on the gurney. He's to the side. The other officers are trying to get him on the gurney. Matthew Gallagher cannot see what Farina is doing because Farina's behind him. This is Farina kicking. This is Matthew Gallagher looking down at Robert Brooks' face. Officer Kingsley then turns his back into Matthew Gallagher, pushing into Matthew Gallagher and moving him out of the way. Here's the entire clip. This is 47 minutes. Okay, go back. Break, stop. As he does that, Officer Trombley, who's right here, testified, I told Matthew Gallagher to go get the shackles. So Matthew Gallagher's leaving the room because he was told to get the shackles. Now this is the first order anyone's issued, and it's by Trombley. And he leaves to get the shackles. Matthew Gallagher is gone to get the shackles for 37 seconds. From 9:25:57 to 9:26:32. Play 49 cash. You can see him leave the room. It was 9:25:57. That's his 9:26. He's already out of the room at this point in time. Matthew Gallagher has no problem in his mind, has no problem to leave because he's leaving behind his bosses. They will handle the situation. Trombley is given an order, albeit weak and late, but Mr. Brooks is on the gurney. Trombley or Marshall are in charge, and Matt Gallagher is heading up the hallway to do what he was told to do. Keep playing up 49. While Matthew Gallagher is going out of the room, Farina starts up again. Trombley and Marshall do nothing again. At 9:26:03 to 30, you will see Farina and Walrath again assaulting Brooks. Stop there. It's horrible, right? Matthew Gallagher's not in the room. He doesn't know that. He doesn't know that just happened. He's walking down the hallway to get the shackles. Slide 51. At the moment that they strike him again at 9:26:20, this is Matthew Gallagher's body cam. He's out of his van. He doesn't know this is going on. He doesn't know that there's another strike going on. When he returns, the assault, the next assault, that assault, is over, and he didn't know that Farina had again assaulted Brooks while he was gone with Wallraff, neither of which is supposed to be in the room because of the earlier use of force. And what does he see when he returns? He sees Farina and Wallraff struggling with Brooks' legs. He went out to get the shackles because the boss said to him, he comes back and they're struggling with his legs. Slide 52. Matthew Gallagher walks in.
Oh, all right. So next one.
Probably told.
Oh. All right, this is part 3. And it's only 14 minutes in, so I wonder why they're breaking it up this way. Is their camera battery finicky? All right, so this video is only 14 minutes. Maybe they ended up going to lunch. So we'll finish this one out and we'll figure it out after we play this one. I'm going to lower this one a little schmidge, medium volume.
To do, or that he intended to injure Brooks by putting the shackles on? How can it be that Doc sends a Matthew Gallagher onto the front lines, tells him to follow lawful orders, one being shackles, put on shackles, and then prosecute him here for murder, manslaughter, and gang assault for following that lawful order? From 9/26/38, when Matthew Gallagher returns to 9/27/58, Robert Brooks remains on the edge of the gurney. And once again, everything stops. From Matthew Gallagher's perspective, it stopped 3 minutes earlier when he left the room for the shackles. When he left the room for the shackles, that was the last time that he saw anything that was excessive. Then, once again, because they left Anzalone in the room, unprovoked, right in front of Trombley, with no notice, Anzalone hits Robert Brooks again. Matthew Gallagher doesn't know that's going to happen. He's not part of it. He's on the other side of the room. But Anzalone shouldn't be in the room, and he hits him. No opportunity by Matthew Gallagher to know what was going to happen or to do anything to stop it. The government also alleges that Matthew Gallagher didn't get medical treatment soon enough for Robert Brooks. Trombley testified that he said out loud that Brooks is to go to the hospital, but must first go to the mat. That's at 9/28/14. Matthew Gallagher has been in the room for 4 minutes, and Trombley says he's going to the hospital. This is what Trombley said. Question of him, at any point in time, did you say that out loud that Mr. Brooks was going to have to go for a trip, meaning to go to the hospital? Answer, I figured he was eventually going to have to go back to the hospital. Yes. Question, did you say it out loud? Answer, I do recalling somebody to get a trip set up. You have to get stuff set up for that. Question, which means to begin the medical care process? Yes. And you would expect everyone within earshot to know that now Mr. Brooks is going to get medical care, right? Yes. So he announces in the room at 9:28, Trombley does, we're getting a medical care. And then what does he do? Trombley leaves the room at 9:29. He's announced they're getting medical care. And the people in the room reasonably expect that Trombley's going to make the call to get medical care. Why would Matthew Gallagher believe he now has to make a call to get medical care when the boss of the infirmary, Sergeant Trombley, who runs the infirmary, has just stated 4 minutes after Matthew Gallagher is in that room that they're going to get medical care for him? and leaves the room to do so, seemingly to do so. Matthew Gallagher didn't deny him medical care. The nurses were in the hallway when Matt Gallagher came back with the shackles. Page 124, Ash. Now both Trump and Kessler also said that he went over to the window to unhook the shackles to get Mr. Brooks ready to be transported for medical care. At 9:31, both nurses are in the doorway to the room. And the medical care is, you haven't seen this, it's somewhat not done by the nurses. I mean, you're going to see two nurses in the room who now take over the medical care, and they don't do anything. Slide 55, actually. That's the nurse. Go back to the next. That was the nurse, right there. Right there's the nurse to provide medical care. $56, Ash. Stop it. That's a nurse. That's a nurse. At 9:33:41. Go ahead. He's getting paperwork. Does the nurse look motivated to be helpful? But they're in charge. This is the medical care. Now, the government has told you that the defendants, Matthew Gallagher, are blaming others that were claiming, I think the analogy is Nuremberg, I took orders. We're not saying he was under orders. But we are showing that he didn't do anything that's criminal in this case. We are showing you that the circumstances that led to the decisions Matthew Gallagher made were the proper ones, and that he didn't intend to cause any injury to Robert Brooks. The evidence will show that there were people that did. Anselmo, Farina, Kessler, Walrath. What they did to Robert Brooks is a horror. You will so justly want to sit here, want to not have sat here for 2 weeks, watch this played over and over again, and not find someone guilty, right? You got to be leaning in. I got to find somebody guilty. Look what they did. You got to feel that. You care. You're repulsed. But they are not Matthew Gallagher. He is not Anselmo. He is not Frida. He's not Kessler. He's not Walrath. He's Matthew Gallagher. They call him, they dump Matthew Gallagher with the animals. And he's not. He is not guilty of the murder, manslaughter, and gang assault of Robert Brooks. The death of Robert Brooks is on the hands of those officers. The chart that the ME showed you, the medical examiner that had all those injuries, not one of those injuries was done by Matthew Gallagher. Not one. He does not bear criminal responsibility for the acts of those men in the administration building, in the walkway, in the entry to the infirmary, in the building, and in the medical room. The government has not proven beyond a reasonable doubt that Matthew Gallagher's decision in those 60 seconds when he had to make a decision, that he decided and intended to kill Robert Brooks. He did not. He tried to do what he believed under the circumstances to be the right thing to do. When you first came into this courtroom, when we were all here, all of us, agreed you were the best to carefully hear this case. and you took an oath to listen carefully, to weigh the evidence fairly, and to follow law that the judge will give you when the lawyers are finished. And I know you have done so and will do so. Judge Bauer, who's been fair to all sides, will tell you this. The government has the burden of proof. The burden of proof is beyond a reasonable doubt. The government decided to bring this case against Matthew Gallagher. Anzalone, Farina, Kessler, and Walrath, the people that struck Robert Brooks, are not on trial. You want to find them guilty. But Matthew Gallagher, this man, is on trial. This is his trial. The government made promises to you at the outset. The government then chose the witnesses to prove its promises. The government gathered the evidence. And the government didn't keep its promises to you. It is the government's burden to prove Matthew Gallagher guilty beyond a reasonable doubt. Proof beyond a reasonable doubt that Matthew Gallagher had the intent to hurt or murder Robert Brooks. That Matthew Gallagher has a wicked mind. That by placing shackles on Robert Brooks' ankles, that Matthew Gallagher intended to cause Robert Brooks to die. That by moving Robert Brooks onto the medical gurney when others were struggling to do so, that Matthew Gallagher intended to cause Robert Brooks injury. He did not. In this country, under our Constitution, none of us can be convicted for the crimes of others unless we share the same mental state of those who committed those crimes. Unless the government proves beyond a reasonable doubt that the person they are accusing, Matthew Gallagher, has the same intent, the same objective as Farina, Walrath, Kessler, the whole crew, the charges must be dismissed. There is no other choice. None of us can be convicted when the government does not prove beyond a reasonable doubt. Mr. Gallagher is not guilty of the serious crimes he is charged with. I ask you, the cameras are on. They're only on me, but the spotlight's on you. You have to be courageous. You do. You have to make the right decision. You do. And find Matthew Gallagher not guilty.
Wrap it up.
So folks, given the hour now, I think it's best to give you a lunch break. Remind you of your admonition. You might be tempted to talk about the case because you heard a couple of closing statements. You're only halfway through the book, so resist that temptation. Over this lunch break, do not discuss the case with anyone, even among your fellow jurors. Do not rewatch or listen to any accounts of the case in the media, nor conduct any research on your own. Do not view the location that advice to let you have occurred. Continue to keep an open mind. If anyone tries to influence you in any way, you must report that to the media immediately. Let's say 1:30. Please be back no later. We'll start at 1:30. Enjoy your lunch.
So it seems like they're going to resume in 9 minutes from present time. Because I said 1:30. So we'll keep, do they say anything here? Maybe about that objection. Let's listen to this and see if they put something on the record about that mid-closing argument.
All right, now the jury has left the courtroom, remaining on the attorneys for each side, along with each of the three defendants. Before we take our lunch break, one thing I have to address, because I don't believe the direction each of the defense counsels are facing, it came to your attention. I'll affirmatively note this for the record, as I believe I have an affirmative obligation to ensure a fundamentally fair trial. During Mr. Woodbrand's closing argument, a gentleman came in and from outside entered the audience wearing an orange jumpsuit with Department of Corrections emblazoned across it. And if he's still here, I'll advise you, sir, you're welcome to be present in the courtroom. However, your choice of attire, I can only assume, is intended to offer some form of statement or influence or prejudice toward the jury, and our law simply does not allow that. So when you return from the lunch break, you are going to have to change your attire. On the bright side, I can say that I observed this gentleman as soon as he entered the courtroom, and I immediately turned to our jury, who fortunately seemed to be engrossed in looking at the video monitors that Mr. Louis Brand was calling attention to during that portion of his closing, so I do not believe any of them even saw this individual. But to prevent any prejudice as we go forward, nothing of that sort will be permitted as we continue on. Is there anything else on either side? People?
No, you're right.
Defense?
No, you're right. Thank you.
All right, we'll see how that can run through.
Well then. So if you missed that, somebody walked into the gallery with chosen attire that, I mean, undeniably was to make a statement. You're not supposed to be walking into court with like t-shirts that have slogans on it that could influence the jury or make a public statement. So apparently some guy walked in wearing an orange jumpsuit that they had printed on it the Department of Corrections name. So yeah, this is a jury trial. NYP had also asked, he called no witnesses for character. So, and I'm relying on EJF here a little bit. Doesn't seem like the defense attorneys for any of the 3 that are on trial here put on a case. So, but yeah. So yeah, that's what happened. That is what happened. They should be coming back from the feed with a feed in a few minutes if WKTV goes live right at 1:30. We'll have to refresh until we see one. Courtney Clenney, if you guys missed that. Today's hearing was continued, although the judge did grant the motion to compel. Don't really know if that's significant until I can see the order. Because she could grant the motion and it could be the same 10 days or maybe barely more than 10 days or just make an effort to get that over. I'm going to grant it because I can't deny something like this. You're statutorily obligated to turn this over in the 10-day time frame before trial. But maybe the judge was like, I want you to turn it over by the 15th. And that would give the defense 30 days to prepare. Or more since trial's delayed. I don't really know if it's a substantive ruling. But other than that, everything else, all the issues seem to be continued until next week. The docket says the 5th. Reporting says the 4th. Not next week, next month. And then trial, I don't see when the trial date is reset for, but trial date was postponed. Munktunk. So I mentioned at the beginning of the stream, Jim said he's going to go live on Friday, so that's going to be fun rants and bants. I do want to look at, and it'll be a blind look for me, the state's reply to the Antonio Sledge appeal, the Munktunk appeal. And I'm trying to drink some tea. And we'll play, I think we have one more defense closing argument, right? So we've got to get through that, and then we have the state's closing argument. I don't know if I'll schedule that for today. If we don't do the Munktunk state reply reading today, we'll get together tomorrow morning, okay? Because I'm really excited to read that. I'm hoping I'm not getting sick. I'm drinking some tea. But when we were doing the Courtney Clenney stuff, I don't know if you guys get certain symptoms when you start to get sick. I always feel tired because work is working me. But I started to feel like my pores, I had sweat coming through my pores. I don't normally feel that when I stream. So it made me a little nervous that tomorrow I might wake up and get hit by this flu that's going around. But we'll see. And since it's a motion that we're going to be reading, we'll get some tea, we'll get some cough drops, we'll make it work. But with this stream, I think we're going to finish this out with the arguments. That might run us until like 4 p.m. Eastern, 5 p.m. Eastern. And I don't know if I'll be up to doing a 30-page reply brief reading. So either today, this evening, or tomorrow, we'll get together for Munktunk. Free the Tunkster. Free the Tunkster. But I'm excited to grab that document and we can look at it together. And, yeah, get some zinc. Crazy name, amazing results. I've been drinking throat coat tea, and it never fails me. It always seems to be super helpful. So I'll be drinking this during that stream, whenever it is, and today to see if it wards off the flu demons. Yes, YP over on Twitch with the Munktunk emoji. Love it, love it. Most popular emoji. So that'll be good, and then I expect that Jim will talk about some of the issues and his reply, because he should be filing, if he didn't already file, him and Tiffany Adams should be filing their reply to the state's reply. So. Is that in New York how to say it, drinking some tea? It's so great. It's such a sketchy name. It's such a pause name. But it's so good. It's so effective. It really, really helps. And I mean that. It's not just because it's hot and any other tea would work. I really think that that tea makes a difference if you feel like you're getting a sore throat or getting a hoarse voice. It's just great. Highly recommend it. Refreshing here. Let's see if we get a lunchtime feed. If not, I'm going to pull up random articles. We're going to read whatever my news ticker brings across. Let's see. Oh no. Okay, I found one that we're gonna read. Oh my gosh, I hope Tay-Biz is still in here. Shout out to Tay-Biz, the sponsor of the stream and one of my favorite creators here on YouTube. Oh, I hope you're still in here, Tay-Biz. Oh, let me change. This is a crappy way to read this. All right, we're going to read this. Let me see if I can put it in reader mode. All right, so we're going to read this random news story. Chicken wing scheme leads to arrest of Texas corrections officer, police say. Now, we talk a lot about Fulton County and the Fulton County Department of Corrections, their facilities, the APD, all of it, right? Texas has been in the news a lot lately because of their own prison problems. There's been, I think, a rising number of deaths and serious health injuries or health-related issues or injuries stemming from incidents at the facilities, the jails and prisons. So Texas has been in the spotlight for corrections issues. Now we have chicken wing scheme leading to the arrest of Texas corrections officer. So let's see, this is Travis County. A correction officer with the Travis County Sheriff's Office has been charged with allegedly bringing contraband into the county's correctional facility. The alleged contraband, chicken wings. This is exactly how I would write this article. The ... chicken wings. On August 21st, a corrections officer with Travis County Sheriff's Office Security Threat Intelligence Unit became aware spontaneously, that corrections officer Amos Nyanwe, that's a great last name. We're going to get these chicken wings in by any way necessary. Allegedly provided chicken wings to an inmate in exchange for money, according to a TCSO press release issued Tuesday afternoon. An investigation began shortly after, and Nyanwe was placed on administrative duties during the investigation. He was fired on Tuesday, and the sheriff's office said that he's been arrested. Nyanwe started working with TCSO on June 17th, 2024. Well, he made it past the 90 days. We've got, I'm disappointed that a Travis County Sheriff's Office corrections officer made such a foolish decision. We hold our employees to a high standard of conduct and accountability. We simply cannot tolerate contraband of any type being brought into our secure facilities, said Sheriff Sally Hernandez in the release. So that's a Class B misdemeanor, carries a possible jail sentence with up to 180 days and or a fine of up to $2,000 according to the Texas Penal Code. How do you bring a chicken? Chicken wings have like a smell to them. I don't know if it's because of the hot sauce. Well, maybe they weren't hot sauce flavored. You know, that's the upstate New York creeping in. I think by default, chicken wings should be buffalo wings. They should have some Frank's Red Hot or a hotter sauce if that's your liking. But that is a smell that like carries, like the cartoon type of smell. Just carries. But secondly, I know certain foods probably hit the spot when you're locked up and don't have the freedom to go to wherever you want to get the food that you want. But these had to be like soggy and cold, right? Chicken wings. They should have gone with the pot pies. What else do we got going on? We'll do a quick refresh on the feeds. All right, they're back live, you guys. We got a chicken wing interlude midstream. The Trial Watch album. Alrighty, so we're back in action. Check on the volume. Oh, maybe they were boneless. There was, I don't know if you guys caught it, potentially Criminal had covered it, but there was an appeals court, an Ohio appeals court, had to hear a case on, it was civil. Somebody was suing a restaurant because they ordered boneless wings, but there was bone in the boneless wing piece, and they said that they chipped their tooth on it or something. And the ruling, the decision from the appeals court, affirmed that, you know, because these are parts coming from an animal, even though they're called boneless wings, a reasonable person should not expect for them to literally be boneless. So according to an Ohio, like, court of appeals, it might have gone up all the way to the top level. I don't remember. Boneless chicken wings do not have to actually be boneless. So that's a good time case. Let's rewind this to, it looks like they're just on a placeholder. All right, so maybe they didn't start the feed. All right, so we'll skip this placeholder part. And then it looks like it's starting in the middle of this guy's sentence. So this is defense attorney number 3 for the third and final defendant on trial here.
The prosecution was going to be putting in 4 body-worn cameras, 4 videos that captured the relevant portions of the events of this very, very tragic event. I then stated that we, Mr. Kiefer and I and Mr. Curley, were going to use those same videos that the prosecution has offered you to show you that Nick Kiefer is not guilty of the crimes he has been charged with. We also alerted you, ladies and gentlemen, that there were many, many people in these videos, and you have now seen that with your own 2 eyes. We ask you to pay very close attention to those videos, and I ask you to look for Nick Kiefer. See with your own eyes what Nick Kiefer's actions were.
Do we ever make it through a trial without hearing about a Nick?
If any, and see if Nick is even present when the assaults on Mr. Brooks is taking place in that treatment room. Now, you have all seen the videos multiple times, and I personally have observed each and every one of you looking very, very closely at those videos and paying very close attention to them. And again, we thank you for that. We are now asking you to carefully deliberate on this matter. And remember, if you deem it necessary to view those videos again, simply send out a note to the judge. The judge will rule on that note, and I believe he will allow you to view those videos as often as you deem necessary to render your just verdict. Now, the New York Department of Corrections and Community Service, DOCCS for short, is its own world. It has its own rules, It has its own regulations. It even has its own procedures for determining whether those rules and regulations were violated. And if they determine that their rules and regulations, not laws, rules and regulations were violated, they even have their own system for how to deal with such violations. Now, you have heard testimony throughout this trial about a duty to report and a duty to intervene. Ladies and gentlemen, again, those are DOCCS directives. They are not the law of the state of New York. And ladies and gentlemen, we sit not in a DOCCS courtroom. We sit in a courtroom of the state of New York, and we are bound here by the laws of the state of New York, as the judge will charge you before you commence your deliberations. Now, the death of Robert Brooks was tragic. It was brutal, it was ugly, it was unnecessary, and it was unforgivable. You know that, I know that, everybody in this courtroom knows that. The city and the county, everybody knows that. We are all deeply troubled by that. But ladies and gentlemen, you are called upon today to determine if Nicholas Kiefer can be held responsible for that tragic death of Robert Brooks. Ladies and gentlemen, the issues here for Mr. Kiefer are threefold. Number one, did Nick Kiefer act with complete depravity for the value of human life? Number two, did Nick Kiefer intend to cause a physical injury, or did he intend to cause a serious physical injury? And number three, did Nick Kiefer intend to file a false instrument? To state it more clearly, more succinctly.
Okay, so this is this third guy. He's the only one on this trial that has the count of falsifying the document, the reporting document. The other two don't have that.
Did the prosecution meet its burden of proof to prove to you, based upon the evidence, that Nick Kiefer had the required state of mind or intent to commit the crimes that he is charged with? I submit to you, and respectfully so, ladies and gentlemen,
Submit to you, counter.
that the prosecution has failed in their burden of proof on all four of the charges filed against Mr. Kiefer. The evidence presented to you by the prosecution is simply not there. It is lacking. Now, the prosecution is asking you to convict Nicholas Kiefer not as a principal actor, but as an accessory to serious and violent crimes, including murder second degree, depraved indifference murder, manslaughter in the first degree, gang assault in the second degree, and filing a false instrument. They're seeking principal liability on the last charge, the filing the false instrument, and accessorial liability on the top three. Ladies and gentlemen, the law requires you in your determination to look beyond emotion, to look beyond the tragedy. Let us be clear. Under New York law, the mere presence at the scene, even with knowledge that a crime is taking place, or mere association with those who commit a crime, does not make somebody criminally liable. To convict as an accessory, the prosecution must prove to you beyond a reasonable doubt that Nicholas Kiefer intentionally aided, solicited, commanded, or encouraged the conduct, and that he did so with the same culpable mental state as the principal actor. Now, let me have a moment to discuss the charges with you. Depraved indifference murder. To prove depraved indifference murder, murder second degree in this case, the prosecution must show you that Nick Kiefer while sharing a depraved, indifferent state of mind of others, recklessly engaged in conduct that created a grave risk of death and thereby caused the death of Robert Brooks. Ladies and gentlemen, depraved indifference is not simply recklessness, it is not negligence. It is a mindset of an utter disregard for the value of human life, a grave moral deficiency, not just a lapse in judgment. The law demands proof beyond a reasonable doubt that Nick Kiefer shared that mindset with the others, that his conduct was so wanton and so egregious that it equates to a conscious disregard for the value of human life. Manslaughter first degree. To prove manslaughter first degree in this case, the prosecution must prove to you, again, beyond a reasonable doubt, that Nick Kiefer, with a shared intent to cause serious physical injury to Mr. Robert Brooks, caused serious physical injury to Mr. Robert Brooks, and that serious injury resulted in the death of Mr. Robert Brooks. They must prove to you that Nick Kiefer participated in the beatings that caused Mr. Brooks' death. Gang assault second degree. This is also a very serious violent crime. The prosecution must again prove to you that Nick Kiefer, while intending to cause physical injury, actively participated with two or more others physically present with the violence inflicted upon Mr. Brooks, which resulted in a serious bodily injury. Ladies and gentlemen, I submit to you that the evidence that you have seen in this trial does not support not one of those crimes. Again, Mr. Kiefer's mere presence in the vicinity or the association with others does not equate to participation in that crime. The prosecution has failed to produce for you credible or convincing proof of such intent on the part of Nicholas Kiefer. Offering a false instrument for filing. Offering a false instrument for filing in the first degree is like most other crimes, ladies and gentlemen. It requires an intent to commit a crime. You've heard testimony right from that witness chair from Mr. Robert Kessler. You've heard testimony from Sergeant Glenn Trombley. And they told you, Nick Kiefer, Mr. Kessler, and Mr. Angelone were told by their supervisor, by their superior officer, to keep their use of force reports confined to the walkway only. You heard the terminology come right out of Mr. Trombley's mouth. To craft a story. Don't mention anything in the treatment room. You heard Mr. Kessler testify that he didn't submit 1, 2, 3, he submitted 4 or 5 reports before he got his final report accepted. He told you that it was Sergeant Trombley who ultimately accepted that final report. On cross-examination, I asked him, Mr. Kessler, what happened to those first 4 or 5 drafts? I believe you heard his answer loud and clearly. He shredded them. They're gone, shredded.
Well, that's familiar.
So, was the final report of Nicholas Kiefer an intent to commit a crime? Or was it an intent to merely get a final report that wouldn't be rejected or shredded, accepted by his supervisor? After all, you heard from Sergeant Trombley, a sergeant must sign off on the final reports. And you heard Sergeant Trombley tell you who that sergeant was that must sign off on the final report. And that sergeant was Sergeant Glenn Trombley. He had to sign off on the reports. He is the one that crafted the story. He, ladies and gentlemen, was the sergeant in charge. Allow me to take a moment and call your attention to the evidence in this case, or more aptly put, the lack of evidence in this case as it relates to Mr. Kiefer. You have all taken an oath to conduct your deliberations and reach your verdict free from bias, sympathy, or prejudice. In a case like this, ladies and gentlemen, we recognize that is a big ask. We understand that. But let's walk through the events before Mr. Brooks was taken into that infirmary treatment room at the Marcy Correction Facility. What do we know from what the special prosecutor has presented to you? The prosecution has taken pains to bring to your attention that Mr. Brooks was not a large gentleman. He was not a large guy. And he only had one infraction in his DOCCS green file, his disciplinary history file while incarcerated. Only one disciplinary record. Ladies and gentlemen, that does not mean that Mr. Brooks was any less dangerous. After all, do not lose sight of the fact that Mr. Brooks was in prison for stabbing his girlfriend repeatedly while in a drug-induced stupor. He's housed at the Mohawk Correctional Facility. While in the Mohawk Correctional Facility, Mr. Brooks was severely beaten by other prisoners with a padlock in somebody's hand. On December 7th, 2024, he got beat. This beating resulted in facial injuries, swelling around his eye, bruising leading down to his jaw on the right side of his face. This beating caused the Mohawk Correctional Facility registered nurse to request he be seen at an outside hospital. You have the photos of his condition that the defense had put in as exhibits E, F, G, H, and I for your review. Recall the process to get a prisoner to an outside facility. Recall that Assistant Chief Marticello, the very first witness that they called to the stand, when questioned at cross-examination, I asked him, Mr. Marticello, if an inmate is injured in the use of force, could he end up in his cell? Does he go to a hospital? He told us the process. If they're injured in the use of force, they go to the facility PCU, primary care unit of the facility. They try to treat him there. If they need a higher level of care, they got a big TV screen called telemed. They'll go to telemed. If after telemed they need a higher level of care, meaning the injury must be worse, they then will make arrangements to have him shipped out to an outside hospital. They go to an outside hospital. That is precisely what happened with Mr. Brooks. His injury was so severe, he went to an outside hospital. He went to the Wynn Hospital here in Utica, New York. He was treated by Dr. Marin. You heard the examinations that Dr. Marin had made of Mr. Brooks, the certain tests that were run on him at the hospital. What you didn't hear Dr. Marin say is that they found any trace or evidence of K2 in Mr. Brooks' system on December 7th, 2024. Mr. Brooks was discharged from the Wynn Hospital that same day. He had specific instructions from his discharge. The specific instructions said, if the symptoms reoccur or if you get any new symptoms, immediately go back to the emergency room. Mr. Brooks did not go to an emergency room. He did not go to the PCU unit of Mohawk. And yes, the symptoms did return. He actually had new symptoms occur. Mr. Brooks was then moved from his dorm on December 7th to a new dorm within the Mohawk Correctional Facility. If I noted it properly, I think it was dorm 4B, Bravo, I believe is what it was. And this was in an effort to remove him from the gang members that violently beat him so severely on his face and head. This is told to you by Sergeant Sayal. He was the sergeant at the Mohawk Correctional Facility. Mr. Brooks moves to his new dorm in the Mohawk Correctional Facility. Mr. Brooks has trouble in his new dorm at the Mohawk Correctional Facility. This is the very next day, ladies and gentlemen, December 8th, 2024. Mr. Brooks became sick. He vomited in his cubicle. He did not clean it up. Let's remember one thing, ladies and gentlemen. We're not talking about college dormitories here. We're talking about state prisons. Nobody cleans up for you in state prison. You're in a large room with 40 or 50 other inmates, prisoners, incarcerated individuals. If vomit stays on the floor for any period of time, it's unpleasant for everybody. Mr. Brooks was directed to clean up his vomit. Mr. Brooks did not clean up his vomit. Some other prisoners / gang members beat him up on December 8th, 2 times. One time with metal locks, plural, locks, in the sock. Mr. Brooks was ultimately able to get away. He got a mop, a bucket, and he cleaned up his vomit. The same thing happened the very next day on December 9th in the early morning hours. He got beat up yet again. Recall the testimony of the incarcerated individual that the DA called, Mr. Michael Peacock. Recall the testimony of Sergeant Sayal. They told you all that information. In fact, incarcerated individual Mr. Peacock told Mr. Brooks, look man, if you're going to throw up, go in the bathroom, throw up in the urinal, flush it down. This way it doesn't bother anybody. Ladies and gentlemen, if Mr. Brooks could get to the bathroom to smoke cigarettes, he wasn't too sick to go there when he felt nauseated. If he was sick, why did he not get a sick pass? Go to the facility's primary care unit. You heard Nurse Jennings tell you what the process was. If an incarcerated individual did not feel well, he could ask to get, I think she used the term sick slip, get a sick slip. Can then walk over to the PCU unit. He will be seen, he will be treated. Maybe they would have even given him something to settle his stomach, to resolve the nausea. How sick was Mr. Brooks and why was he sick? Well, he wasn't too sick to smoke cigarettes in the bathroom with Mr. Peacock. We heard that from Mr. Peacock. He wasn't too sick to be using K2. Maybe he didn't want the nurses in the PCU unit to know he had K2. How much K2 does it take to make a guy indifferent to lying in his own vomit? Recall that Mr. Brooks thought that he was getting on a plane to go to Puerto Rico. Mr. Brooks was found with a lock in one pocket and a sock in another pocket, which, according to Sergeant Sayal, could be turned into a weapon within moments in a prison setting. Officer Sayal then said he had to do the investigation into the assault of Mr. Brooks, and his investigation indicated that Mr. Brooks was in trouble with other inmates or a group of inmates for some drugs that Mr. Brooks was holding for them, or that Mr. Brooks lost, or perhaps that Mr. Brooks had used. Mr. Sayal also requested a mental health examination for Mr. Brooks due to the grandiose ideas he had and the nonsensical statements he was making. So we know that Mr. Brooks was a problem at Mohawk. Ladies and gentlemen, if you're part of a large organization, as large as DOCCS, and you have a person who is a problem, what do? The answer is very easy. You make him somebody else's problem. You pack him up, you ship him down the road, and you send him over to Marcy. And that's what they did with Mr. Brooks. He went to Marcy. He arrives at Marcy about 9 o'clock, 9:07 at night. And you heard from Mr. Kessler. Marcy never does their job. Mr. Kessler was a little more descriptive than I'm being. They're supposed to bring the prisoners coming into the facility all the way down to the infirmary, the draft area. They didn't. Marcy then contacts Mr. Kessler. They call him up, say, Mr. Kessler, come up to the administration building, we got an in-draft, you got to get him. Mr. Kessler is a half an hour away from ending his shift. He's irritated, he's tagging dumpsters, which is part of his responsibilities, but he goes to get the in-draft. Mr. Kessler meets my client, Mr. Kiefer, and Mr. Angelo up at the administration building. They get to the lobby of the administration building, there's no Mr. Brooks. Why not? Don't know. You might think that Mr. Brooks would have been grateful for this transfer. He's going to Marcy. He's going to get away from these inmates, these gang of people that are beating him up while at Mohawk. After all, the prosecution has showed you how he was beaten by his dorm mates at Mohawk for 3 consecutive days. Maybe Marcy could be a fresh start for Mr. Brooks. Well, it wasn't a good start for Mr. Brooks. Mr. Brooks is refusing to get out of the van. He's being non-compliant with a lawful directive to get out of the van. So Kessler goes out with Mr. Kiefer and Mr. Angelo, and Kessler starts to talk to Mr. Brooks. What does Mr. Brooks do? He stares straight ahead, doesn't even acknowledge Mr. Kessler, he ignores him. Mr. Kessler talks to him again, and eventually is able to convince Mr. Brooks to exit the van. Was Mr. Kessler obligated to do that? No. Could Mr. Kessler have just pulled him out of the van? Sure. Trying to get compliance and start out on the proper foot with an in-drafting incarcerated individual. As soon as they get a look at Mr. Brooks outside of the van, they can tell he's coming to Marcy because he's obviously had problems at Mohawk. His eye is discolored and swollen. He's got blood in his nostril of his nose. And you heard Sergeant say, I'll tell you, a dude doesn't hit another dude for no reason. Once out of the van, ladies and gentlemen, Officer Kessler gives Mr. Brooks another lawful directive. He tells him to carry his in-draft bags. Again, Mr. Brooks refuses and is non-compliant. Again, Officer Kessler negotiates with Mr. Brooks. I'll tell you what, I'm going to carry the heavier bag, you carry the lighter bag, let's get into the administration building. Does Mr. Kessler have to do that? Absolutely not. Again, to gain compliance. Good for Marcy. They ultimately get into the administration lobby. Mr. Brooks, again, refuses to carry his own property bag any further. He states, I'm not going to carry the effing bag. He was more descriptive than I.
This is, again, the duality of the argument. If you just argued, and there was testimony about, we had concerns for our safety because you'll have a lock in a sock and you'll use it as a weapon, like a blunt force weapon you can swing or hit somebody with. Now you're showing that, well, the officers, their state of mind was impacted because he didn't want to carry his own bag. Well, if they were so worried about what could have been on his person that he could have used as a weapon, why wouldn't they just want to carry the bag? Why weren't they denying him the opportunity to carry his own belongings if they were scared of what belongings he had and could and apparently was trying to use as a weapon? You can't have both arguments.
For the third time while at Marcy, Mr. Brooks is non-compliant. He is not following a lawful directive. Again, Mr. Kessler, trying to be reasonable with Mr. Brooks, tells him, look, if you don't pick up your property and you don't carry it, you're not going to have your personal property. Mr. Brooks, again, refuses. He says, F it, I don't want it. Did Mr. Kessler have to try to convince Mr. Brooks to carry his property? No. So again, good for Mr. Kessler. Later, on the walkway, you saw the video, you see that neither Mr. Brooks nor Mr. Kessler is carrying a property bag. So apparently that did not work out, and Mr. Brooks remained non-compliant with lawful directives given to him. They go into the Sally Port within the administration building. They ID Mr. Brooks per policy. They exit the Sally Port. They now enter into the area we've been calling the breezeway. Mr. Kessler tells the Mohawk correctional officer, the transport officer, remove the leg restraints, remove the handcuffs, remove the waist belt. The Mohawk corrections officer removes all three. Mr. Brooks is now unrestrained, per Mr. Kessler. Mr. Kessler then gives Mr. Brooks another very simple, safety-based directive. Put your hands deep into your pockets. Very simple. Again, Mr. Brooks does not comply. Mr. Kessler told you at that time, C.O. Walrath runs into this breezeway, puts Mr. Brooks up against the wall, and puts him into what's been described as a UFC headlock, and he starts yanking with great force on his throat. Mr. Kessler told you, I have no idea what the hell just happened. I don't know why the hell Walrath did this. He had no idea. I submit to you, neither did Nicholas Kiefer have any idea why Mr. Walrath had done this. Did Walrath see something that maybe the others didn't see, or did he think he saw something? We don't know. We do know, according to Glenn Trombley, that Mr. Walrath is a very heavy-handed correctional officer. When Mr. Walrath runs into that room and takes hold of Mr. Brooks in that headlock, what do the officers do? They do what they're trained to do. They come to his aid to get Mr. Brooks and Mr. Walrath separated. That's what they're trained to do, and that's what they are required to do. That, ladies and gentlemen, is Employee Rule 8.18. They are to immediately come to the aid of a fellow officer who is struggling with an incarcerated individual. Rule 8.18. That is not the time for second guessing. Recall that even a simple toothbrush in a prison setting can be turned into a deadly weapon, a shank. Somebody yells, "Stop, enough!" We know it wasn't Mr. Kessler, we know it wasn't Mr. Walrath. That leaves the Mohawk transportation officer, that leaves Mr. Anzalone, that leaves Mr. Kiefer. Maybe it was one of them, maybe it was two, maybe it was all three of them. But somebody said stop, and it stops. Kessler said that he and the other officers, including Mr. Kiefer, got Mr. Walrath off of Mr. Brooks. Kessler also told you that he himself had struck Mr. Brooks multiple times, a peroneal strike, but he could not tell you what any other CO had done in that breezeway in that moment. Remember what Glenn Trombley told you. He told you that Mr. Kessler is a hothead. At any rate, Mr. Kessler told you on a question on cross-examination that this entire breezeway event lasted maybe 7 seconds, no more than 7 seconds. Mr. Kessler then testified that Mr. Kiefer told the Mohawk transportation officer he didn't see anything. Do you think that's true? Why was the Mohawk transport officer not called to testify as to what Mr. Kiefer allegedly said to him? The prosecution could have called him, they didn't. Maybe it's not that important to the prosecution. If what Mr. Kiefer actually said or didn't say is not important to the prosecution, I submit to you, ladies and gentlemen, it may not be that important for your deliberations. They then leave the breezeway. Mr. Brooks is not keeping pace. He's being escorted by Mr. Anzalone and Mr. Kessler. Arm in arm, they're walking towards the infirmary. Again, Mr. Brooks becomes non-compliant with a very simple lawful directive. Walk faster. They enter the man-trap area on the outside of the administration building. This is the big double doors, the Sally port outside. They get to the exit, Mr. Brooks sits down. They get Mr. Brooks back up to his feet, and they tell him, keep walking. Again, he does not keep pace. As Mr. Kessler told you, he was lagging behind. Recall Mr. Trombley told you, as he was driving up, he saw the incarcerated individual turning his head back and forth and moving his arms while he's walking. Those were against the directives that Kessler had given Mr. Brooks. According to Mr. Kessler, Mr. Kiefer then says to Mr. Kessler and Mr. Angelone, put Mr. Brooks on the ground, he's going to pepper spray him. Why? To get compliance, to gain compliance with Mr. Brooks. He's been uncooperative since he's arrived at Marcy. Recall the sworn testimony of the Assistant Chief to the Office of Special Investigations, Mr. Christopher Marticello. He told you that when he was a corrections officer at the Green Haven Correctional Facility, at the beginning of his career, he had to use force several times. He told you when he had to use force on those several occasions, on each and every one of those occasions, he did it to gain compliance, not to cause injury. Ladies and gentlemen, that is precisely what Nicholas Kiefer had done, to gain compliance. Did Mr. Kessler tell you, stand this guy, or did Mr. Kessler tell you that Mr. Kiefer said, stand this guy back to the fence, I want to face him so I could pepper spray in his face? He did not say that. Did he tell you that Mr. Kiefer said, put Mr. Brooks on the ground face up so I could spray him in the face? No, he did not say that. They put Mr. Brooks on the ground, he went down to his knees, they laid him down on his chest, face down. Face down. Mr. Kiefer sprays the minimum amount of pepper spray. That apparently hit Mr. Brooks in the back of the head or the neck area. Sometimes, ladies and gentlemen, that's all that it takes for a prisoner is to be reminded that corrections officers carry OC spray, and they will use it if necessary. It certainly was the minimum amount of pepper spray. Most importantly, because the spray hit Mr. Brooks on the back of his head or sweatshirt or the back of his neck, it had no effect on him. Recall what Mr. Kessler said about that on direct examination. He said he really couldn't tell if the pepper spray got into Mr. Brooks's eyes. I think we could all be confident that if the spray got into Mr. Brooks's eyes, everyone would know it. It would be obvious. Kessler was asked on cross-examination, Mr. Kessler, did the minimum amount of OC pepper spray that was dispensed have the desired effect on Mr. Brooks? His answer, no, not really. You heard Glenn Trombley yesterday. He kind of vacillates on the issue. He said on his direct testimony that it was sprayed and they were coughing a little bit. Then on cross-examination, he agreed he did not see any effects of the pepper spray on Mr. Brooks. There was no orange residue, there was no tears, there was no mucus from his nose. He stated that he thought the pepper spray hit Mr. Brooks in the back of his head or the neck. He also told you, ladies and gentlemen, that pepper spray usually does not cause an injury, and that DOCCS prefers pepper spray over physical force. He said it was the first line of defense. Glenn Trombley also told you on cross-examination yesterday that he...
I'm confused. They're trying to say that Brooks didn't have any mucus, so the pepper spray... That's not how, in my experience, I worked at a lot of nightclubs, and so when things would get crazy at the let-out, they'd spray pepper spray. And you didn't need to be the target. You didn't even need to even be that close. And everybody would be coughing. It'd be a whole swath of people coughing. Cheering, snotting, sneezing. Like, if you're not used to it. So, again, it doesn't help. Oh, he sprayed him in the back of the head. There was no mucus, so clearly there was no cause of injury. It was just pepper spray. That, to me, suggests that either something was going on with Brooks that he didn't have the physiology in play to start snotting, sneezing, and coughing, which is concerning for health reasons, or 2, he was used to it, which means that this is a recurring thing that they do frequently.
He has never seen Nick Kiefer get mad. Never seen Nick Kiefer get mad. And he said, and I quote, "For Nick Kiefer to use pepper spray, something must have happened." For Nick Kiefer to use pepper spray, something must have happened. You have all seen the videos. You have all seen Mr. Brooks on the videos. Did you see them have to decontaminate Mr. Brooks? No. No, you did not. You heard the good doctor, Dr. Merkulova, who did the autopsy? She did not even make a note of any pepper spray being on the exterior of Mr. Brooks's body. The pepper spray, ladies and gentlemen, had no effect on Mr. Brooks at all. His eyes were open, you see that on the video. There was no drooling, you see that on the video. No mucus from his nose, no tears from his eyes, no coughing, no orange residue on his face, nothing. Recall that both Mr. Kessler and Mr. Trombley told you that after this pepper spray incident on the walkway, Nicholas Kiefer did not lay one finger on Mr. Brooks. Not one finger on Mr. Brooks. Now, ladies and gentlemen, I'm not commenting about what happened to Mr. Brooks in the treatment room. Nick Kiefer was no part of that. He wasn't there. What I'm asking you to do is to review and evaluate the situation up until Mr. Brooks was carried into that infirmary building. It's unfortunate, but it's true. Mr. Brooks was a problem at the Mohawk Correctional Facility. Mr. Brooks was a problem at the Marcy Correctional Facility from the time he arrived there. Recall the state police investigator Sarah Neerhook, if I'm pronouncing her name properly. She was the one with the walkthrough video that she filmed to show you and give you a perspective right from the parking lot all the way to this incident. She actually went all the way back into the treatment room so you can get a visual of the actual route that Mr. Brooks was taking that evening. To get all that on film so you would have a good view of it, it took 1 minute and 45 seconds. For Mr. Brooks to walk that same route, it took over 14 minutes. Now that we have reviewed the evidence, or more accurately put, the lack of evidence, ask yourselves, ask each other when you're deliberating. Did the prosecution prove to you that Nicholas Kiefer intended to aid or encourage anyone's criminal conduct? Did Nick Kiefer act with the mental state, depraved indifference, or conscious disregard for life? Did he intend to harm or cause serious injury to Robert Brooks? Or was he simply present for brief moments but not acting with any criminal intent? Our law does not punish people for being in the wrong place at the wrong time. It punishes those who act with criminal intent and indifference. For Nick Kiefer, the prosecution has not met its burden of proof on any of the 4 charges. Let's talk about Dr. Merkulova. She did the autopsy. She told you that Mr. Brooks' death was due to compression of the neck and multiple blunt impact injuries. Multiple blunt impact injuries. That's contained right in our autopsy report that was submitted by the special prosecutor. That is Exhibit 36 for your review, if you so desire. There was no evidence presented that Mr. Kiefer inflicted any blunt force injury to Mr. Brooks or caused any injury at all. None. No evidence. Dr. Merkulova closely examined the exterior body of Mr. Brooks and did not note any pepper spray on any portion of the exterior of his body. She told you that she examined his face, his eyes, his mouth, his neck, his nasal passage. No pepper spray in those areas at all, none. She also told you that she did the internal examination of Mr. Brooks's body. She looked in his mouth, she looked down his throat, looked at his tongue, looked at his lungs. No mention of pepper spray in any of those areas, and certainly no injury as a result of the minimum application of pepper spray. Ladies and gentlemen, if you have any doubt, any reasonable doubt, about whether Mr. Kiefer possessed the required mental state or whether he intentionally aided or encouraged the conduct, you must find him not guilty. The burden is on the prosecution, and quite frankly, they did not meet their burden, and I say that with respect. You've been told many times, ladies and gentlemen, and you're going to be told again when the judge gives you the final instructions, the burden of proof on these charges rests entirely, 100% upon the prosecution. The defense is not obligated to prove anything. But did the prosecution take you through the video evidence and say, here's where Nick Kiefer committed murder second, depraved indifference, here's where Nick Kiefer committed manslaughter one, here's where he committed gang assault? No, they did not. There were 4 body-worn cameras in the evidence. You have them all. The A-Long video, the Trombley video, the Gallagher video, and the Fisher video. I was the one who initially took you through those videos, minute by minute, that the prosecution had put into evidence. I did not try to hide anything from you. I wanted you to see it all with your own eyes.
So for clarification here, the reason this attorney is taking this approach is because Kiefer was in the hallway. He was never in the treatment room. He was never in the room where everything actually, it went in those viral videos. So the argument here isn't that they didn't actually pepper spray him. That's not what they're trying to say. The argument is the pepper spraying didn't proximately cause death, and the pepper spraying wasn't done in a means to facilitate knowingly what the other guards were going to do next in that treatment room. So Nicholas Kiefer was never in that treatment room. State's theory, state's charges against Kiefer are that he facilitated the gang assault by pepper spraying him in the hallway after he's transported, but before he's entered into that room. It's not just that he wasn't pepper sprayed. It's the pepper spray wasn't some knowing and intentful action to facilitate a gang assault that ultimately led to the death of Robert Brooks. So I think with that context, because it's interesting, that's why it's interesting to watch 3 people on trial for three lawyers representing 3 different defendants. They've got different facts to work with in different ways. So I see his strategy a little bit more because of that.
I showed you every time Nick Kiefer walked in and out of that treatment room. I showed you how long was he in that treatment room and what was happening in that treatment room when Nick Kiefer walked in and out. Nick Kiefer, ladies and gentlemen, was in there 4 times, and that's assuming you're counting his leaning through the threshold over to the counter to grab his body-worn camera and exit the room as 1. If you don't count that as 1, he's in there 3 times. At no time that he was in that treatment room was he in there longer than 16, 17 seconds. And at no time when he was in that room did he see, or do you see on the video, anybody punching, kicking, striking, assaulting, or other abuse on Mr. Brooks. Ladies and gentlemen, at the start of this case, Mr. Fitzpatrick assured you that he would prove to you that Nicholas Kiefer was a member of a gang of murderers. Did he? I submit to you he did not. Although they promised you they would, the prosecution has not shown you that Nick Kiefer acted with depraved indifference. There is no evidence that Nick Kiefer exhibited a wanton disregard for human life.
I mean, I don't know about
that. The facts
that.
do not show that he...
I would argue that grabbing your body cam and getting your camera out of the room that potentially you guys thought wasn't recording could show something. Were you just grabbing it at that moment in time for the sake of it?
Consciously disregarded a grave risk, nor that he encouraged or aided anyone else in such conduct. Nick Kiefer was only present in that treatment room for mere seconds, very brief moments. But even if he had been in that treatment room for the whole time, his presence alone is not guilt. Unless Mr. Kiefer intentionally aided or encouraged the conduct, he cannot be held criminally liable as an accessory. The prosecution has not shown that Nick Kiefer intended to cause a physical injury to Robert Brooks, let alone prove to you that he caused a serious injury to Robert Brooks. In fact, the prosecution has not shown you that Mr. Kiefer caused any injury to Robert Brooks. Ladies and gentlemen, the prosecution's case relies on speculation and assumptions, not on concrete proof. You cannot convict on speculation. You must base your verdict solely on the evidence and the law as the judge will instruct you. Emotions play no role in this. As I stated, this case is a tragedy, but our justice system demands that we distinguish between those who are truly culpable and those who are not. Nick Kiefer did not act with depraved indifference. He did not intentionally aid or encourage the conduct that led to Mr. Brooks's death. Mr. Kiefer did not intend to cause a serious injury that resulted in Mr. Brooks's death. Mr. Kiefer did not intend to cause a physical injury when he was aided by two or more who were physically present to Mr. Brooks. And he did not intend to file a false statement. Ladies and gentlemen, the evidence does not support the prosecution's theory on all four of these charges. I ask you to return a verdict of not guilty on behalf of Mr. Kiefer. The prosecution's strategy in this case seems to have been charge them all and let the jury figure it out. You, the jury, let you guys figure it out. Well, ladies and gentlemen, on behalf of Nicholas Kiefer, I think you have figured it out. Nick Kiefer is not guilty of the crimes charged against him. Please tell that to this court. Please tell that to this community. Return a verdict of not guilty on behalf of Nicholas Kiefer. We once again thank you for your time and attention in this matter. Thank you very much.
Thank you, Mr. Longo.
Thank you, Your Honor.
Okay, so we're going to get to the state. So we're going to get to the prosecution now to do their closing argument. So the state will tell us, again, we couldn't watch the trial. I've been following through text-based updates. Now we're going to hear the best live stream that we can get of the state's order of events. And I think all three of these defendants are facing murder and manslaughter. The manslaughter is first degree. The first and third are both facing a gang assault charge. And then the third, the attorney that we just saw speaking for, is also facing this, this instrument for possibly altering and destroying the record, the reports, that. So what's interesting to me about that is I think we're looking at a situation based on what I've seen from this trial. I have not seen everything and what the jury has seen. But you could have a jury that might just go across the board and say they're all wrong. Or you could say, hey, if we look at the technicals, let's look at it. Maybe in the situation of someone like Kiefer, I think there's, just from what I've seen, and I've really only seen defense's side for these closings, there's enough here to get him on these counts. Maybe we don't think the state met their burden on these. And if we were going to convict that, it would be out of principle or to make a statement, and maybe we shouldn't do that. But let's agree, these two counts we think the elements were met. I don't think this looks good for any of the defendants. I just don't. So I'm a bit surprised I'm a bit surprised they didn't take pleas. Because you're putting your future in the hands of a jury. I don't think people are sympathetic with a whole group of people versus one person in any circumstance. I don't think anybody's sympathetic to seeing someone get jumped and beat on when they're outnumbered. And then this is supposed to be people in a position to keep things safer. Whereas the other person, Robert Brooks in this case, he couldn't leave and get out of the situation if he wanted to. I don't know. For a million reasons, very risky, more than usual to take it to a jury trial.
After 2.5 hours of listening to how this was a tragedy, let's now get back to reality, if that's okay with all of you.
Oh!
What's the tragedy? I'm missing the point here. We have 3 heroes in the room, ladies and gentlemen. Forgive my impertinence for indicting them for what they did. I'm sorry. I must be waiting for their award ceremony.
Oh.
For the heroic actions of Mr. Kiefer in pepper spraying a helpless 148-pound guy who's lying on the ground and who the testimony says didn't do a thing. Oh, I'm sorry. It took him 10 seconds to get off the van. The death penalty for that? Mr. Gallagher, a babe in the woods, didn't say a thing.
A babe in the woods.
Just doing his job. Shackling the guy who's getting his testicles pushed up to his larynx, right in front of him. And he has the temerity to stand in front of you for 90 minutes and say, he did nothing wrong, just following orders. He's such a good guy. Leg iron award for him, pepper spray award for him, and God only knows what for Mr. Kingsley, who also did nothing wrong, ripping a guy's throat off. Let's get back to reality. And I remind you that they killed him. The whole rotten, stinking, disgusting group of them. They all participated in it, and they all killed that man. You know it, and everybody in this courtroom knows it. Don't fall into the trap of analyzing minutia. Who hit him hardest? Which was the worst blow? Who struck first? Was Anzalone worse than Kingsley? Was Kingsley worse? Was Kiefer worse than Gallagher? Was Gallagher worse than Trombley? They were all in it together. The Marcy Welcoming Committee. Or, as Mr. Lubran said, just an average in-draft at Marcy. The fact is that when you look at these videos, this snuff film of a helpless prisoner,
Ooh, that is what it feels like.
Awestruck by the community.
Yes.
The lack of panic, no sense of urgency by these 3 men or anyone else. The laughter, the almost calm serenity. I'm standing next to a guy dying. I'll check my watch to see if my shift is almost over.
Ooh.
The haste to fill out a form. The guy's body hasn't even been taken out of the infirmary. And Kiefer's sitting there getting ready to doctor his form. And you can listen till the cows come home, and Judge Bauer isn't going to tell you that there's a defense to filing a false report that says I was ordered to do it. That's your name on the form, Mr. Kiefer. not Mr. Trombley's, not Mr. Gallagher's, not Mr. Mayshaw's. It's your name on that report. And you know what the sickening irony of all this is? As I sit here and listen to this 2.5 hours of Fantasy Island, you know, I'm a great believer in providence. I do not think that we have been created by a cosmic accident. I believe in fate. And I believe that fate recorded those videos. Can you imagine what this trial would have been like? I'd still be sitting there. These guys would still be charged. But can you imagine what it would be like without those videos? We already know. Mr. Kiefer told us. All force ceased before entrance into the infirmary. That's his report. He's required to file it. And he sits here and he tells you he's not guilty of that. It would have been a whole trial of, oh yeah, he resisted, he was a maniac, he was high on K2, he was a lunatic, he had a sock and a lock, and oh my God, he slipped outside, and thank God we were able to save ourselves. We know beyond any reasonable doubt that Mr. Kiefer was involved in this up to his neck. And speaking of necks,
Oh, we're gonna
we
get
know
the
that Mr.
motion.
Kingsley was involved. Just look at that photo. And a few moments ago, his lawyer told you he did nothing wrong. Did nothing wrong. Mr. Gallagher, it's 9:30. Robert Brooks is dead. If he was in the Mayo Clinic, he'd still be dead. This guy's laughing. That doesn't show indifference, depravity. These were not corrections officers. They were a gang. They were a gang of murderers. I'm not going to spend a lot of time on what you heard during the summations. But I will ask you to remind yourselves about evidence. Okay? Evidence. I'm not going to tell you what so-and-so was thinking, what my client was thinking, or what he really went to do, or what he wanted to do, because if I stand here till doomsday and ask Tracy to read that back, she ain't going to be able to, because there isn't any evidence of that. I didn't know till today that training was the cause. His lack of training, it was only 43 seconds. How much training do you need to join the human race? If I see a civilian, and I've seen it 1,000 times in my 40-year career as a prosecutor, if I see a civilian run into a burning building and come out and saving somebody, I don't sit down with them and say, where did you get your training for that? Because I know where they got their training for that. They got it by being a human being. Training for 43 seconds, I don't care if it's 4 seconds, I don't care if it's 43 days. The guy's been on the job for 18 years. He doesn't know that he's supposed to intervene. Isn't it funny how all of the rules that help these guys, they're experts on. But the one rule that points out that they're murderers, we barely knew about that. Don't fall for that. Did someone actually stand in front of you a few moments ago and say that Officer Farina was wiping off Robert Brooks's nose? Did I hear that?
That's how it was.
Sitting there. I don't know if you heard that. Common sense, reality. Let's get back there, okay? Wiping his nose, and how many times Did you hear? What was he supposed to do, Mr. Gallagher? There wasn't a thing he could do. There wasn't a thing he could do, good Lord. In a few moments, you're going to hear Judge Bauer discuss and define accomplice liability. The example we've used up to this point is the getaway driver versus the Uber driver. You'll hear words like intentionally aids. You won't hear Judge Bauer say, he's really got to aid him a lot. He's got to substantially aid him. It's got to be like really huge how much he aids him. He's going to tell you that if someone intentionally aids someone in what is obviously happening in front of them, then they too are responsible for that conduct. Based on what we've listened to for 2 hours, I want to play for you 10 minutes of reality.
Oh.
13 men, including these 3 defendants, murdering Robert Brooks. And I remind you that much of what happened to Robert happened before the cameras ever came on. That is obvious to any sentient human being.
What?
When Mr. Gallagher's lawyer tells you that he had no idea what had happened out in the breezeway or the walkway, take a look at Robert when he's brought in.
The sirens in the back.
After he was walked right by Mr. Gallagher. A typical in-draft at Marcy.
That's kind of small.
Mr. Kiefer coming in with his pepper spray can, already having participated in the beating, according to the testimony of Officer Kessler.
That would nudge me to
You see how
all four
concerned
for
everyone
Nick.
is,
Not
how
that
worried
Nick.
they are about Robert. I had no idea there was anything wrong with Mr. Brooks. Just a typical in-draft at Marcy.
There's a screen here, but it looks like he's staring down the table. I think that's his table. Oh. Hey to Judge McBurney's court. All right, let's refresh again. I don't know why they're parsing it this way. I'm guessing they're changing the camera batteries every so often. Let's get to the new feed.
He holds. What could he possibly have done? Maybe rejoined the human race and told these animals to stop? No. No, I'll hold him down and help Farina.
Zoom in because I want to see the name markers because I get confused.
If that doesn't look like aid, I don't know what does.
And again, it's...
Weren't you expecting to see a violent kick from Robert based on what?
Okay, so Farina, Walrath, Kiefer. So there we have Kiefer, who we just heard arguments that he wasn't in the room when the assault was taking place from the defense attorney, and then Kessler.
What you heard during opening statements. His legs are barely moving.
So of that frame, Kiefer is the only one of these three on trial. I think the other three all took pleas that were marked there. Anzalone testified.
Now, let's take away the last possible line of defense that he has, his legs,
He's not
and cuff
kicking.
them together so that Farina can stand on the chain and continue this beating.
There you go, done.
And he stands there, Gala, and doesn't do a damn thing to stop this. I'd show you all of that, ladies and gentlemen, from Mr. Gallagher's body-worn camera, but coincidentally, apparently, as he went out into the cold and came back into the warmth of the infirmary,
He zipped up
he
his
zipped
jacket.
up his jacket.
See, that's, that was my first time thinking about that. When we heard it mentioned earlier, the defense attorney mentioned it, and we paused the stream. I became a pausing McPauserton, and I was like, that doesn't make sense. This was in the cold New York. New York gets really cold in the winters. You could see there was some snow sort of melted on the ground in the footage that we just watched when they were still outside. Why would you be inside and then zip up your jacket? You know how sweaty and gross that'll make you feel? If you guys have never lived in a colder climate where you have like an insulated jacket, you've only lived somewhere where you put on like a light, like one layer. When you're in somewhere that's insulated, it holds heat and moisture in. It is not comfortable to have a zipped up coat inside. I just cannot imagine someone doing that instinctively because they were cold or drafty once they walked inside. So to me, I know it's so stupid, but it's such a damning detail.
So I can't show you the rest of it. Nicholas Kiefer saw no evil, heard no evil, spoke no evil. He was part of the greeting committee. He strikes Robert Brooks in the arsenal for no reason at all. He pepper sprays Robert for no reason at all. He stands by and watches this occur. He follows the gang into the ER while Robert has clearly been beaten senseless. never does a damn thing to intervene, despite multiple opportunities to do so. And he sits here today and says, I didn't do anything wrong. He even tried to go back in till he was finally ordered out.
Hey, cats.
You know what I've often thought? We had 5 senses. I kept listening to this trial about how you didn't see this, you didn't see that. Are these people deaf? Do you think there was noises coming from that room that might have been indicative of the horror that was going on? And then he wrote a use of force report that he tells you isn't a crime. All force ceased. Nicholas Kiefer, guilty of murder. Matthew Gallagher, I was just following orders. I didn't know nothing. I didn't know what I could do. I had been on the job 18 years. It's still new to me. I just don't know. I tried my best. I thought I'd get the leg irons to what? He's part of the greeting committee too. He watched what happened in the ER. How can a human being look at that? And you're charged with responsibility for protecting that guy. It's a tough job, it's a dangerous place. Yeah, that's a tough job, that's a dangerous place. It's a dangerous place for Robert Brooks.
Oh.
He holds Robert down while Anzalone and Farina are punching the guy's penis, fracturing his testicles. He stands there and tells you, I didn't see anything. It's a guy beating him with a shoe. He tried to convince you earlier in this trial that he saw kicking. There's no kicking. He bravely rushes out to his van. Oops. I think I'll zip up my jacket.
That's when he zipped it up, is right then?
You know why he zipped up his jacket. Everybody in this room knows why he zipped up his jacket.
I need an air horn. Ba 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 ba. Oh.
The next 9.5 minutes are blank.
Jesus. There's
He
no
restrains Robert to
explanation.
continue the assault. You've already seen that multiple times.
Hey, the source, flesh of the
He
gods,
yanks Robert's
formerly known
pants
as.
off. His final act of indignity to that dying human being. And then he tries to tell you it's regulations. Yanks
Oh, okay.
them off.
So outside, sorry, I was muted. We're gonna watch this again, so you can see the zip up right there. You see him, it's like he's seconds. Who goes inside a building and zips up their coat? I'm not saying this facility had the thermostat cranked up, because you know how some facilities be, right? And maybe if you have health concerns, you don't want to keep it at a festering hot temperature. But still, to be coming outside from the outside temperature, which is undoubtedly way colder than it is within the facility, even if they keep that thermostat low, why would you within seconds go bloop?
The next 9.5 minutes are blank.
I know, I can feel like I'm sweating imagining having
He
my old
restrains
New York
Robert
winter
to
coat
continue
on.
the assault.
It'd be like me going and getting
You've
a coat
already
right
seen
now.
that multiple
It's
times.
just like, hey guys.
He yanks Robert's pants off, his final act of indignity to that dying human being. And then he tries to tell you it's regulations. Yanks them off like he's treating an animal.
I need one of those, YP. I might get one before the Mook 2 stream. I think we're going to do Mook 2 stream today.
Look at the professionalism, the sensitivity, the care that you just heard about a few moments ago. Never intervenes, never questions, never files a use of force report. Just following orders. Ordinary, good, decent people get a summons in the mail. You wind up on jury duty. Sometimes greatness is accidental. Sometimes we strive for greatness. A generation from now, your kids, your grandkids, they'll look at you and they'll say, "What did you do, Mom, Grandma, Grandpa, Dad? What did you do that was great in your life?" In a few moments, you can answer them and say, "I brought justice to a system that dehumanized a man, a simple man who did a terrible thing, but whose opportunities were only ahead of him. A man who looked around a room as he was choking to death on his own blood and undoubtedly asking himself, who is here to protect me? I was pepper sprayed for no reason. I was beaten for no reason. I was hogtied for no reason. I was choked to death. No reason." The sad, inexcusable, unthinkable answer is that no one, not one member of that gang, did a thing to help. Not Mr. Kiefer, not Mr. Gallagher, not Mr. Casey. And now, we all know what happened to Robert Brooks. When you reach your deliberations, someone look at your watch. And when you get to 31 minutes, you will have given more time to these three men than they gave to Robert Brooks' life at Marcy. Murder in the second degree. Just click it forward, Jim. Depravity, wanton disregard, indifference, manslaughter in the first degree, intent to cause serious physical injury, gang assault in the second degree, intent to cause only physical injury, causing serious physical injury, all acting in concert. The question for you is, was there a commonality of purpose, a design? Not to kill, they're not charged with intending to kill. 5 times on his summation, Mr. Lubrand told you that I was required to prove that his client intended to kill Mr. Brooks. 5 times. He's not charged with intending to kill Mr. Brooks.
That's Gallagher's attorney.
This was a gang with the express intent of dehumanizing Robert. We're not going to stand for such impertinence as failure to put your hands in your pockets. If you find that inhumanity, that depravity, which is obvious, frankly, the next question is, did the defendants aid in this dehumanization and this depravity?
I gotta say, that coat zipping, if there was a chance for any of the defendants, because when this indictment came down, I thought at least several people were just effed. Like, that's it. The facts are going to be bad for several of the officers. I didn't know the names of who was who. It took a little bit of time for them to issue the charges. And a lot of people were disappointed that it was only 10 individuals that were indicted. When only 10 were indicted, I said, okay, that seems like they went through and they're not trying to overcharge. But there are some individuals, this is before anyone took a plea, that maybe, based on the charges, look like they did something after the fact, but maybe they didn't participate in the assault. Maybe that's the case for Nicholas Kiefer, jacket guy. But when you show me that jacket zipping video, whether you meant to do something specific for this instant or you did it because this is what you're always doing, I'm sold on a guilty across the board. And I say that as somebody that I really don't take the prosecutor's burden lightly. And I usually don't like prosecutors making a plea to make a statement for the greater good. But here, since we're dealing with people that were in the position where they're working in the capacity as a corrections officer, the system and their individual actions are inextricably intertwined. So, gotta give some flowers, gotta give some flowers, gotta give some flowers. And he's a special prosecutor. Marcy Prison, where this happened at, is in Oneida County, and he's from Oneonta County. They brought him in as a special prosecutor.
Mr. Kingsley? Of course he did. Mr. Kiefer? Of course he did. Mr. Gallagher? Of course he did. The 3 of these men, Mr. Kiefer, Mr. Kingsley, Mr. Gallagher, they were part of it, they joined it, they did it willingly. I think to one of my favorite movies, which you may or may not have seen, A Few Good Men. It's a great ensemble cast, Tom Cruise, Jack Nicholson. And there's 2 Marines on trial. And they were on trial for killing a fellow Marine by the name of Willie Santiago. It's a great scene, cross-examination in the trial, where the Tom Cruise character gets Colonel Jessup to admit that he ordered a code red. Not the phony red dot that Kiefer ordered, but a code red, which was designed to terrorize a fellow Marine who they thought was slacking off. Turns out Santiago had a medical condition. He wasn't slacking off at all. But it's a form of discipline. So the Marines go to trial, and they're feeling pretty good because they got Jessup to admit. that he ordered the code red. And sure enough, they were acquitted. Private Downey, Lance Corporal Dawson. But then they're found guilty of conduct unbecoming a United States Marine. And Downey, if you remember the movie, Downey's stunned. What do you mean, guilty? We didn't do anything wrong. Downey's the shorter of the two. He's kind of a country bumpkin. We didn't do anything wrong. Colonel Jessup ordered the code red. We did nothing wrong. And then the wiser Lance Corporal Dawson says, yeah, we did. We were supposed to fight for people who couldn't fight for themselves. We were supposed to fight for Willie. These three men, before they divorced themselves from the human race, were supposed to fight for Robert. And justice demands that they be held accountable for the brutality of their actions and their inactions. Nobody's charging them with failure to follow a DOCCS regulation, but that's part of their state of mind. Myself and my colleagues, defense lawyers and prosecutors alike, we fight all over this country for justice in America's courtrooms. If you ask 10 lawyers to define justice, what is it? You probably get 10 different answers. But right now, today, in a Utica courtroom, I'm looking at justice. That is about to pass into your hands. Justice most certainly for these three men, and justice for Robert Brooks. And I know you have the common sense, the wisdom, the courage, the decency to let justice ring from this courtroom, let justice ring in the canyons of Manhattan, let justice ring from the snow-capped peaks of the Adirondacks, and let justice ring in every single town and village and city in the county of Oneida. God bless you, and I thank you very much for your kind attention, and I wish you Godspeed.
Oh. I like his style.
Patrick, ladies and gentlemen, you've been listening attentively for some time now. My instructions will take a bit of time, so I'm going to give you about a 5-minute break. Let you stretch your legs. Continue on with my final charge when you come back. We'll take about 5 minutes.
All right, so we can skip a little ahead. I don't think we've got 5 minutes to time travel. I do want to hear jury charges because, again, we've got the murder charge, the top level count. We've got manslaughter in the first degree for all three. And then for two of the defendants, there's a gang assault charge. And I don't know if that's first or second degree, but the intent difference is intent to cause serious bodily harm for first degree gang assault. For second degree, it's just intent to cause harm. And it's supposed to be with two or more other individuals. So the three number for the rule of gangs. And then for Kiefer, we also have that destruction of instrument. I don't know the exact language of the statute charge. So I do want to hear those, how those are worded. Oh, we got a New York seal. The Excelsior. They don't have the Wisdom banner. The Dom Wiz banner. Alright, maybe they'll do a new feed for this. Let me check. Let me check if they've got a new feed. Yeah, so they ended this one. Or maybe I spoke too soon. Maybe they aren't going to... Maybe there won't be a feed for jury charges, you guys. Yeah, no Dom Wiz banner. Everybody in this chat is trained to look at the seal. To look for that Dom Wiz. We've watched way too much Fulton County stuff, you guys. I think... So, this is a New York trial, you guys. And this is upstate more, but I think New Yorkers... I think a lot of New Yorkers are primed to working long days, like 8 to who knows what. If the jury gets in there and they think they're relatively on the same page and just want to weigh through the things, I think this could be a fast verdict. I honestly think a holdout would be why we don't get a fast verdict. But I think this is just such a compelling case that even if the jury might not agree on the specifics, the burden being met to every element, I think it's compelling to convict anyway. Just saying. Just saying. Oh, we've got a Broken Baker raid. We've got to fight back, you guys. So since we're waiting to see if they come back for jury charges with this feed, or if the cameras just are, because again, they were only allowed to stream opening arguments and closing arguments. I'm not sure if jury charges are included in those permissions. So we might be ending soon and then resparking a stream to do the Antonio Sledge appeal, which is Fulton County YSL trial. YSL case was supposedly over a few months ago. I don't agree with that. I think we still have lingering issues with several of the sentences and this ongoing appeal with Mungtung specifically. We're going to look at Fulton County's counter arguments to Jim Robichaux, Happily Angry Lawyer, and Tiffany Adams, the Fit Lawyer ATL. We're going to look at the Fulton County reply and see if it's any good. But we'll wait this out for we'll give it 5 minutes and see. But we've got to fight back since we have this downtime. Broken Baker has always been raiding us 3 times this last week. And I'm always still on, so we don't have the opportunity to raid them back. So click the link I just put in the chat. Go punch a like button. Hit the subscribe if you're not already subscribed to Broken Baker. You guys, and I love to see you guys would be like, can you stream a trial? Can you cover a trial? I think Baker's been doing Daisy Link and all of these other trials, giving you something to watch daily. He lives overseas in a different time zone from me. I'm self-centered. I think of everyone in my own time zone. But he goes live from what's a regular daily schedule for my time zone. So he cares about my viewership. He cares about making sure he covers trials when most of us can watch at a good time. So show some love over to Broken Baker. We love Broken Baker's coverage and his good commentary, and always appreciate the raids. But we've got to fight back. We've got to fight back. Show some love over there. Yeah, Sweden has arrived at the gates. Are you guys stuck at the gate? And hey, you got your YouTube name. It's weird to see you as the Let's Go Brandon. So there we go. I'm refreshing over here for channel 2. No feed. I don't think they're going to bring up jury charges. And with verdict, we will, since we're going to be doing a motion reading on the stream we start up in, I'm going to take a quick break, get some tea, and we're going to start up another stream that's dedicated to the Mungtung appeal, right? So if you want to hear some Fulton County drama, that's the stream to come watch. We'll be starting that in about 50 minutes, 50. And we'll also keep an eye if there are jury charges and or a verdict or any news on this Marcy Corrections Officer's trial. A lot of people are calling it the Robert Brooks trial. I don't like to refer to a case by the victim's name because it makes it seem like the victim's the one that's on trial. But it's helpful here because I think that's what most people use as their clue. So with that being said, oh, so your birthday's September 11th, not just 911 in your name. Well, good to know. Happy, very belated birthday. We're past a month. I can't even say celebrate all month long because we're in October. Just usurp October and celebrate again. I don't know if we'll get to see a verdict or sentencing, but again, if it pops up, especially if it pops up while we're doing the Mungtung reading, we can jump over live and watch it either way. Yeah, and then Brooklyn with another Fulton County adjacent story. So Woody, Kenneth Copeland, has a new baby, and Miss Weaver, the court reporter that we know for wearing Chuck Taylor's Converse, got the baby size ones. They have the little ones as a gift for the baby. So if you guys remember, Woody had testified that because he wasn't willing to get on the stand and testify, Fulton County had him locked up for a weekend in a cell with feces on the wall. Feces on the wall. He called it feces. And wanted to force him to testify. He told them during the ex parte meeting, why do you want to get me street clothes? Like, just, you don't want them to see me in this, referring to the Fulton County Blues attire, the jumpsuits. And they wanted to get him street clothes so he wouldn't be on the stand in his, looking not credible for the state. Hilariously, if you guys remember, on a future occasion, he showed up in a full suit to testify. Like a full, stocky, full-shouldered suit to testify. He ended up telling us that Miss Weaver, the court reporter, was the only one that after he'd spent all weekend in jail, without his family members knowing where he was, no refreshments, nothing, Miss Weaver, I think, got him a Gatorade or an apple juice and made sure he was good. She was the only person that asked or cared. So, very memorable. Good to see that humanity there. And, yeah, this will redirect you over. Sorry, Bakers, to redirect you back to another cat stream. But we've been waiting on this appeal brief. I think some of you guys have been asking me for a few weeks, what's going on? So we're finally going to take a blind look at it. I'm excited to see. We'll resume that at 4 p.m. Eastern. So thanks for hanging out here for Courtney Clenney and the Department of Corrections thing. See you over for YSL Continued. See you guys.